All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 16th. We have 12 bills on the docket and over 100 witnesses today. I just want to thank our troopers for their help and assistance. I know they're managing the flow of folks, and today's an extremely busy day as we have a lot of controversial issues before us. So we'll start off with Senate Bill 446. We'll go to 396, 517, 456, 457, 429, 533, 484, 441, 509, 504, and we'll end up, it looks like we'll end last with 387. So with that, Vice Chair Wallstreicher, you're up with Senate Bill 446.
Thank you, Mr. Chairman, members of the committee. It's wonderful to be back in person in front of you. We do have some controversial bills today. This will not be among those. In fact, I'm just incredibly honored to present this bill to you. Our firefighters are heroes. Everyone in this room knows that. They run in while everyone else is running out. We saw it on September 11th. We see it here in Maryland each and every day. And it's just incredibly moving to be amongst these public servants who risk their lives on my behalf, on your behalf, and on the behalf of our constituents. Senate Bill 446 establishes a peer support program for firefighters and EMS workers. The peer support has three critical elements. First, it's free. It's at no cost. Second, it's confidential. And third, it's done by peers, people who understand the work that they do. Our own Congressman Trone recently passed and President Biden signed a bill requiring this for police officers. This state-level bill is consistent with that framework and simply expands that to our firefighters and EMS workers. There are routine public safety exceptions in the bill where confidentiality is not required. That's listed on page 2, lines 18 through 28, where there's a threat of suicide, where there's a threat of bodily harm, where there's information related to child abuse, or where there's an admission of criminal conduct. Mr. Chairman, members of the committee, I ask for a favorable report.
Excellent. Thank you very much, Mr. Vice Chair. So we'll now move on to your panel, and first up is Mr. Buttle. Welcome. Good to see you in person.
Mr. Chairman, it's good to see you as well. It's been far too long. On behalf of the Jeff Buttle, on behalf of the professional firefighters of Maryland who are here in support of this testimony, the Professional Firefighters of Maryland serves as a statewide affiliate of the International Association of Firefighters. Our membership includes IFF affiliates at the state and local level, which combined represent over 12,000 active and retired fire, rescue, and emergency services personnel. The need for mental health resources in the fire and rescue service is on the rise. Each and every day, our frontline heroes are exposed to the most unimaginable of circumstances. Over time, this takes a toll on the mental health of our first responders. The International Association of Firefighters, working in conjunction with our local IFF affiliates, successfully and developed and implemented peer support programs around the United States, including here in the state of Maryland. While implementing this critical program, the most common issue we heard from our members was confidentiality of the process. This legislation would ensure that any member reaching out to a peer support counselor for assistance can do so with the assurance of state law that those conversations will be kept confidential. The peace of mind that goes along when reaching out for help without fear of reprisal from an employer or the stigma of seeking mental health services is immeasurable. Thank you for your attention to this critical piece of legislation and the positive impact it will have on mental health services to our firefighters and emergency medical services members across the state of Maryland. We strongly support Senate Bill 446 and encourage a favorable report. Thank you, Mr. Chairman.
Thank you very much. All right, next we'll hear from Mr. Walker.
Good afternoon. My name is Grant Walker. I am the 1st District Representative for the Professional Firefighters of Maryland and a Vice President for the Prince George's County Professional Firefighters and Paramedics Association. I'm a Lieutenant with the Prince George's County Fire and EMS Department. On April 15, 2016, the members of my local experienced one of their darkest days. John Skillet Olmschneider was shot and killed in the line of duty. Our department would see multiple line-of-duty deaths and multiple off-duty deaths in the following years. When Skillet was killed, we saw regional and national peer support resources pour in to help. These resources were the calm in the storm. Unfortunately, those were short-term resources. Long after these teams had gone home, the scars of my members' trauma remained. Our local created our peer support team following the death of Skillet, and we have seen it become a critical component in our daily lives. Our peer support team, on average, has over 400 contacts with our members per year. Some of these contacts can be as simple as needing someone to talk to. Many of these contacts are considerably more serious. What the peer support team actually does is address problems prior to it affecting someone's work product. Too often, sending someone to a counselor in a workplace is looked at as a checkbox in the disciplinary process for workplace behavior. These peer support resources ensure that our behavioral health needs are addressed prior to them manifesting in workplace problems. Unchecked, we've seen these issues lead to reduced productivity, inability to work, and more serious events like DUI and suicides. We're here today because this critical resource is at risk. The peer support model is hinged on the idea of privacy and trust. This confidentiality is essential to overcoming the stigma of asking for help and the fear of a ruined workplace reputation. For most of my career, we didn't talk about behavioral health. Similar to the military, we were always told to deal with it. These days are gone. We've acknowledged that our firefighters experience the worst days of people's lives day in and day out, and we must address the behavioral health impacts of their experiences so they can continue doing the work that they love. I ask the committee for a favorable report on Senate Bill 446. Thank you.
Thank you very much. All right, next we'll hear from Mr. Wells.
Thank you, the members of this committee, for letting me speak on behalf of the Fire Service Peer Support Counselors in the state of Maryland. My name is Mike Wells, and I've served as a career firefighter in Prince George's County for the past 15 years. Additionally, I serve as the peer support coordinator for the Prince George's County Professional Firefighters and Paramedics Association, as well as a master instructor for the IAFF, where I've trained nearly 800 firefighters as peer support counselors across America and Canada. I've also deployed disaster areas and terror attacks on behalf of the IAFF, coordinating and providing behavioral health resources to firefighters. On March 29, 2008, I was a rookie firefighter advancing a hose line to a single-family residence in Bowie. As I got ahead of my crew, I felt a sudden drop and a rapid increase of heat. I'd fallen into a burning basement, isolated, trapped, and under intense heat. I knew I needed to call a mayday. However, I vividly remember trying to convince myself that I could figure this out and I didn't need to call a mayday. I thought if I called a mayday, it's going to be career suicide. People are going to think I made a mistake. Luckily, I came to my senses. I called the mayday, and my brothers and sisters got me out. As a peer support counselor for the past 6 years, hundreds of firefighters have called me during their personal maydays. In peer support, personal maydays look like marital problems, post-traumatic stress symptoms, addiction, suicidal ideation, and even suicide attempts. Often feeling isolated and trapped, it's not easy for a fellow firefighter or paramedic to reach out. Stigma of being the weak link and fear of losing their job is a common hindrance, and it's not until there's a crisis often is our help requested. This legislation would have the opportunity to stomp out stigma and allow our men and women to ask for help before there's a crisis. We'll be able to tell our brothers and sisters that when they reach out for the help, they're protected by law, by this bill. This bill will also help employers have a stronger, healthier workforce through primary and secondary prevention. The group that benefits the most from this legislation is the citizens and visitors of the great state of Maryland. I thank you for your time and your favorable consideration.
Excellent. Right on time. All right, thank you very much. Now we'll hear from, oh, sorry, do we have questions for the panel? Oh, sorry, Senator West, go ahead.
Thank you, Mr. Chair. So this bill, my son is a volunteer firefighter, so I've got personal interest in this. But this bill seems to assume that there are peer counseling programs available for all the firefighters in Maryland, because it doesn't establish any peer counseling. What this bill does is say that establish confidentiality standards and then requires a report. Can someone, one of you or maybe the sponsor of the bill, confirm that there are in existence peer counseling services for each of the firefighters, wherever they might be in the state of Maryland?
Sure. Senator Jeff Buttle with Professional Firefighters of Maryland. There are many peer support programs that are established around the state of Maryland. There may be some places in the state, in the smaller jurisdictions, that don't have as advanced of a peer support, but everybody has some variation of the peer support. And one of the things that that we wanted to do with the second piece of the bill which was establishing the best practices, is to be able to assist some of those smaller jurisdictions with standing up a program. Maybe they have something on the informal level, maybe they're trying to figure out a better way to do it, which is why the back half of the bill is in there. And that was something that was similar to what was in the federal legislation as well. But let me be clear, as a fire service in Maryland, we are one big family. And whether, you know, the station that your son may be a volunteer at or wherever, if there are peer support resources that are needed, everybody in the whole state of Maryland is available to come to wherever, whatever station, whatever department. Even if you have a jurisdiction that doesn't have as formal as a program as some of the bigger ones, we're available to go to anywhere and talk to any firefighter anytime they need it.
Okay, in the report, would you be unhappy if we added a provision that would require the report to include a survey of each of the fire departments and the volunteer fire departments around the state to ascertain in each case that there are peer support services that are not only available, but that the firefighters have been informed how they should get in touch with the peer support services?
I think that would be fine.
Okay, great, thank you.
Yep.
All right, Senator Heddleman.
Mr. Buttle, if you wouldn't mind going back
Sure.
up there,
Yep.
thank you. I'm looking through the written testimony, and it looks like the Behavioral Health Administration of the Department of Health thinks that they shouldn't be the ones, but the Maryland Institute for Emergency Medical Systems does, and I just wanted to give you an opportunity to comment whether you agree.
Yeah, so I think the reason the Behavioral Health Administration was put in there is they would contract with a specialist to look into peer support. We don't distinguish really the difference between MIMS or the BHA. MIMS does critical incident stress management, but that is very different from peer support, and it's very different. They're just two completely different things from each other. So we felt as though, and the reason the bill was drafted the way it was, is that we felt the BHA would be the better entity to be able to focus in on the peer support. MIMS is Emergency Medical Services and Emergency Response, and they do critical incident stress management, which is like the initial response to critical incidents, whereas peer support is more long-term over the long run. So you have the critical incident that happens, the initial counseling and response is there, but then on the, a lot of times in response to a critical incident, it's, you get the immediate response through the critical incident stress management, but then, our members of the Fire and Rescue Service are left with long-term and long-lasting scars from these events, and that's where really peer support picks up and takes it over and makes sure that they have the health and resources necessary over the long run.
That's really helpful, thank you. And I just want to say thank you for everything you all do every day.
Thank you.
Thank you, Mr. Chairman. Just following up on what Senator Heddleman just brought to you, I want to thank you all for your service and your sacrifice to our community. But I do want to know, with this confidentiality law, how does this benefit being a police officer? I was on the street for 30 years. I want to know how it benefits the people that you're here representing on the street. How does this work for them?
Yeah, so this would give, in the fire service, there's a lot of our members need help. And we came up with a program a couple years ago, and we termed it Coming Out of the Shadows. And coming out of the shadows, what we meant by that was there's a lot of firefighters and emergency medical responders that need the help, but they're afraid to come forward, or they're afraid to have this stigma of seeking help from a professional mental health provider, like a psychiatrist or a psychologist. They don't want to be labeled as the person who's going to seek professional mental health services, which is why we created the peer support program twofold. One, it's a lot easier for our members to talk with a peer versus having to seek that professional help. And number two, it's really hard, unless you've ever been a firefighter, to understand what it's like to do our job, what it's like to respond to the calls, how you feel, which is why we created the peer support program. What the peer support program doesn't have is the equivalent of what you would have if you went to a mental health provider. So what this will provide all the firefighters and rescue and EMS personnel around the state is the assurance that if I come forward and I talk to my peer, about things that are bothering me that have happened on the job, whether it's a one incident or whether it's an accumulation of incidents over the course of a very long career, this would give them the protection that I don't have to worry about, except in the limited exceptions that the bill provides. I can go to my peer support counselor or peer support coworker, talk to them about everything, and I don't have to worry about my information being shared.
Thank you, gentlemen.
Excellent. See any further questions from the committee? I will echo the sentiments of Senator Bailey and Hedelman. Just thank you all for everything you do, and thank you for your service and your valor. So,
Well, and
thanks.
thank you, Mr. Chairman. You've always been a big supporter yourself, and we appreciate that.
Appreciate it. Thanks. Excellent. All right, we'll now go on to Mr. Phillips and Mr. Delbridge.
Good afternoon, Mr. Chairman, committee. My name is Robert Phillips. I am the chairman of the Legislative Committee for the Maryland State Firefighters Association. We are the statewide association that represents the volunteer side of the firefighters, EMS, and rescue personnel. We are in support of this bill. I have filed my testimony. But what I'd like to say is that the rise in incidences of first responders having issues due to the stresses of their jobs, it's increasing every day. Part of the interventions now being offered and used is peer support from other first responders who have relevant training. That's an important part of it, relevant training. It's been found that people will be more open to speaking to someone else that they identify with. It's a good beginning for all involved, but conversations now are not a protected conversation. A person can have a conversation with someone, talking to them. This is how I feel. I'm having some issues. That conversation is not protected. It can be questioned. And this bill protects that conversation. We have enough issues, and just like you've just been told, and we've been told for years, suck it up, take care of it. And that's not the way to do it. We have found we're losing good personnel. We're losing them from the fire service, from the EMS service, and we're losing them from life. And we need to have a mechanism here that they have, and they can go somewhere and talk to somebody. If I were a person having an issue, in career or volunteer, the volunteer goes home, the career goes back to his station, but we all go back to our public, to our neighbors. And we don't want that perception out there that we can't do our job, we're not good enough. This bill goes a long ways to take care of that by making those conversations confidential, and they stay where they're supposed to. The MSFA does ask that you favorably support this bill. Thank you.
Good afternoon. Thank you, Mr. Chair and committee members. I'm Dr. Ted Delbridge, Executive Director of MEMS, the Maryland Institute for Emergency Medical Services Systems, and we offer support for Senate Bill 446 with a suggested amendment, as was mentioned. MEMS' job is to coordinate the statewide EMS system, and we do that through clinical protocols and medical direction, by licensing and certifying EMS clinicians, by supporting EMS educational programs, and often by facilitating access to support and counseling following particularly traumatic or stressful events among EMS personnel. For emergency responders, the window to the world can be incredibly stress-inducing and psychologically challenging. The emotional well-being and mental health of our EMS, fire, and rescue personnel is important to all of us who, without notice, might need to call on them and depend on them. Peer support groups, in an organized way, represent one phase on a spectrum to help maintain mental and emotional fitness among those we call on in a crisis. A tenet is the promise that shared personal feelings and other sensitive information is held in confidence. I don't think that needs any elaboration. We have all at some point felt the need to hold something back about ourselves because we couldn't predict the result of sharing. And participation in peer support, if it is to be effective, shouldn't be one of those times. After consultation with our colleagues at the Behavioral Health Administration, we offer an amendment, which is in our testimony, to strike the BHA and substitute in its place MEMS. In 2019, MEMS convened an Emergency Services Personnel Health and Wellness Work Group. It's comprised of EMS, fire, law enforcement, and 911 center personnel. And the focus has been to identify best practices and effective strategies to improve health, wellness, and resiliency. MEMS could, in part, capitalize on this work group to help produce the required report in the time specified. I would respectfully submit that MEMS is a better fit for this particular assignment than is the BHA. In summary, it is an important issue that affects us all, and MEMS supports Senate Bill 446 with amendment and urges a favorable report. Thanks.
Excellent, thank you very much. Right on time. All right, Senator Bailey has a question.
Thank you. As having been a police officer and dealt with MIMS quite a bit, I'm curious about a couple things about your amendment. Number one, I mean, this has been an issue for a couple years. And I was just wondering what you currently do to teach about peer support with MIMS right now. What is the requirement and what do you do?
So we're not involved in the teaching of the peer support so much, except in the sense of offering continuing education programs for EMS and fire personnel. We rely on folks like the IAFF and other community-based groups that do that work. Our job often is to connect people with the need to the service that's available. As a matter of fact, every EMT and paramedic card issued in Maryland has a phone number to call in case you need help. And I do recognize, as was mentioned, there is a spectrum of care that begins with talking to your buddy, an organized peer support deal, all the way to seeking a licensed professional, right? None of those are mutually exclusive. They're all in a spectrum of going from one to the next.
So I don't want to discredit that at all because it might have worked for some people having that peer support, that number on a card, right? But I worked with 3 people that committed suicide, right? Having that on a card didn't help, right? Peer support definitely is a big issue.
Sure.
Right, and it is a big deal, and I just have my reservations about you guys managing it that way with that amendment, but we'll discuss it in committee.
Well, may
Thank
I
you.
respond to that?
Yes.
In our conversations with the Behavioral Health Administration, the concern was that they are not intuitively connected to the emergency responder community. And this work group that we've been working with for the past couple of years has been a little sidelined because of COVID. It isn't MEMS. It is a group of people who are in the field who are doing the job. And it is our intention to call on their expertise and their perspectives in order to manage a report. We're not managing a system of peer support. The system of peer support exists with the peers. Our perspective was that in order to determine a best route to get forward and what the qualifications ought to be and how you not codify, but how you organize a system, that we had access to the people with better perspective than the BHA did, and so did the BHA. As a matter of fact, right now, the peer support that exists for hospital and nursing home personnel, the crisis management activities are being managed by MEMS with a grant from the BHA. The Behavioral Health Administration just doesn't have connectivity in that world, which is why we thought we could be helpful in that regard.
I appreciate your response. I'm going to say that we're going to have to discuss this because it seems like you're trying to hijack this, something these people have done themselves for 2 years, and I think they should be recognized for doing that.
No, well, again, I'm not in favor of not recognizing them or hijacking anything. I'm saying we feel compelled to offer our expertise and our ability to reach those people who are doing the work in a way that the Behavioral Health Administration would have an immediate challenge to do. And other than that, it makes no difference to me.
Excellent, thank you very much. Further questions from the committee? All right, thank you both very much. And with that, that will conclude the hearing for Senate Bill 446. We'll now move on to Senate Bill 396, and we'll start off with Mr. What is it? Is it 396? Yeah, Mr. Mitchell and Ms. Chase.
Good afternoon, Mr. Chairman and members of the committee. It's good to finally be back in person. It's been a while, and it's great to be here. And I'm here on behalf of Senate Bill 396, Violent Firearms Offenders Act of 2022. Senate Bill 396 is the administration's emergency legislation to increase penalties for criminals who use and repeatedly possess illegal firearms, as well as those who supply these guns to criminals. Public safety in Baltimore has been in crisis. Last year, we lost 336 people in Baltimore City to violent crime, 88% of them killed with a gun. So far in 2022, 40 people have been killed in Baltimore City. Just last month, Baltimore recorded 36 homicides, the most in January in nearly 50 years. Tackling devastating violent crime has been and will continue to be the priority for Governor Hogan until he leaves office. Since taking office, Governor Hogan has dedicated resources to fighting violent crime in Baltimore City. The governor has provided more than $1 billion for public safety and crime control efforts. That's just not law enforcement. That includes programs like Boys and Girls Clubs, police athletic leagues, and also victim services and crime prevention programs like Safe Streets. In partnership with Baltimore City, state law enforcement agencies has provided the Enhanced Visibility Patrol Initiative, through which state law enforcement officers patrol high crime areas to detect and deter criminal activity within partnership with Baltimore City Police. The governor has expanded Project Exile to provide state funding for additional federal prosecutors dedicated to charging repeat violent offenders with federal crimes. The governor has pushed for a joint strike force comprised of more than 200 law enforcement officials from 18 allied law enforcement agencies focused on disrupting and dismantling violent crime organizations. And that the governor and his team has also created the Maryland Criminal Intelligence Network to allow for better data sharing among local, state, federal law enforcement to better target criminal enterprises. But we continue to see violence rise, and it's not just in Baltimore City. Jurisdictions across our state and across our nation are struggling with increased homicide rates. Prince George's County had its highest increase of murders since 2007, and Montgomery County saw its highest number of murders in over 20 years. We have reached a crisis point, not just in the city, but nationally, not just in the city and state, but nationally as well. If we're going to get a handle on the rampant violence, we must work together and get repeat violent offenders off our streets. We have one more opportunity to help combat the surge in violence. Let's take advantage of this opportunity we have left to pass this emergency legislation. Mr. Chairman and members of the committee, I would respectfully request a favorable report on Senate Bill 396, and I'll now turn it over to my colleague, Aaron Chase, who will walk with you through the bill.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. My name is Aaron Chase, Deputy Legislative Officer with the Governor's Office, here to ask for your favorable report on Senate Bill 396, which contains numerous provisions aimed at those who use and repeatedly illegally possess firearms, as well as those people who supply guns to criminals. Criminals are using and repeatedly carrying firearms to commit violent crimes. Of the homicide suspects in Baltimore City, 84% had a prior record. 43% of homicide suspects had a previous arrest for gun crimes. As you know, the costs of crime, particularly gun crimes, are too significant to avoid considering every possible measure for reducing the toll. To that end, Senate Bill 396 proposes to increase penalties for criminals who not only use firearms to commit crimes, but also those who repeatedly illegally possess firearms. This legislation will help us address the violent crime crisis that is terrorizing our communities by ensuring that these violent criminals are off of our streets. Specifically, on the sentencing side, the bill provides for enhanced penalties for second and subsequent offenders by doubling the minimum penalty for these offenders who use firearms to commit crimes. The minimum penalty for the first-time offenders remains the same. It also requires that those who use a gun to commit a violent crime serve their sentences consecutively rather than concurrently, and the legislation makes conforming changes to ensure that these penalties are the same for machine guns and assault weapons. The legislation also increases the maximum penalty for repeat illegal gun possession by persons prohibited from possessing a gun due to some factor in their background, which serves as a disqualifying crime, mental health issue, or a history or violent behavior towards others. The bill also adds gang convictions to the list of disqualifiers for the current felon in possession of a firearm penalty, which carries a 5-year sentence. Senate Bill 396 also proposes important procedural changes aimed at tackling the use of illegal guns. The legislation provides the state with the right to appeal a decision for the trial court to exclude evidence during a trial for a number of firearm offenses, including illegal possession. This interlocutory appeal provision simply allows the state to appeal an evidentiary decision by the court during trial. This right currently exists for crimes of violence and drug felonies, and this bill just adds gun offenses to the existing provisions. Senate Bill 396 also increases penalties for those who illegally supply guns to criminals. The bill increases the maximum penalty for those who knowingly transfer a firearm to someone who has a previous violent crime conviction or plans to use the gun to commit a crime, classifies the theft of a gun as a felony and establishes minimum penalties for stealing a gun or possessing a stolen gun, and increases penalties for straw purchases to minors or prohibited persons. Through all of these provisions, Senate Bill 396 increases accountability for those who pose a danger to our communities by using and illegally possessing firearms. The legislation also increases penalties for those who facilitate guns getting into the hands of criminals who should not have them. A number of these provisions are standalone bills that you and your colleagues have introduced this session or in sessions past, and we look forward to working with the committee to pass meaningful legislation to reduce the violent crime crisis and hold criminals who use guns to commit these crimes accountable. And for these reasons, Mr. Chair, the administration respectfully requests a favorable report on Senate Bill 396.
Excellent. Thank you both very much. We'll switch over to the committee for questions. I'll just kick us off then. I know there are questions out there, but people the testimony was so riveting, they're just ruminating over it.
Well, with that, Mr. Chairman, I'll move for favorable.
There you go. There's no second on that. Yeah, there we go. All right. So I guess there are several mandatory, I'm going to get specific and not philosophical, and this is not a soapbox speech, just wondering, there are several mandatory minimums in this iteration of the bill, and we are also considering legislation to deal with judicial transparency and prosecutorial transparency so that we have better information of how things are flowing through our criminal justice system. And so I wonder about the wisdom of mandatory minimums and where we're going to have a check, which constrains the discretion when we're going to put in place mechanisms for more transparency and understanding where there is that discretion, how it's playing out, and better be able to respond to that in the future. I just wonder of the wisdom of the imposition of so many new mandatory minimums.
Go ahead.
Thank you, Mr. Chair, for that question. I would propose that I think it's kind of a holistic approach. I think that, we've said multiple times that not every mandatory minimum is created equal, and I think that this is to address the violent crime crisis we're seeing today. And I think that, that requires ensuring that our violent offenders are off of the streets while also having that judicial and prosecutorial transparency. I think it's a balance of all three.
No, I appreciate that. And I mean, look, we'll have to continue to work, as I've been on record about the mandatory minimums piece. Just being inflexible about that, yeah.
And Mr. Chairman, I just want to, on
Yeah.
behalf of the administration, I just want to thank you for working with you as chair over the years, not just on this legislation, but the other legislation, and continuing to have an open dialogue with our team to get legislation through. And, I want to give credit to the Senate for getting the legislation through to get, for the past couple of years, to move over to the other side of the street. And we'll be working just as hard to get that passed also.
Understood. And appreciate a two-way street is what that, I mean, honestly, look, I know there are, a lot of people talk about long-term, root causes, and then there are kind of short-term operational things, and I know there's, issues that we have to deal with immediately as well, so I get it. I think Senator Sidnor had a question, but he's gone now. Want to jump in? Anyone else want to jump in? Senator Carter.
I was not going to ask any questions. We've had this bill a number of years, and we've discussed it and debated it ad nauseum. But, Mr. Mitchell, I just couldn't resist the temptation to ask you a question.
I'm sure you couldn't. I look forward to it.
So, first, this bill comes accompanied by a lot of public statements about the outrageous amount of crime as well as what was in your testimony. And I think we all agree that crime is horrible and we hate it. We don't want people killed. We just have some difference of opinion about the solutions to get to solving the problems. So the first thing I observe is that with all of the people in Maryland that are so outraged about crime, I just would note that there aren't any of those people really here testifying in support of this bill as a solution. But in addition to that, my question is, there have been studies, and I even had a bill a couple of years ago that did a study about crime guns and the sources of those crime guns and how they were getting into the streets of Baltimore. And in addition to that, like the legislature passed like another bill that did the same, like a similar gun study. I think Senator Bidle passed that bill. One bill had the Governor's Office of Crime Control and Prevention looking at doing the study. The other had the Attorney General's office doing the study. I'm only kind of laughing, not that it's funny, it's just that, you know, some of the efforts might have been duplicative and still we haven't solved the problem. But the results of everything that I've seen from the study that was done through GOCAP indicate that more than half of all guns that are found to be involved in crime are their initial their origin is outside of Maryland. And it also indicated that there were a number of, it indicated that a great source of the problem of like the illegal guns that are on the street that are causing all the problem, which we agree about that, is not necessarily like this one individual, like picking off one individual person that's in illegal possession or using it in a crime of violence, but it's these mass traffickers and wholesalers that are doing this. And so I was concerned always that when you continue, it's kind of like the failed war on drugs. When you continue to go and pick off the person on the corner that's like making a hand-to-hand transaction as a dealer and, you know, maximize the penalties for that person, but ignore those people that are like responsible for bringing all of the mass amounts of drugs into the place, you're not really addressing the problem. And so that's kind of like the concern I've had about that bill. And so I'm wondering, either is there a part of that bill that really focuses on those mass volume gun dealers, those gun wholesale dealers that may even have a license to do it, but are responsible for a lot of the large volume of illegal guns that wind up in crimes on our streets?
Thank you, Senator. First, let me address the part dealing with why there's a perception that no one is here to support this bill other than the administration. That's false, respectfully. I know that legislators this year and last year received phone calls and letters and emails from their constituents regarding this bill and other bills that the administration has put forth. I've also will cite a polling that was done by the Washington Post that talked about increased penalties regarding firearms nationally, that there was overwhelming support for that. So you may not see them here in the committee room testifying, but the support is out there. As relates to the increased in terms of going after the dealers,
Large volume.
the large volume dealers, I think this bill would help go after that. I know that the state police and along Baltimore City Police have been working closely along with the mayor's office to look at to go after the flow of guns, illegal guns coming through and being used in Baltimore City. But in terms of specific data, I don't have that yet. I can get that to you on that. So I don't know if Aaron had any other.
Senator Carter, I would just add that there are provisions in the bill that do address the restrictions on the sale, rental, and transfer of regulated or stolen firearms. So we are trying to address that. But if you have ideas on how to, better get at these volume dealers, happy to have those conversations.
Thank you so much. I do, and I'd probably propose it. I'm happy to talk about it. I'd probably propose it in the form of an amendment. I think it's important because the reason that we do these studies to get at the roots of where these guns are coming from and how they're getting involved in crime is so that we can come up with solutions. And I do think there's some additional things that should be added that would help attack it at that higher level.
Right. Thank you, Senator.
Senator Carter, just as a parenthetical, we've been talking to Senator Sidnor a lot about folks getting some more information on trafficking. You know, I mean, it's a big deal, so to your point, we're definitely going to take a deep dive into that. Senator Huff.
Yeah, thank you. It's interesting to bring up polling, because I remember a couple of years ago, you know, quite frankly, when we did the criminal justice reform and they were doing it across the country, crime was at such a low level that Gallup was like taking it off their polling because people weren't concerned. And I was just looking up here. Yeah, as crime continues to soar across the country, here's a poll right here. 8 in 10 registered voters, 77% are extremely or very concerned about it. So, you know, it just seems like we go through these waves in this country where when crime goes up and then crime goes down. And unfortunately, we are back in sort of a crime wave where we've been for a couple of years. But to Senator Carter's point, there is, correct me if I'm wrong, there is portions of that legislation that says if you knowingly sell or transfer a firearm, so if that doesn't matter if you drive into Baltimore City with a truckload of guns or you're just on the corner knowingly selling or transfer, you're going to face a stiffer penalty, correct?
Yes, that's correct, Senator Huff. I think we provide a penalty for a maximum of 15 years on that.
Yeah, and so it always struck me because when we did the long gun bill here, which you don't have in your statistics here, but I'm assuming high percentages are handguns that we're talking about, the murders. But when they did the long gun bill, which long guns are used, you know, in an insignificant, or a smaller amount, I should say, of crimes. But they did that. They added a provision to that saying tougher provisions on illegal transfer, and yet we left handguns. It seems like this gaping hole, which this bill addresses. The only question I have is, do you still have the provision on here on the bailable offenses too in firearms?
We do. We have provisions that deal with restrictions on pretrial release. So basically, we would limit the district court commissioner's ability to authorize pretrial release if the defendant has previous crime of violence conviction or is charged with certain firearm offenses. The judge still could release under their rules, but we do limit the district court commissioner in this bill.
I think that's very important that we address the bail portion of it too, because, you know, all these changes that the General Assembly pushes, the courts push, don't happen in a vacuum. And when they change the bail laws, you've seen this across the country with the bail laws, where people are basically returning right back out in the streets. And so I think that's important that this legislation would keep folks who just went in on a firearm offense from walking right back out. So thank you.
All right, additional questions from the committee? All right, with that, that'll conclude the testimony. Thank you all very much.
Thank you, Mr. Chairman.
Thank you.
All right, so we'll go to the next panelist, Ms. McDonald.
No questions? All right. Thought you were going to start here.
Mr. Chair, Vice Chair, members of the committee, Stacy McDonald. I live right here in the heart of Annapolis, and my neighbors and I are becoming more and more fearful every day of being victims of violent crime. Right near the Senate building, an innocent woman was shot to death last June at the Graduate Hotel, where many of you I know stay during session. She was sitting at the patio outside while visiting her son, who went to the Naval Academy. She was murdered by a drive-by shooter. She was the unintended victim of this drive-by shooting. We've been dealing with this unacceptable and rising level of violent crime for a while in this state, in Annapolis, in Baltimore City. Baltimore City has been particularly hit hard by this, with over 35 murders in January alone. I support looking for long-term solutions. Nonetheless, any solution, including getting violent criminals off the streets and into prison where they cannot murder more innocent people, would be okay for now. What plagues our cities and counties is recidivism. These career criminals need to be locked up. While I do believe in second chances and rehabilitation, these options should be offered to those that are not repeat offenders. It is in the best public interest that repeat offenders be taken off the streets and be sentenced to minimum times in prison. This bill not only strengthens law enforcement, it forces those who are in charge to rid our society of the small criminal class who has wreaked havoc and spread violence for years. Career criminals belong in one place, prison. I urge your support for this bill. While it's not only the answer, it is much needed start. We must take back our streets from criminals and begin to restore our communities. Thank you.
Excellent. Thank you very much.
Thanks.
All right, with that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel and Ms. Hanson-Mundell. Okay. All right. Just call her name one more time, Ms. Hanson-Mundell. Nothing seen, nothing heard. All right, with that, that'll conclude the bill hearing for Senate Bill 396. Thank you both very much. All right, we'll go now to Senator Bailey with Senate Bill 517.
Thank you, Mr. Chairman, members of the committee. Senator Jack Bailey, District 29, representing St. Mary's and Calvert County for the record. Today, I'm going to introduce you to Criminal Procedure, Location of Information, Exigent Circumstances, the Kelsey Smith Act for Maryland. This bill would require that service providers of electronic devices cooperate with law enforcement and public safety agencies by providing the location information of an electronic device if requested when exigent circumstances apply. The purpose of this bill is to save the lives of missing persons. When first responders are looking for a missing person, minutes and seconds matter to find that person when they are still alive. Senate Bill 517 is based on legislation that is passed in 30 other states. This legislation is necessary because, since this exception does not currently exist in Maryland, service providers can take hours and sometimes days to respond to requests from law enforcement. The Kelsey Smith Act is named for a young woman who was abducted in broad daylight from a Target store in Overland, Kansas. About 3 hours after she was abducted, her car was found in a Target parking lot, and her family and friends, as well as the police, began to search for her. An hour after Kelsey was kidnapped, a signal from her cell phone was picked up. When law enforcement officials asked her cell phone carrier to ping the records, which would have pinpointed her location, the carrier did not provide those records for over 3 days. When the carrier did turn the records over, it took authorities less than 45 minutes to locate her body. She'd been raped and murdered and left for dead. Law enforcement officers are currently able to obtain this information in exigent circumstances, but it can take hours to days as the law does not require service providers to comply. I talked with search and rescue people just this week. They can ping the phone, but they don't report it, sometimes days. So they're sitting here searching for these people, and they don't get the results back for days. This bill limits the agency's request location information to a maximum of 48 hours and provides that a person who complies with this law cannot be held civilly liable. What it does require is it requires that they comply with the order in a timely fashion. So when they get it, they ping the phone and they turn the information over. In addition, following discussions with those who have expressed concerns about this bill, I'm working on an amendment that would clarify that the carriers are also not liable if they comply with this law, as well as to provide for notification for the person whose location information was obtained and ensure that these individuals can request judicial review of the decision to obtain their location information after the fact. I respectfully request a favorable report on Senate Bill 517.
Thank you, Senator Bailey. Mr. Morris?
Good afternoon, Dave Marsh, Chief of Staff for the Anne Arundel County Police Department, here speaking on behalf of the Maryland Chiefs of Police Association and Maryland Sheriff's Association. It is good to see everyone in person, finally. We support Senate Bill 517 for all the reasons that the Senator has laid out. When time is of the essence and critical, when we're dealing with these critical situations, we need to be able to access information. We need the cooperation. Historically, we have that cooperation with the carriers. This just codifies it in a way that ensures protections for both the community that's in need of the services of law enforcement and search and rescue, and equally provides the protections for the carriers for civil liability. For those reasons, we would support this and ask for a favorable report.
Questions from the committee? Senator West.
Thank you, Mr. Chair. The question for the sponsor, the term exigent circumstances is not defined, is it? Oh, it is. Okay. I'll have to go take a look at section 1-2 of 3.1, but if that's an adequate definition, my question is answered. Thank you.
All right, thank you. Any other further questions? All right, seeing no questions, that concludes the hearing on Senate Bill 517. Thank you, Senator Bailey. You are back again, Senator Bailey, with Senate Bill 456. And if you'd like to bring Mr. Pennock up with you, you are welcome to do so.
Thank you, Mr. Chairman, members of the committee. Senator Bailey, District 29, St. Mary's and Calvert. For the record, today I'm introducing you Senate Bill 456, Firearms Handgun Qualification Licenses. And this deals with the firearms orientation component. This bill allows an applicant for a handgun qualification license, HQL, to use either live or inert ammunition to demonstrate the person's safe operation and handling of a firearm as part of the safety training course required to obtain an HQL. The state police has interpreted the provision of law that this bill modifies to require an applicant to fire a single live round with a handgun before the HQL can be issued. This live round requirement does not demonstrate proficiency, does not demonstrate accuracy, and it also requires an individual to travel to a gun range to discharge the handgun. This same demonstration can be performed with dummy ammunition. The person would show safe carry. They would show that they understood how to load the gun safely, and they could demonstrate that they could fire the gun safely without having to travel to a firing range. The most significant barrier posed by current requirements is the difficulty it causes prospective HQL holders living in areas that have either few or no gun ranges for the prospective holder to carry out this live fire requirement. In these jurisdictions, it's harder, particularly for residents who have lower incomes and those who rely on mass transit to fulfill this requirement and obtain their HQL. By permitting the use of inert ammunition to satisfy the requirement of the HQL training, Senate Bill 456 would give these individuals and all Marylanders more options to receive this license. We heard this bill last year. We had discussions on it, and we changed some of the wording. I respectfully request a favorable report on Senate Bill 456.
All right, thank you very much, Senator. Mr. Pennock, you're up. Welcome.
Thank you, Mr. Chairman. It's a pleasure to be here. Mark Pennock, President of Maryland Show Issue. We support this bill greatly. It is this very requirement imposed by the state police is not only contrary to the legislation this body passed in 2013, it basically usurps the legislative function by putting on a discriminatory requirement that effectively discourages the very training that the HQL statute was enacted to encourage. The reality is that firing one live round does not demonstrate a thing. I'm a trainer. I instruct on this course. But in order to actually accomplish what the state police demand, I have to take my students to a range. Because in all of Montgomery County and all of Baltimore City and most of the other urban parts of Maryland, including all of PG County and most of Howard County, you may not legally fire a live round of ammunition in any of those areas except on a range. Except. And that imposes higher costs, greater delay, and discourages the very training that the statute was enacted to encourage. It is a huge barrier to the very training that the statute was enacted. We urge that the committee realize that, eliminate this discriminatory aspect of the Maryland State Police regulations, and issue a favorable report. I'm happy to take any questions.
Senator Watson.
Thank you for your testimony. Define for me inert ammunition, please.
It's a dummy round. Typically, it is a round that looks like a regular round of ammunition. It has a spot where the primer is, except it has a spring there, and it has the same size of a regular cartridge. But it doesn't have any powder, it doesn't have a real primer, it doesn't have a real bullet. It's just the same size and roughly the same weight as a round. So you can use it as a loaded magazine, you can use it to chamber a round, and you can use it to safely drop the hammer on a piece of dummy round without causing mechanical difficulties for the system.
So it doesn't have a bang, it doesn't have a kickback like a real round?
That's the only thing it doesn't have, that's correct.
Well, but that's important. Me being a military guy, I'm taught to train like I fight. And so if you're going to give somebody the ability to go through firearms training and not have them fire around like it would be done in the field, why would you even be comfortable with that, knowing the ramifications?
With respect, Senator, the military training that you're speaking of doesn't fire one live round. You fire thousands of rounds. My son's a captain in the Marine Corps. He tells me of the tens of thousands of rounds he fires. The reality is firing one live round doesn't teach you anything except that it goes bang. And like going bang, you can vocalize that. You can teach this course to the state police satisfaction by using a .22 short, which has a little bang and no recoil. So it doesn't accomplish any sort of training objective. It simply makes a bang, but you have to go to the range for it.
It seems like it's no difference than having someone play a video game and then coming out saying they know how to shoot a weapon. Now, I just really recently received my handgun qual, and I had to shoot a shot group that was scored to tell me that I passed before I could, get my weapon.
And that sort of qualification is required for a carrying permit in this state, because you actually have to shoot a course. But it's not in the legislation established for a handgun qualification license, which allows you to actually acquire a handgun that you can then use to achieve proficiency. So this is the very first step to the acquisition of that proficiency, is to be able to acquire the handgun, and you have to have an HQL for that. And this acts as a barrier to the acquisition of the right to purchase, which is a constitutional right.
Thank you for the clarification.
Thank you. I was trying to figure this out, and maybe you know the data off your head. And I was going back when this HQL was done. I don't know how many people were here or not. I think we probably had more people come down. At the time, Senator Stone, who'd been here since, I don't know, 1950s or 60s, he'd been here a long time. He said it was the most people he'd ever seen come down to Annapolis. And when the HQL was done and this huge amount of restrictions on, I would argue, law-abiding citizens, it was argued we were going to do this because it was going to decrease gun violence in Maryland. Yeah. And I was trying to remember, 2013 is when, so the law went into effect in what, 2014?
October 1, 2013.
Okay, went into effect 2013. And I just believe at the end of the day, we should use data a little bit more to make decisions on some of this stuff. And what was in 2013, do you have or what was gun violence in 2013? Do we have numbers what it was then compared to what it is now?
Oh, we do, and you'll see that in the FBI reports, and we furnished that in other contexts to the committee and to the legislature. But it was much lower in 2013 than it is now. I think in 2011, if memory serves, there were 211 murders in Baltimore that year. and a few more than that in 2013. There's now over 337 murders in Baltimore alone. It's higher throughout the state. So has this training requirement actually resulted in safer Maryland? I would argue not. Certainly not if you look at the crime statistics.
I'm just even curious, do we have any statistics on how many of these people that are being apprehended? We just had the governor's crime bill. I don't know how much you heard of that. How many of these people that are being arrested or apprehended have HQLs? I'm guessing the number is very low.
I'm guessing the number is extremely low because in order to get an HQL, you have to submit to a background check. And people who are willing to do that are usually not your common criminals.
I just think what would be if you or any group out there could find for me the data to show, I think that the numbers tell us that crime has gone up since that bill went into effect. I used to have a chart in my office where I would bring in here and I would show that, but I think it's probably even worse now because it's gone up. But I would be very curious to know how many people on firearm offenses, particularly murder and these other things, have a HQL, because the point being, what many of us argued in the beginning against this law, that criminals were just going to ignore it and not do it anyways. And so, but that would be very helpful data if we could look at that.
Senator, that information as to who actually holds an HQL is protected by state law.
Interesting.
We cannot ask the state police to give it to us. They won't. So there's really no, they're the ones that would be in a position to have that data. You could ask.
I can ask, okay.
For this, and I would encourage you to do so. But I would expect, again, that the number to be extremely low. Now, the training requirement we're talking about here really doesn't have anything to do with crime. It has to do with creating a barrier to the acquisition of a handgun. Now, the idea was, well, you need training to handle it safely. And in the abstract, as a trainer, I would agree. But you don't need to fire one live round, which has no training value whatsoever.
Yeah. Well, I remember the problem was, because you said you were on a range, there was talk at the time that the gun stores were going to set up a barrel, and you went outside and you shot into a barrel or something, because isn't it in Baltimore City, isn't there a real lack of ranges? Is there a range in Baltimore City?
There is not, and a discharge of a firearm, any firearm, anywhere in Baltimore City is quite illegal. It's a crime. There's a discharge of a firearm in most of Montgomery County is a crime. Discharge almost all of PG County is a crime. Discharge in all the metropolitan areas of Howard County and in Baltimore County is a crime. And the only way you can fire that round is to go to a range, in which there are none in Baltimore City and none in Howard County, and I think only 2 in PG County.
All right, so if you live in Baltimore City or Howard County, and you don't have let's say a vehicle, say you live in Baltimore City, a lot of people that live in the city might not have a car, they might just Uber around or something. That's a real barrier to be able to legally attain a firearm. All right, thank you.
Mr. Bank, just because there was a little confusion on this, I wanted to just clarify a couple points. If you could walk us through the steps. When you walk into a gun store and a person wants to buy a firearm, right, and they eventually want to have a carry permit, what do they have to go through?
It differs according to whether the firearm is a handgun or a rifle or a shotgun.
Handgun.
For a handgun, by law, the HQL statute bars a dealer from selling and you from receiving any handgun if you do not possess a handgun qualification license. For a rifle, that's simply a matter of filling out the Form 4473 by the ATF. For a handgun, you have to fill out an additional form called the 77R that the dealer will give you that goes to the state police, and they do a background investigation, and you have a 3-day waiting period, a 7-day waiting period in order to receive the handgun. But you can't even get to that stage to fill out the form unless you demonstrate by showing the dealer an actual physical copy of the handgun qualification license.
So when you are doing this and you're going to actually attempt to get your HQL to fire this one round, the whole thing that this legislation has talked about, is that in the law generated by the General Assembly, or is that an interpretation by the state police?
It is not in the statute. In fact, the very requirement to fire live ammunition was removed by the statute on a floor amendment by then Senator Delegate McDermott, which then passed this body. So it was actually changed, the original bill promoted by the Governor O'Malley, was that requirement was deleted. And it was then reinserted to 1 round by the state police by regulation.
Thank you.
So the regs say you have to do live rounds for the squad. So are semunitions are actually, yeah, considered live rounds, or are they inert?
I'm sorry, Senator, I could not understand.
So the regs say that you have to do this with a live round.
Yes, expressly.
So the question is, semunitions, are they live or inert? Can you, because we've done some training with those, and you wouldn't be precluded from using a semunition in like a garage or something like that, or some other facility apart from just a firing range.
The state police have issued an advisory that says you can use ammunition, but ammunition is permissible under the regulations because it is a live round.
So it's live rounds.
It is a live round
Yeah.
already because it isn't explosive. It's actually meets the definition of a live round in state law.
So why couldn't you use? Okay, why couldn't you
Because
just
state law, local law, bars the discharge of a live round.
Understood. So it's okay. Got it.
Including SIMs.
Understood. Senator West.
Thank you, Mr. Chair. So I keep hearing about this one round, and I'm having trouble. What possibly can be accomplished by requiring a person to fire 1 round in order to get a license?
For the training experience, nothing is accomplished because you can teach all that, how to chamber a round using dummy ammunition just fine. All you get from a live round is a bag, and that's it. But it is a very effective barrier, and this is what we think in the litigation that MSI is a party to, was I think it was intended by this, and that is to create a barrier for the acquisition of a handgun by making it much more difficult for people to satisfy the statutory requirements set out in Section 117.1.
If legislation were to be introduced next year to overturn the regulation the state police have provided to require 1 round to be fired, what would be the argument against that legislation?
I don't know of an argument that they could mount that 1 live round amounts to anything. In the litigation that MSI is a party to, the state police expert testimony admits that 1 live round is insufficient training to accomplish anything. So not even the state police suggests that 1 live round is actually accomplishing anything of the statutory aims, which is to train people.
I see. Okay. Thank you very much.
All right, Mr. Pennick, thank you very much.
Thank you, Your Honor.
All right. Next, we'll hear from, we have Ms. Mooney, Mr. Hodge, and Ms. Novotny. If you want to come on up.
Good morning. My name's Carla Mooney. I am from District 29C, Mr. Braley's district. I am a professional firearms instructor. I'm also the Maryland Qualified Handgun Instructor Certificate. I teach these classes probably 3 a month. I've been doing this probably since 2015 or 16. The single shot really is not necessary to teach firearm safety. I am a huge advocate for firearm safety. I'm a Second Amendment advocate with the DC Project. We teach, and we expect to teach education over legislation when it comes to gun safety. Our safety is our first paramount, and the requirement to train is important, but that single shot is a limitation. Just like they said, in locations where a live round being fired is against the law, that means going someplace, that means traveling, that means extra costs. It is not necessary, and it does not assist in the firearm safety portion. So I would like to hear a favorable report on this bill. Thank you.
Katie, you got it.
Good afternoon, members of the committee. Thank you for having us here today. My name is Katie Novotny. I'm coming to you from District 35B, and I support this bill. Thank you, Senator Bailey, for again bringing this common sense legislation. It's already been covered extensively that there's a lot of areas that you just cannot, meet this training requirement. People have to travel extensive distances. But to me, the big problem with this bill is that the state police have added in a requirement that this very body purposefully rejected. This was not an oversight. This was not an omission. This body purposely rejected it. And the fact that the Maryland State Police has decided they can just arbitrarily add things to statutes and to law, make requirements for people should be shocking to everybody. I know there's a lot of people in this committee that don't support gun ownership and gun rights, and that's fine. But there may be a bill that you care about, that's been thoughtfully crafted, extensive discussion and debate, come to an agreement, it's passed, it's signed, and then the Maryland State Police goes, we don't like that. We want to add this. And that should be disturbing to everybody. So because of that, I request a favorable report. Thank you.
Mr. Chairman, Senators, my name is Darrell Hodge. I'm a resident of Arnold in District 33. I have heard of a rumor that there was legislation like this, but I have rarely seen it. This is common sense gun legislation. As you've heard, the requirement for one live round is not in the enacting legislation. It was added in COMAR. This bill simply takes advantage of existing technology to make it a little bit easier for someone who wants to acquire a handgun to show proficiency, to show safe handling of their handgun. The one round really does nothing in terms of training, but it can show proficiency in handling. Let's take advantage of the technology. Let's enact this legislation. Thank you.
All right, thank you very much. Questions from the committee for the panelists? All right, we'll move on. Thank you very much. Thank you. All right, move on to the next panel. Mr. Hodge, Ms. Novotny, Mr. Weber, and Mr. Burke, and Mr. Tutela.
Thank you, members of the committee. Thank you, Chair, for having us here today. It is a bit of a strange feeling to be standing before you in person and not behind a Zoom screen. I'll be quite honest. So I welcome it in some ways. So it's a pleasure to be before you once again. My name is Daniel Carlin Weber. I'm a Baltimore City resident in District 46. I am a handgun qualification licensed instructor. I can also offer the Maryland wear and carry permit training, but I'm also licensed by the state of Utah to offer their concealed carry permit course. And the reason that that's important is, I'll get to in a moment. I say ditto to a lot of the things that you've heard prior in regards to the limiting of access to training that the current requirement has in it. I've had to shuttle students to the range at times, which can become quite difficult. But that's how difficult it is with this current barrier as it is. I teach a lot of people in Baltimore City. We have to go to Elk Neck or Gumtree or somewhere else far off to be able to successfully complete the requirements as they're codified right now. But one thing I would like to, if you refer to my written testimony, I show you what it's like, how to get a similar permit in DC. DC requires that you have to register a handgun with them, and you have to go through a similar process in order to be able to legally purchase a handgun. There, you sit through, you can take an online course. You take an online course that the Metropolitan Police Department has designed, and ironically enough, it's very similar to what existed in Maryland prior to the Firearm Safety Act of 2013. Once you've shown that you've satisfied that, you go and you are able to register, do a background check, and purchase a firearm. But so if you look at DC, Maryland's is far more extreme compared to our nation's capital. Furthermore, the Utah Concealed Carry Permit course that I teach is virtually indistinguishable from the Handgun Qualification License course, except that's more on carry. But there is no live fire requirement in that course, and that permit is recognized by 33 states. So it is time for this body to change its language. This is far too extreme, and it is limiting people's access to their constitutional rights. So for that, I ask a favorable report. Thank you very much.
Michael Burke, also out of District 46. I've been a firearms instructor and a law enforcement officer since 1976. The current requirement for a police officer in Maryland from the Maryland Police and Training Commission requires 35 hours of classroom training and at no less than 200 rounds of ammunition for a police officer to become proficient in handling and carrying a firearm. To the contrary, the HQL requirement, which is merely required to purchase a firearm, is now allowed to be taught in a 4-hour class online, according to Maryland State Police guidelines, because of the last 2 years of the pandemic, except for the requirement to travel 5 to 50 miles for a city resident to a range to fire a single shot. And that is somehow determined to be proficient in the eyes of the state police. This statute would eliminate that requirement. That would open up the right to purchase a regulated firearm for city residents to get past this onerous obstacle, which is designed apparently to prevent the population of Baltimore City from obtaining HQLs. It's not possible to buy a handgun in Baltimore City because there are no licensed dealers in Baltimore City. It's not possible to train in Baltimore City because there are no ranges in Baltimore City. Even firing, as the chair mentioned, a simunition round is a crime anywhere in Baltimore City limits. So I urge this committee to issue a favorable report and see our written testimony detailing why this is an excellent addition to the state legislature and remove this requirement from the citizens. Any questions, I'll be happy to entertain.
Are there any questions? Senator Huff?
An excellent point you make there at the end about, because we just had a hearing, I don't know if any of you heard the hearing before this, where we talked about enhancing penalties for people who illegally buy and sell guns. And what you're saying and what you all have testified to is about the problems in Baltimore City. So this would tell you somebody who is law-abiding, wants to do everything right. For those concerned about over-criminalization and over-penalizing folks, and specifically, you were talking about how many people are you regularly taking out of the city to help them purchase guns legally? But I mean, a lot of people, I have this correct? Sounds like they're being trapped up, and if they illegally buy the gun, laws that I support to punish those folks, we're going to get some good people trapped up in that, are we not?
I recently spoke with a public defender that I run with about all this, and when I described the handgun qualification license process and what's required, she says, well, no wonder so many people are not following that, because it is much easier to get a gun illegally than to follow the requirements that people want, that the state wants people to do. And if you do purchase a firearm illegally, that's a severe crime. You're looking at life-changing criminalization there. So the incentives to legal gun ownership should be much lower or much higher than the burdens and barriers that the state has created to a legal pathway to gun ownership.
Thanks.
Senator Huff, to answer part of your previous question, to my knowledge, in 9 years since the HQL requirement went into effect, absolutely no one has been prosecuted in Maryland for possessing a handgun without an HQL. Nobody has been arrested for obtaining a handgun without an HQL.
I get that. I got to reach out to state police after this, try to get that data, because to me, that's just not somewhat surprising there's not one, but thank you. That's speaks to the efficiency of the law.
It would be equivalent to having a driver's test require a student to drive 1 foot and then obtain a driver's license.
Yeah, or the bigger one, it's like requiring a license, and then it's, there's never been anyone arrested for not driving without a license. So.
Exactly, sir. Thank you, sir.
All right, further questions from the committee? Excellent. How many, I'm sorry, Mr. Detelli, you said this. How many states do not require this one live?
As far as I know, Maryland is the only state that has a live fire requirement and a permit to purchase requirement. So in Maryland, you need a permit to be able to purchase the firearm. As far as I know, Maryland is the only one that has a live fire requirement. Other states sometimes have small training courses akin to what DC has, and et cetera, but none have a live fire requirement as far as I'm aware.
And these are regs that are promulgated by MSP, right? These are
Yeah,
regs.
they were introduced at the AELR hearing in September of 2013.
Got it.
Mr. President, Illinois requires a firearms owner identification card to purchase and possess a firearm. There is no live fire requirement. Massachusetts requires a permit to possess a firearm. There is no live fire requirement. Maryland is the only state which has this requirement, and it's not by law. It's merely by an unelected official decision by someone who is no longer in service in the state of Maryland.
All right. Senator Bailey, has MSP weighed in on this, or did they just submit information?
I don't think they've weighed in on this year.
All right, excellent. Further questions from committee? With that, thank you very much. Thank you all.
Thank you.
Thank you, Mr. President.
And with that, don't tell Senator Ferguson he's called me Mr. President. He'd get me in trouble. All right. All right. We'll now go on. That concludes the hearing for Senate Bill 456. We'll now move on to Senator Lee with Senate Bill. Oh, sorry, Senator Bailey, 457. My apologies. You're up.
I was feeling sort of bad about
Oh, I'm sorry.
reducing you.
Sorry, Senator Bailey. Did I miss someone?
Yeah. I'm Nick Catello. Am I on the list?
Oh, yes, you are on the list. Yes, please come up. My apologies.
Hello.
The saved round for the testimony. All right, that was a bad joke. All right, go ahead.
Well, thank you for including me. I just wanted to add on to this. I've lived in Maryland my entire life. I've floated between Baltimore and Carroll County, and I think, in my opinion, rights shouldn't be limited based on where you live. At any point between all these moves, the proximity between me and the nearest firing range could have changed by orders of magnitude. Like, firing ranges are not exactly evenly distributed throughout the state. And we already have all these other requirements that none of the other even neighboring states have just to be able to buy the handgun. So I urge you to vote favorably on this bill because it'll make it to where we have more equal access, similar to voting at a voting booth. And I think this is just an unnecessary requirement. Thank you.
Thank you, Mr. Tello, and my apologies for the oversight. All right. And with that, that'll conclude the hearing for Senate Bill 456. We'll now hear from Senator Bailey with Senate Bill 457.
Thank you all. Thank you, Mr. Chairman. Members of the committee, Senator Bailey, District 29, St. Mary's, Calvert County, for the record. This bill is Senate Bill 457. This is a work group to study trial in absence. This bill would create a work group to study the possibility of allowing individuals who fail to appear in court for minor offenses to be tried in their absence. This work group would consist of two members of the Senate, 2 members of the House, public defender or their designee, president of the Maryland State's Attorneys Association or their designee. In addition, I'm submitting an amendment to this bill so that 1 member would be appointed by the Chief Judge of the Court of Appeals. The work group would be tasked with studying other jurisdictions where this practice is used and the feasibility of implementing trial in absence in Maryland. It would also determine which minor offenses would be eligible for trial in absence, the condition under which a trial in absence would be authorized, and determine how any penalties incurred through a trial in absence would be collected. So how did we get to this point when we're talking about trial and absence? And I know the attorneys in here probably haven't seen this unless you practice in different jurisdictions. But in my 30 years as a police officer, I attended court in multiple jurisdictions, both in this state and in other states, including the state of Virginia. In Virginia, I saw many times when a defendant accused of a nonviolent criminal misdemeanor was tried in their absence. In the same scenario in Maryland, it would have been a failure to appear, resulted in a warrant being issued for the defendant's arrest. From discussions with members of the judiciary, a large part of the administrative work in the courts is the result of processing failure to appear warrants. If implemented, this may give our state one option to limit interactions between law enforcement and individuals charged with very minor crimes who fail to appear for their court dates, which would also allow our police officers to focus on more serious offenses. The work group's report would be due on December 1st, and the bill sunsets on June 30th, 2023. I respect the favorable report, but I'm here to answer any questions.
All right. Senator West.
I'm a little confused about this. Maybe we could have a conversation offline, but under U.S. constitutional law and Maryland law, a person has a right to be present at his trial or her trial and confront witnesses and cross-examine witnesses. Would this conceivably try to deprive someone of that right?
So what it would do is if, you know how it works right now when you fail to appear. If you fail to appear, you are then granted another court date, right? Even though a warrant is issued for your arrest. When you go to court in, let's say, Virginia or Pennsylvania, you are tried in your absence, right? As long as you
voluntarily failed to appear.
As long as you fail to appear,
right?
Right, you're not there. You're tried in your absence. But at the trial, right, is clear and apparent that if you, the person that didn't come there, if there was some reason or you didn't make it, you can request a trial, right? And you can then get a trial. But just like you can when you have a warrant issued for your arrest, once the warrant is served, you can then get a new trial date, and you go back to court for the reason that you failed to appear. Okay. But what this does, you can still do that in these states. You still get your day in court if you want your day in court. But the situation is, and when I saw this and saw the number of arrest warrants that we have in Maryland and compared that to Virginia and what I had seen, and when you're going and dealing with people that are, you always hear somebody say, "You're arresting me for this," right? What are you guys doing? Aren't you, why don't you go get some real criminals or some serious issues, right? You hear that all the time. And the issue is that police interaction for that minor incident, right, that quite frankly, when a lot of minor incidents, right, life happens in this world and people have a lot of things going on. And what I'm saying is, if there is a way that we can alleviate some of that police interaction where they have to arrest that individual for a minor offense and it then becomes a civil infraction, we can do that, and we don't have to move forward with an arrest and having the police put their hands on every person that fails to appear in Maryland. Okay. That's my intent. That's what I've seen in other states. I'm a little bit, getting over my skis here as a police officer, but I've seen it. And after sitting in this room and debating the police bills last year, thought this was a good way that we could potentially look at limiting police arrests for minor infractions.
Okay, so I think I understand it now. So someone has full notice of the trial, it doesn't show up.
Right.
And then what you're suggesting here is a trial could be conducted in that person's absence because that person failed to show up when notified to show up for the trial.
Yes.
Gotcha. Thank you.
Further questions from the committee? All right, seeing none, thank you very much, Senator Bailey. And with that, that'll conclude the hearing for Senate Bill 457. We'll now move to Senator Lee with Senate Bill 429. It feels weird to say, but you're got to bring up the panel.
Come on,
There
panel,
you go.
come on up. Thank you, Mr. Chairman. I'm here to present to you, for the record, Senator Susan Lee, District 16. I'm here to present SB 429. It targets repeat and unrelenting stalkers with enhanced penalties. Usually, increasing penalty doesn't dissuade a crime, and a crime of stalking doesn't have as many convictions as we may have wanted or warranted. But with the combination of tools from legislation before this committee, this session, I think we can change the dynamics and fight the growing threat of stalking with a combination of tactics. And this is, of course, is like a blunt force object. Stalkers may need to know that the penalties are severe if you ignore our laws. Presently, conviction for stalking is just a misdemeanor. There's no enhanced penalty for repeated convictions of stalking, yet there is frequently a crime of repetition. Most states have some form of enhanced penalty for this type of behavior, but our state does not. According to the CDC, stalking affects 1 in 6 women and 1 in 17 men. And approximately 74% of the victims receive threats of physical harm, and the victims are often the youngest adults, college age. An unbelievable 11% of the stalking victims have been stalked over 5 years. 2/3 of the stalkers pursue their victims at least once a week, and 1/3 have stalked before. Stalkers who have been intimately involved with their victim are most likely to approach, threaten, or harm their victims. And as you know, these numbers are pretty scary, but stalking is much more frightening than it may sound. Imagine being a victim and knowing that your stalker could, at most, receive a misdemeanor charge. Picture the stalker relentlessly terrorizing you physically, emotionally, and digitally. Similar to strangulation, stalking's been a very high correlation with homicide. Victims of domestic violence are especially likely to have been victims of stalking before an eventual homicide, and the correlation and causation are clear. There is failure to protect victims of stalking across the country and globally. The change was triggered with new technologies and failure to train police on that type of abuse, combined with an abject failure to adequately punish offenders and empower the victims. Over 3/4 of female homicide victims were stalked by a person who killed them. These are murders we can prevent if we protect the stalking victims and lock up the stalkers, especially those who ignore our criminal justice system. The bill serves as an intervention in the delay between the stalker and the victim, and potentially a deadly outcome. We have increased the sentence for repeated conviction of stalking and stalking while under a protective order to a felony, with a maximum up to 10 years and up to a $10,000 fine or both. This bill works in conjunction with my two-party consent bill because convictions for stalking are far too infrequent, relevant to the frequency of the offense, and we must not bind the victim's hand by not being able to record their stalkers. We do incurrently because equally important to the enhanced penalties is the fear of being caught. This session, we will have the ability to deter crime, have trained police training, and update our laws based on technology as well as common criminal practices. All combined, we can further recognize, document, and intervene in stalking, therefore preventing those homicides and serious injuries as well as serious emotional stress caused by stalking. And as for those reasons, the advocates here and I request a favorable vote on 429. I'll turn it over to my panel of experts. Mr. Chairman, do you have a list of who goes first?
Yes, but whomever on the list if you announce your name when you come to the podium, I'll be able to check you off.
Thank you.
Thank you, Senator Lee. If we could come to the podium,
Sorry.
we're all a little bit rusty.
Yep, absolutely.
Good afternoon, Chairman Smith, members of the Judicial Proceedings Committee. My name is Debbie Feinstein, and I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I also chair the Montgomery County Domestic Violence Coordinating Council and the Montgomery County Domestic Violence Fatality Review Team. I'm a member of the Governor's Family Violence Council, and I'm chair of the Maryland States Attorneys Association's Domestic Violence Subcommittee. I tell you all of that because I have the opportunity in the course of all of these various committee councils and my day job as a prosecutor to see the impact of stalking on members of our community. Stalking is insidious, and stalking results in great fear from its victims and, unfortunately, as Senator Lee mentioned, a high correlation with homicide. 76% of female homicide victims have been stalked by the person who killed them. 67% of female homicide victims have been physically abused by their intimate partner. 89% of female victims who were physically assaulted were also stalked in the 12 months before their murder. And 79% of abused female homicide victims reported being stalked in the same period that they were abused. The reason for the bill that we have before you all today is because the penalty and the level that this crime is affiliated with is not enough. It's not enough because when you have a 5-year misdemeanor that is not a crime of violence, an offender, even if they were given the maximum sentence, would do barely over a year. And with someone that is stalked, you want them to be on probation. So you don't even want to give them the maximum sentence because you want to make sure that there's a period of probation, that they have to do conditions, that they have to get treatment, that they have to stay away from the victim. And so it really is a very minimal penalty for a very, very serious crime. Moreover, intimate partner stalkers are more likely to reoffend as compared to other types of stalkers. 92% of intimate partner stalkers are likely to reoffend. These are exactly the type of people that we must deter and we must protect our community. I urge a favorable report of Senate Bill 429. Thank you for your time.
Good afternoon, Mr. Chair, members of the committee. My name is Catherine Marsh. I'm the Special Victims Liaison for the Charles County State's Attorney's Office, and I'm here on behalf of the Maryland State's Attorneys Association, urging a favorable report of this bill. On April 28th of 2017, 8-year-old Jay was located by a neighbor outside of his home, appearing shocked and confused. Police responded and located his mother, Tanya, who was shot and killed. The investigation revealed that Tanya had separated from her husband. When she left the marital home, he began stalking her. She changed her phone number 3 times and continued to stay with one family member after another. She worked for the Maryland Department of Corrections. Her employer had observed the stalking behaviors and made a report and helped Tanya obtain state services. She applied for 3 protective orders within a 1-year time period, and the last one was just 4 months before her death. In that hearing, she testified about the defendant's stalking and the threats that he'd made, specifically that he would see her in a coffin and that the only way she'd be leaving the marriage was if she was dead. I played her testimony at his sentencing. It was a stark reminder that she had asked for help and predicted her death. The victim had sought help from the courts, her employers, and 8 days before her death from her primary care physician when she reported the stalking. After the murder, the thorough investigation was done. Search warrants, interviews with friends, cell phone mapping, all of which revealed the defendant would show up where the victim was. Police recovered many threats from cell phone analysis. This kind of tools and times just aren't available for a simple misdemeanor charge. This murder witnessed by her 8-year-old son was preventable. We failed her. We failed Tanya. We failed her family. Maryland is the only state that does not categorize repeat stalking or stalking when there's an active protective order as a felony. And as you've heard, Tanya's case is not unique. 54% of female homicide victims reported that they were stalked to the police before they were killed. Maryland is the only state that doesn't recognize enhanced penalties, and we need to do better. I urge a favorable report for this bill.
Good afternoon, Mr. Chair, members of the committee. My name is Brett Engler. I am the chief of the Domestic Violence Unit at the Frederick County State's Attorney's Office. I've been a prosecutor for approximately 10 years. My unit handles everything related to intimate partner violence, from misdemeanor protective order violations to domestic homicides in Frederick County. And what we know about stalking, and I won't repeat the statistics my colleagues have, but we know that stalking is homicide in slow motion, particularly as it relates to female homicide victims, so femicide victims. As Ms. Marsh said 54% of female victims report stalking to the police. If we want to prevent intimate partner femicide, we need to deter stalking. We need to incapacitate offenders before they murder their victims. Even if offenders aren't murdering their victims, they're forcing these women to leave their homes, take their children out of school, change their phone numbers multiple times, trying to get away because they don't think the criminal justice system can protect them. And under the current state of the law, we really can't. A felony conviction reflects the true nature of the harm that's done to a victim. Stalking, as my colleagues have said, requires an intense amount of law enforcement work that patrol really is not able to do. You need to cell phone map, you need to get search warrants for cell phones, you need to do historical cell site records. It's an intense amount of work. And law enforcement, with the limited resources they have, they focus on crimes that are felonies and crimes that can incapacitate offenders. We need a stronger penalty. We need, in Maryland, you can now get a permanent protective order for acts of abuse if under 50506 of family law, if your act of abuse is stalking and you've been stalked previously, as a victim, you have to choose, do you want probation or do you want 5 years of active time? Because that's the only way you're going to get a lifetime protective order in the state of Maryland for stalking. That gives victims a very poor choice from their safety perspective because you need, as Ms. Feinstein said, you need probation to deter offenders. That is the only way we can keep victims safe, and I urge a favorable report. Thank you.
Good afternoon, Chairman Smith and members of the committee. My name is Jessica Garth, and I am the Chief of the Special Victims and Family Violence Unit in Prince George's County at the State's Attorney's Office. I'm here on behalf of the MSAA and State's Attorney Aisha Braveboy to urge a favorable report on this bill. As my colleagues have already pointed out, stalking is an insidious crime. It places our victims in fear. It places them in a constant state of having to look over their shoulders. It places them in a constant state of invasions of privacy and of violence. This bill enhances penalties for only the most serious offenders of stalking, those who have been previously convicted and those who have an active protective order. What that means is that these people who are facing this enhanced penalty have already shown a willingness to engage in this behavior after a court's adjudication. They've shown that they are dangerous not only to the specific victims in these cases, but to the community as a whole. Felony classification of stalking, which is one of the components of this bill, has a significant impact on our ability to prosecute cases. Felony cases in my unit are screened vertically, which means that a specialized prosecutor becomes involved in the investigative process at the earliest moments. It means that these cases are investigated by detectives rather than patrol officers, and it means that overall, our communities have more resources to devote to these investigations and to these prosecutions. When we have more resources, we have better outcomes. We have increased convictions. We also have increased rehabilitative services. And what we know is that increased convictions and services reduce recidivism. And decreasing recidivism cannot be understated in these cases. As my colleagues have pointed out, the statistics show that people who have convicted of stalking commit crimes of violence, including murder of those same victims. And this is something that we have to prevent. Victims of stalking in Maryland deserve more protections, especially when these stalkers have already been given a second chance. This bill helps to provide those protections, and I would again urge a favorable report. Thank you.
You're all right on time. All right, Senator Huff.
Yeah, I would just like to ask, before we increase the penalty on something, to see, I mean, obviously, if we increase the penalty, it's because the current penalty is not deterring or incapacitating people. And the fiscal note says in 2021, it looks like there was 31 cases. 2 of them ended up going, basically serving time, and 29 of them went on parole and probation. So I guess my question is, if the vast majority of these people right now aren't serving time, I mean, how does making it a felony or increasing the penalty change that?
Thank you so much for your question. Would you like us to go to the podium to answer? Sure. Thank you so much for your question. One of the things that we've actually been discussing sort of across our state's attorney's offices is that because stalking comes in through the district court, It's typically charged as a part of, a charging document that a patrol officer has put together. And there's not a lot of information. There's not a lot of evidence that's been gathered. And the time frame in a district court case is really fast in non-COVID times. Now, it's still pretty fast, I have to tell you, even in COVID times. Our district courts and our domestic violence dockets have been up and running in my county. And with that short time frame, there's not an opportunity to secure the cell phone records, to get the mapping, to get the historicals. And so oftentimes, and again, we were all having this conversation, oftentimes those cases are not resolved to the stalking because we simply can't prove it. It's being charged, it's being alleged, but we don't have enough time and resources to be able to prove that type of a case. And really, by having a repeat offender enhancement, we're getting at the most violent people. And we definitely have repeat offender cases. We definitely have individuals that have been charged with stalking before and have repeated that stalking behavior, and the statistics bear that out. And really, by increasing the penalty and raising the level to a felony, it puts it on the same level as other similar crimes of violence. And when you see this type of recidivism, the dangerousness factor just goes up and up and up. And that's what we're trying to prevent.
I understand, but, on the flip side, I mean, we have to be very careful because what we turn into a felony and not. And I certainly understand the argument for a subsequent penalty, but there's a lot of other serious things that come in front of you all, assaults and things like that. And so if there's not the resources, that seems like it's a separate issue than making it, and we could make everything a felony, but we're not obviously going to do that. I guess it's just my concern. I mean, if you're looking right from I'm looking at it, you've got two inmates in there right now. So that's just, it's hard to make the argument of when we're not even, and we see this a lot. We had one to do an assault on, I think it was healthcare workers or something that came in this, it was the same deal. They were all getting parole, it was transit workers. And then the transit workers, they were all getting parole and probation. They were not even being incarcerated, and they wanted us to make this assault a felony. And it was like, we're going to make it a felony. You're not even incarcerating now. So perhaps the state's attorneys need to just do a side, if we make it a felony or whatever, it seems like maybe they need to do or if we don't make it a felony, need to do a separate unit or something about dealing with it. I mean, it sounds like more of a resource issue, what you're arguing, than the law, because right now it's hard to justify the law when you only have 2 inmates and 29 have parole and probation.
I'm going to defer to Ms. Marsh to answer that second question, if that's okay with the committee.
Sure.
Thank you.
Senator Huff, thank you very much for that question, because quite frankly, that's a big concern of all of us. When we run the sentencing guidelines for stalking, if somebody has a major criminal record, so they are at the top end, they've got 7 or more misdemeanor convictions, or they've had a couple crimes of violence. With a major criminal record, the way stalking is right now, the guidelines are 3 months to 2 years. That's with a major record. With a minor record, they're probation to probation. With a moderate record, they fall within a probation to 1 year. That's why you don't see individuals who are being incarcerated on stalking, because our guidelines, even when somebody maxes out, give us that very low end. And what we see oftentimes, like what Ms. Feinstein said, is because of the fact that they're in the misdemeanor or the district court, they go much quicker, and we often have to resolve cases with maybe it's just the harassment versus being able to actually meet the stalking. And I know there have been several cases where we've had to make resolutions instead to other counts because we don't have that cell phone mapping. We don't have that additional evidence to show that continuing course. We do want them in specialized units, without a doubt. There's a study that was done, and it indicated that to properly investigate and prosecute a stalking case, it requires 10 times the amount of work hours than the average domestic violence case, and that's by police and the prosecutor. And unfortunately, that level, which is the national best practices for stalking investigations, cannot be done with a misdemeanor, with the maximum they're going to get with a major record between 3 months and 2 years.
So does making it increasing the penalty on the subsequent without making it a felony, does that assist in what you're trying to get at?
I think in part, because obviously at that point guidelines would change as well. But I think when we make it a felony, almost all of us, I think we all have vertical prosecution with regard to those serious felonies, and they're assigned to specialized domestic violence or special victims investigators. And so by having a felony case like that, you get a specialized detective who's had the proper training, and then you get a specialized prosecutor who's had the proper training to make sure the cases are handled appropriately and that the victims are protected.
All right, I mean, you could see it from our point of view. We say, we gave you up to 5 years to put them away, and then they're not coming in. We don't control, obviously, the sentencing guidelines or how your offices are structured, so I generally see it from our view, it's like, you know, you want to see a whole list of people, like, oh, all these people are getting 5 years, they're all getting the maximum, and that's not working, so now we got to come back and add on more, so, but I understand the subsequent and stuff, so I'll look at it, thank you.
Thank you very much. The only other one thing I'd point out is it's not a crime of violence, so even if they max out, they're getting out at a quarter of their sentence, so even if we could
We
convince.
could fix that, we could make it a 14101, we can do
So,
that.
well, that would help quite a bit, quite frankly. Just something that simple would help quite a bit.
I mean, we could do that. I mean, that's another idea. I just have a hesitation we get a lot of bills in to make things felonies, and, you know, if we passed them all, almost everything would be a felony, so, but I understand the seriousness of the issue. Thank you.
Thank you very much.
And I don't, whoever is best can answer this. Is there research that shows, I'm looking at page 2, lines 24 through 26, and I'm wondering, it says that a person has previously been convicted once under a crime under the laws of another state, actually 22 through 26. So if they have a history, are you looking at a history with that specific person or not necessarily? Because I don't think that's clear if you are. And I guess the follow-up to that is, if somebody has stalked someone once, does that necessarily, is there research that shows that that is a proclivity that they have, that they are apt to do it again, in which case that leads to a different answer to that question?
So if I can answer just a little bit on the study part, there are several studies. Most of them, I will say, are related to the intimate partner violence stalking. And there is one that specifically found that and this study went through, and I'm happy to provide the actual site to you as well, Senator Hettleman, but went through 3 different subgroups of stalkers. So intimate partners, stranger stalkers, and then just kind of acquaintance partners. And they found that when it came to reoffending, intimate stalkers were the most likely to reoffend at 92% with regard to, as opposed to 56% with the rest of the groups. So the other groups are still hitting over 50% subsequent restalking, but the intimate partners are at that 92% they found when it comes to repeat stalking. The other thing they found is with the study, when it comes to stalking, that the average time they repeat stalking from being arrested is within 117 days. And so when we're talking about our intimate partner victims, when they do go to law enforcement, they do go to get help, and then their persons may be arrested, maybe they're charged on a summons, and then within 3-4 months, they're back stalking them again.
So that's very helpful. But so is the bill aimed at somebody who is stalking the same person, or not necessarily?
It's not necessarily, because what we have found, unfortunately, is that many times a stalker, the behavior that causes an individual to stalk, will exemplify those same behaviors with the next person they get in the relationship with.
Right, so it's the power and control,
So
not necessarily.
It's exactly the power and control dynamic. And when we broke through the other states, and again, Maryland is the only one, so every single state and the District of Columbia has the repeat stalker enhanced penalty. And they found the same thing when they were going through their laws as well, that the stalker would repeat with the next relationship.
Helpful, thank you very much.
Senator Hillman, that was actually my question as well, part of my question, because I thought it was a drafting thing, or was it a policy choice? Because it didn't read, it was the same person that could have, you know, someone else could have an order against you, and then you're stalking someone else, and then you get it. And it doesn't have to be against the person you're actually stalking, so.
I'm
Is that a
sorry.
drafting error?
The
Or so?
protective order is the same person. So if
Okay.
I have a protective order, the enhancement only comes, I'm going to make Ms. Feinstein my stalker.
Yeah.
If she stalks me, not if she stalks somebody else. If there's been a prior conviction against anybody, the subsequent conviction makes the enhancement.
Got it. So, okay, then this lower down on page 2, okay, so if the person has been previously convicted once under subsection C, there you go, okay, because I was wondering if that's a policy decision as well. Okay.
Yeah.
Just, it read interestingly to me, so I didn't understand it initially.
Can I say that's the same as our protective order subsequent offender? That's been the law for quite some time, is what I see in my practice. I'm sure everyone
Could you pull the mic towards you?
sorry.
It's,
That's the same as our subsequent offender for protective order violations and/or peace order violations doesn't require that to be the same person. And what I see in my practice is that offenders are breaking protective orders, but against multiple women, almost every relationship they've had.
that's interesting. Okay. Yeah, I know. Yeah, yeah. All right, well, I'm glad I'm not as familiar with this then, all right? All right, any other questions from the committee? All right, thank you all very much. Thanks.
Thank you.
Thanks. And I think that will then conclude the testimony and the hearing for Senate Bill 429. We'll now move on to Senate Bill 533. Senator Reedy, welcome back to JPR.
Thank you. Great to be back.
No more amendments, man, you know.
Very nostalgic. Just talking to my staff saying I miss those rollicking JPR voting sessions. It's a little tamer in finance, but you know, maybe not quite as thrilling. So, Chairman Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings Committee, I'm glad to be with you today to discuss Senate Bill 533. It would classify the theft of a handgun as a separate felony offense. This first conviction would impose an additional 5 years imprisonment with a minimum of 2 years and $1,000 fine, and/or $1,000 fine. Second conviction would impose an additional 10-year imprisonment with a minimum of 5 and up to a $2,500 fine. So under current law, and many of you know this from previous years that we've discussed this issue, but under current law, Maryland classifies any firearm with a barrel length of 16 inches or shorter as a handgun. Theft of a firearm is subject to the general theft statute, which imposes penalties based on the value of the stolen property. A first offender with who steals a $600 handgun will receive a misdemeanor charge with a possible 6 months imprisonment. And if they don't learn their lesson, the second or subsequent conviction is only possible 1 year imprisonment and $500 fine. These penalties are far more fitting. We want to have a penalty that is far more fitting to the crime of stealing a handgun than what we have in the current theft statute. According to the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, the 56% of firearm traces in 2020 were pistols and handguns. Additionally, over 1,100 of the traced firearms in 2020 were in the possession of those traced firearms were in the possession of individuals younger than 21 years of age. And around 240 of those handguns were in the possession of kids 17 years old and younger. And while not every firearm that's traced is previously used in a violent crime, they're requested by local law enforcement agencies for the purposes of investigating the sale, transfer, and possession of specific firearms. We know from the statistics as we see, you know, there's been a lot of talk about violent crime this session, and I think it's appropriate. And there's we've talked a lot about the need for action on that. We've seen when we get statistics on the murders that are committed in our state, we've seen that the large majority of those murders are committed by handguns, and quite often, most of the time, that handgun is not a legally obtained handgun. Not always is it stolen. Sometimes it's obtained other ways, but there are stolen handguns involved in these types of crimes. So it's clear that it's common, and current law does not impose serious enough penalties to both deter people from stealing a handgun, but also to make sure that if someone does it, that they do pay that penalty. I think we have a lot of discussions about firearm safety, gun safety. I know you had a bill earlier today relative to firearms. We've had a lot of battles in this committee on, you know, what's the appropriate restriction on the Second Amendment and appropriate restriction on law-abiding citizens' rights to own and carry firearms. And we've talked a lot about penalties for people who hurt people with firearms. To me, it makes a lot of sense that as much as we've regulated the right to keep and bear arms, that if someone were to steal a handgun, and quite often it's not for a good purpose, that should be a felony, and there should be serious jail time associated with it. And so I would request a favorable report on Senate Bill 533 and ask for your support and see if you have any questions.
All right, thank you, Senator Reedy. We'll now move on to your panel, and I'm sure there'll be some questions during this resolve. So we'll call up Mr. Pennock, Ms. Mooney, Mr. Hodge, Ms. Novotny, and we'll go from there.
Thank you, Mr. Chair. I'm Mark Pennock, President of Maryland Shall Issue. We strongly support this bill. I know from my 3 decades at the Department of Justice that stolen handguns are crime guns. They are used to commit violent crime. And yet, the thief receives virtually no penalty in Maryland. First offense, probation. Second offense, probation. That person is not even punishable by a severe enough sentence to make him ineligible or a disqualified person to buy a handgun or any other firearm. Contrast that serious crime that leads to death and crime all throughout Maryland with the punishments that this body and the state of Maryland minister to innocent possessions. The person outside of Maryland moves into Maryland and has a handgun and he fails to register it with the Maryland State Police within 90 days, he can go to prison for 5 years and a $10,000 fine. 5 years. If a person in a Pennsylvania resident drives across Maryland to West Virginia and he has in his possession, mere possession, and a so-called assault weapon, which have been banned in Maryland, he can go to jail for 3 years. Again, no intent or mens rea required. Yet a thief who knows what he's doing is wrong gets probation on something we know actually is contributing to the crime wave in Maryland. We urge a favorable report on this bill. Thank you.
Good morning. Carla Mooney, District 29C. I come in to agree with him on bringing a favorable report on this bill, but I come in representing women for rights to have firearms. I come in through personal use and hopes that as a firearm owner, if my guns are stolen, that person will actually be penalized for it. I know that we have a crime wave going on in our communities that has everything to do with no recourse to the crimes being committed. Let's bring that up and make that a change in our communities. Let's penalize these criminals for what they're doing, not penalize the law-abiding citizens for trying really hard to protect themselves from the criminals. I have some friends who are gun owners who are domestic violence survivors who have had their guns stolen from them by their abusers and used against them. No penalty for that, only the penalty for the abuse that they were given. Please give a favorable report to this bill. Thank you.
Good afternoon again, Chair, members of this committee. My name is Katie Novotny. I'm coming to you from District 35B, and I strongly support this bill. Thank you, Senator Reedy, for bringing this again this year, and I certainly hope we can have some movement on this bill. I think this is common sense legislation. As has already been said before me, these misdemeanors, they don't even make you a prohibited person. You can steal a firearm, handgun, whatever, and go out and still legally purchase a gun in the future. And that's just not okay. And also, oftentimes, misdemeanors aren't even prosecuted. These charges that would be potential theft of firearm charges are often associated with other charges. And, with these very small penalties, they're not even going to waste their time prosecuting those. It's not worth their time and effort, to investigate, find out that it is in fact a theft, and prosecute. Instead, these police departments parade these pictures of recovered firearms on their social media pages to say, look what we got off the streets. Yet you can look in case search and see what the outcomes of these are, and it's nothing. These same people are back out, recovering, firearms are recovered from the same people over and over, and nothing is ever done about this. And I think we can all agree that there is, no legitimate reason to steal a firearm. No one is stealing a firearm to go shoot a USPSA match. This is definitely something that drives crime, and the penalty needs to reflect that. Later today, we're going to see a bill that would like to impose a 3-year prison sentence on people for innocent behavior, yet theft has no teeth. I request a favorable report. Thank you.
Mr. Chairman, Senators, my name is Darrell Hodge. I'm a resident of Arnold in District 33, and I would not have believed it, but in one afternoon, we have 2 common sense gun bills. In his testimony last week on unserialized firearms, the Commissioner of the Baltimore Police Department indicated that up to 15% of the recovered weapons were unserialized firearms. What that tells me is that 85% or more are coming through theft or illegal sales. That's what we need to target. This bill targets the theft portion. This bill should be supported. Thank you.
Thank you all. I wonder if we get Mr. Apenic in the mix on this as well. Sorry, Senator West, go ahead. I'll ask my. Sure. So just want to, and either to the sponsor or Mr. Apenic, but so if you were to dial back, so right now it's the sentencing scheme is based off of the price of the actual firearm.
Correct.
Okay, so if you were to then, how many, I don't want to hark on the mandatory minimum piece. I'm going to ask a specific question, then I'm going to ask a more existential question. But if you were to dial back on the mandatory minimum and then, let's say, enhance the penalty based on whatever, less than $100, which is a 90-day misdemeanor, would you make it a felony? What would you do? How else just take out the mandatory and give me a sentencing structure that you think would be effective?
So the answer is probably not, because these sort of crimes are
Prohibited
simply
crimes.
not prosecuted.
Got it.
You heard from a prior testimony today that prosecutors have special procedures for felonies. And they take these crimes much more seriously, and they get more resources for doing so. The problem with these theft crimes we have is that the guns end up being used in violent crime because they're sold and quickly resold. But nobody prosecutes the thief, and they all know that.
What is remind the committee again, then, to be a prohibited individual, you have to be sentenced to a sentence of longer than what?
Well, if it's a felony, it's 1 year.
Yep.
If it's a misdemeanor, exceeding 2 years.
2 years. So what about a 2-year misdemeanor?
Well, 2 years wouldn't be good enough, so it would have to be in excess of 2 years.
Yeah.
Or
more
under
than
state
2 years
law.
and a day, whatever, more than 2 years.
Yeah, and a day. So that would at least make them a disqualified person, so that if you caught them with the gun again, you could then prosecute them for illegal possession. That would be at least something. But and these people are caught all the time, but they're not prosecuted. But we'd love to see severe penalties for the theft itself, because that discourages the thefts in the first place.
The second, more abstract question is, and this is a serious question, this isn't like I'm not trying to make a political point here. Just, why do you suppose that people that would come in on some of the other gun bills we have today are not coming in on this one?
I don't know.
No, I'm serious. I'm not messing around.
I don't know the answer to that question. I would think this is such common sense that to anybody who knows anything about criminal prosecutions, that this should receive complete support from everybody.
Mr. Chair, can I ask you, who are you referring to?
Just referring to some of the people that might come in on some of the other bills and are not here today supporting this one. I mean, the question then is, the more direct question is,
Oh, yeah. Well,
do you
I'd like
think
to
that this would
answer that,
have,
too.
I mean, are there underlying, unintended consequences of legislation like this that could disparately impact communities of color or not? I'm really,
Mr. Chairman,
I
that's a
think
great question.
these issues have to start being discussed out loud.
Sure, that's a great question. And I will tell you that there are some people in communities like mine that would be concerned about theft of handguns, because you could have some sort of domestic dispute where someone takes a gun and, or someone says, oh, that's my gun. It's not. In Carroll County, we've got almost everybody owns some kind of firearm. This deals with handguns, but it can cut more than just the way you're talking about. This is a mandatory minimum because I think it's a serious issue, but I'm, open to talking about if there's an enhancement, way to do enhancement that isn't a minimum. I think we need to make this more serious in the law, though. I really do. And so that I'm open to that discussion. There are groups that I have had in my office talking to me about some of the other gun control bills that I've said, why aren't you supporting, whether it's my bill or
Yeah.
other similar bills? So I think it's a fair question all the way around.
Because we're trying to tackle an obvious problem. I mean, it would be great to have a balanced debate with both sides coming in and just providing like intellectually honest analysis. And if there are data or if there's information or social science to support, hey, this is going to have a disparate impact on one side or the other, or on one segment of the population or not, it would be nice to have that discussion out loud so that we can make these informed policy decisions. And so just a challenge to advocates on both sides. It would be nice to see some of the frequent flyers on gun bills here to lend their voice to this, because I'd really like to hear that. It'd be great.
I too would like to see that kind of data, and I think on the surface of it, it really doesn't matter if you're rich or poor or black or white. If you own a firearm, you don't want it stolen. And that's kind of true across the board, regardless of all the demographic figures that you may have, because that stolen gun may be used against you in a future crime or against someone you love.
Yeah.
So it ought not to be a social justice issue. It just ought to be a common sense issue.
But unfortunately, it all too often is, because some of the laws are just applied
Mr.
differently in certain, yeah.
Mr. Chairman, I understand your point where you're coming from,
Yeah.
and I'm open to that conversation. I will say, Mr. Penix pointed out an equity issue on if someone accidentally transports the wrong gun to the wrong place in our state, that's already in law, it's pretty serious. So I think we ought to at least we ought to look at how we can elevate the purposeful theft of a handgun to something higher than it is right now, and I'm happy to have that conversation.
Well, now that I've opened that can of worms, we'll go to,
I think Senator West was called out.
Senator, I thought Sidnor, and then Bailey, then Watson.
Thank you very much. For Senator Reedy, as I'm looking at the bill, I'm looking at one that seems it takes the gun and it kind of gives it a preferred status over all other property, so you can steal any property, and you're looking at this schedule here.
Yeah.
But the bill will give a special treatment to a weapon, and depending upon the cost of that, I guess under the current law, depending upon the cost of that weapon, you're going to get treated differently. But again, just so that it's clear to me, why should a weapon have this preferred status over any other type of property?
Well, I mean, my pithy response would be a very nice, a very nice garment or piece of jewelry can't shoot people. So, I mean, that's the first thing that I think is what I would say. But, I mean, I don't know. I think when we're talking about stolen handguns, and handguns obtained illegally, we've seen are a huge driver. That's what's being used to commit a whole lot of crimes, murders in particular, but also lots of other crimes. So that's the need for making it more of a preferred status. If I'm driving with cigarettes illegally in the state, if I'm like smuggling cigarettes, I'm not subject to the same criminal penalties as if I'm carrying a firearm that I legally own in another state and I'm driving through. So I mean, there's some areas of the law that have that sort of incongruity.
When a firearm's stolen, it can be used in a crime to protect a criminal. But if I used a firearm to protect myself and I'm not licensed, I'm a criminal. So the gun is a aspect of a crime that once stolen elevates the next crime to a lot more frightening civil disobedience. Our lives, our civilians are injured by stolen guns from drug dealers, stolen guns from
See, and that's where
gang
that's when
members.
I'm kind of get lost in
the gun
in the
elevates
conversation.
what comes next. If it's
Well,
not
possibly.
stolen,
Thanks.
That's where I get kind of lost. I mean, and even to your, I think to some of the conversations that we've had when Democrats have attempted to regulate weapons, and I'm thinking about your response, and then I think folk would then say, well, do we give knives preferred status? If you're stealing knives,
Sure.
do we need to? You see where I'm going?
I do. If there were if there were 300+ murders being committed with knives, I mean, in a jurisdiction, maybe we'd have something different going on here. I mean, I just think for me, in this state, we have dramatically, unlike most any other state in the country, other than maybe 3 or 4 others, we dramatically restrict the rights of people who are otherwise law-abiding citizens to own firearms, have handguns, carry handguns, and yet the crime that we are most concerned about, that we're all concerned about, the violent crime, is being committed overwhelmingly with illegal handguns. So to me, it makes sense that if our law...
Do you by any chance have any data about what you just said?
Well, we had a report from 2020 that there were 353 murders committed in Baltimore City, and I know we don't want to just talk about Baltimore City.
No, I'm not talking about the murders, I'm talking about actually, because, and the chair would tell you, I've been having conversations with him about gun trafficking, and I'm interested in gun trafficking. So, I mean, how many illegal guns, how many guns are being stolen?
Yeah, I don't know that, but I do know that they show up in crimes relatively regularly. They're not as much as the illegally trafficked, I grant you. It's not as big of an issue as the illegal trafficking, but my attitude is someone stealing a handgun, there's no good reason why you're stealing a handgun. And it can be used to commit very violent,
And one of the other questions I had, when the guns are, and again, I think from our laws, generally speaking, your gun owners, when they have these guns, they're in these gun safes or whatever, right? So, and you have to forgive me, I'm asking questions because I don't own a gun. I don't
understand.
know. Those gun safes, I mean, are they easy to crack open to get to the weapons?
They're not supposed to be, no. I mean, I'm sure there's some varying levels of security, but a gun safe is supposed to be very secure. But I will tell you right now, if you misplace a firearm and think it's been stolen, you're in a lot of trouble. A regulated firearm, you're in a lot of trouble in this state. I think we ought to have, again, equal, sort of, more than equal balance for the person that actually stole it.
Thank you very much.
Thank you.
Senator, I know the Attorney General had a task force that's supposed to produce a report in December or something like that, so I think that'll have some of the information you're looking for. But also, I mean, I think you may have been out of the room for a hearing or something, but we're talking about trafficking and how we're definitely going to take a deep dive into that this year. Senator Bailey, yeah.
Thank you, Mr. Chairman. Senator, I have a question, if you're familiar with, what's the value when we talk about stolen property that gets us to the felony standard?
That is, and I have it in my notes, that is, we get to a felony at least $1,500, but less than $25,000, is what I have.
Okay, so we can prosecute somebody for a felony if the value of what they've stolen is over $1,500.
Right.
Okay, so in my knowledge of guns, I would ask you if you agree or not. I'd say with handguns, that's about 3 guns.
Could be. Obviously, there are some guns that are more valuable than others, but yeah.
Right, that's 3 handguns. So my question to you then is having 3 illegal and stolen firearms more dangerous than having 1?
I think it is more dangerous, yeah.
Well, I would say you can do the same with 1 that you could do with 3.
Oh, right.
Right?
You can only shoot one, well, I guess you can shoot 2
Right, you
handguns
could
at a
do
time,
the
but
same
yeah,
with
right.
1 as you can do with 3. You sort of defeated me in my own
You can shoot 2.
argument there.
You can shoot 2 at a
Right.
time. 2 is more dangerous, is it just as dangerous as 3 for one person? That's right.
So let me follow up on Senator Sidnor's line of questioning, because I like the unique way where you're looking at this, because the cheapest gun can kill someone at a distance. The most expensive knife on a planet can't do that. And so I don't like that comparison like that. I think, based on where we are in our communities, this is common sense, and this should be in a class by itself because of the damage it can do, and it shouldn't be subjected just to the value of it, I think. And I'd like to hear, hopefully some more conversation about that, and if we do this, going back to Senator Sidnor's point, are there other things that would fall, or is this really the one unique thing, because we're looking at it not on dollar cost, but literally on potential damage if used improperly. And that's kind of the lens that I hadn't thought of before, but I'm looking at it like that. Do you have any comment on that, Senator Reed?
Well, I appreciate the point of view you're saying, and I think that's really the reason to put this bill forward. And it's not that this bill itself is the panacea for all the problems we're
Right.
seeing with firearms or with illegal use of firearms. But as I told the chairman, this is a pretty harsh bill. I think it's appropriate, but I'm open to conversation about if there's a way that the committee wants to move forward. That I think the best point today has been made by Mr. Pinnock, talking about what happens if I'm caught driving between West Virginia and Pennsylvania with a certain type of firearm, and what I'm subjected to as a otherwise, as in my mind, a law-abiding citizen. There's no mens rea requirement even. So I think we want to at least be sure that the theft of a handgun is treated at least as severely as that. So I appreciate your questions, and I want to work with folks on this issue. It is an important issue to try to crack down on the violence that we see and try to do better.
Thank you.
One last question. This bill is about the theft of a gun, not necessarily the possession of a stolen gun. Correct?
Correct, it's the theft.
Do you know how often people are, do you have any statistics about how often people are actually convicted or prosecuted for stealing weapons?
I don't have those statistics with me, no. I would tell you that we do know that in a lot of jurisdictions where they're either choosing to, or in many cases are overwhelmed with just there's a lot of times that theft charges are not prosecuted. So I think those statistics could be misleading, but I don't have the statistics in front of me.
And again, the only reason I'm asking, to some of the data that you were kind of hearkening to, yes, there are probably a lot of stolen guns that are on the street, but just because that person is using a stolen weapon doesn't mean that they're the ones who went into someone's house and stole that weapon.
That's true.
Anyway, thank you.
Thank you. Thank you, Mr. Chairman.
All right. Do we have Michael Burke? Well, here we go. Come on up, and then Mr. Ditello, and also Mr. Jocelyn.
Mr. Chairman, I'm going to have to go because the other committee's calling me to present another bill. Thank you.
Well, hello again. I just wanted to reiterate, I believe in equal rights, and I don't think that this bill tramples on equal rights. I think that it makes it more fair in this state, because right now, what we're seeing is we have quite a few laws that criminalize gun owners just for how they transport a gun or how they own it. And in a lot of bills, we're seeing proposals for how they store it, or even just possession of certain types that the state doesn't approve of. Often far, far more than the current punishment for simply stealing a firearm. I believe in it, basically what everything we said here. This is a very pleasant discussion I've been hearing. It's good to hear from both a lot of the back and forth going on. But I think it is a very good bill, because we should treat theft of a firearm particularly different than theft of anything else, like theft of a TV. I mean, you're not going to hurt someone by stealing their TV, but you could, when you steal a handgun, your intent after stealing that handgun is very likely to commit a crime with it. So I would just ask for equal treatment for theft of a handgun over some of the other crimes that we're seeing in the state where there's not a clear victim. And for that, I ask you to please vote favorably on this bill. Thank you.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for information only on this bill. I often compare and contrast the legislation that we look at, and I found this very interesting. It does elevate the theft of a firearm to a felony. And I think the rationale is echoed by Delegate Atar when she testified on her bill to make it a felony for a straw purchase. Her rationale was that felonies got more attention and more resources than a misdemeanor and were more likely to be prosecuted. In the matter of stealing property, be it a firearm or whatever, let's say we're talking firearms, the penalty is 6 months and up to $500 for the first offense, up to $1,500 theft. So you could steal a dozen firearms, put them into unlawful pipeline of illegal firearms, do it again, do another dozen into the illegal pipe chain. Now you're looking at the 6 months for the first one, a year for the next time. You do it again, you get another year. So you're looking at 2.5 years for 3 offenses and up to $1,500 in fines. Now, let's contrast that to another bill we're going to talk about today. You own a piece of plastic, you did nothing with it, it's still in the box, but you could be convicted and be sentenced to 3 years and $10,000. If there's any sort of rationale between these two concepts, I don't see it. I believe that 533 is a reaction to the fact that criminals can and often do steal firearms, knowing full well they will not be prosecuted for it because they probably did things that were a whole lot worse. I think you should consider all the legislation before you with a very clinical eye. Compare the various concepts. And I would urge you in the future that before we announce anything's going to pass, that we all sit down and talk about it first. I think we'll make a whole lot more progress and everybody will get along a whole lot better. Thank you, sir.
Michael Burke, Delegate District 46. I've introduced myself before. Again, over 30 years of experience in law enforcement at the federal, state, local level, including investigating burglaries, thefts, and use of stolen firearms in crimes against persons. 3 chains I'd like to add in my brief period. 95% of the handguns available in the common market today are valued at less than $1,000. Someone could walk into an FFL that's well stocked and steal 1,000 handguns and face 1,000 misdemeanor charges. What are the likelihoods of him getting serious jail time for 1,000 misdemeanor charges? He'll take a plea, take probation, and 99% of those charges will be dropped, and the case will be let go. Let's take another case. A man breaks into a house, misdemeanor, steals a handgun, misdemeanor, stalks a victim that we just heard about in the last testimony, misdemeanor crime, shoots his intended victim. What is his sentence going to be? Probably probation, because it's not a felony to steal a $500 handgun. 2 anecdotes. One, burglary occurred recently in Harford County where someone smashed into a licensed dealer, broke through a brick wall and an iron grating, stole 27 handguns, 27 misdemeanor violations if they're caught. All of those 27 handguns are in the gun trafficking pipeline right now. Another incident, an individual broke into an FFL in Baltimore County, stole over 20 handguns, was caught, was prosecuted, was given a misdemeanor conviction, could get an HQL tomorrow because he was only committed a minor misdemeanor and didn't get more than 30 days probation. But he can get an HQL and get a wear and carry permit because he only committed a misdemeanor offense. We'd like to see this elevated to a felony because of the seriousness of the consequences of theft of a dangerous firearm.
Now I see why you're bent on the felony thing, because my last line of questioning, so 5138 is you can get up to 5 years misdemeanor. So obviously over the 2-year threshold to be a prohibited person. Okay. Now I'm trying to figure out, so give me more about the felony, because I mean, I'm trying to understand if you've got the sale, transfer, or disposal of a stolen, regulated firearm, you're gonna get 5-year misdemeanor onto that, which makes you a prohibited person. So talk to me more about the felony, why it's a big.
In the federal statute, the Gun Control Act of 1968, the prohibition comes in at the felony level. If we have, this is a state felony in Maryland, that every theft of a handgun is potentially a felony conviction, that raises it to a prohibiting factor under 922G1, a person who's been convicted of a felony. Any further incidents where that individual is caught with a firearm of any type, he's a felon in possession of a firearm, and federal penalties apply. So this disincentive will serve to reduce the likelihood of people going through neighborhoods looking to break into homes and steal firearms as their primary target, because they know there's no serious penalty for stealing 2 or 20 handguns in a day or a week, or committing the same kind of offense that we're seeing with ATMs. You smash into a Walgreens, you steal an ATM, that's a felony.
Well, I mean, we can have this colloquy later on, but I thought if you're, whether it's a misdemeanor, you're a prohibited person, or it's a felony, you're a prohibited person, you're still prohibited, and that has federal consequences, no matter which avenue you take to get there. But, so, I don't really understand what you're saying in that regard, but, we'll continue. Okay. Okay, thank you all very much. Thank you very much. I think that's it. That's the end of this panel. So that will then conclude the testimony and the hearing for Senate Bill 533. I think, okay, Senator Castley, you've got a relatively, I think, quick presentation here. So we'll go with Senator Castley with Senate Bill 484 while we wait for our other witnesses for the next bill.
We bring a panel up, is that all right? Thank you. Colleagues, this is Senate Bill 484, which is actually, this bill is also part of the governor's crime package that we heard earlier today, just as is Senator Reedy's. And this has to do with interlocutory appeals by the state of certain offenses. And just so we understand that term, normally in any trial, civil or criminal, you have to wait until everything's been tried before you can take an appeal. You can't say, well, the judge ruled against me on something in a preliminary motion, so I'll appeal that, and then we'll come back and we'll try the rest of the case. No, generally, in most instances, the judge will issue rulings as the case moves along, but you have to wait till the case is completely done and appeal everything at the same time. But there's certain exceptions to that, and those are in law, and we call those interlocutory appeals. And this bill has to deal with when the state would be allowed to take an interlocutory appeal in certain circumstances. So I'm going to move this along. I'll turn this over. You going first, Gavin? Sure. Okay. Gavin Potashnik will be our first witness out of State's Attorney's Office in Harford County.
Good afternoon, Mr. Chairman, members of the committee. My name is Gavin Potashnik. I am the Deputy State's Attorney for Harford County. I'm also here representing the Maryland State's Attorneys Association. We're here asking for a favorable report for Senate Bill 484. First of all, I would thank Senator Castley for bringing this to our attention. I also would thank Senator West 2 years ago, who brought this same issue to this committee. I would also thank Delegate Clippinger, who in 2016 brought this same issue before several committees. And I also thank Delegate Winika Fisher, who 2 years ago brought the same issue to several committees. This is a thing that we've been asking for time and time again. What it does is allows the state, in certain circumstances where a judge suppresses the firearm during a search, to allow the state to take an interlocutory appeal. Now, I will tell you, before everyone thinks that we're just going to appeal everything, it doesn't happen that way in our different offices. What happens is we have to get the permission from the state's attorney. The state's attorney looks at the particular case. The state's attorney then reviews whether or not the issue that we are appealing is a legitimate issue before he signs off on it. In fact, we have to certify to the Court of Special Appeals that we're doing this not to delay, not for any other nefarious reason, that we're doing it for a legitimate constitutional issue, and we move forward. It's a very high burden for us to reach. We do it for crimes of violence. We do it for certain drug offenses. I think for firearms, it's also important for us to do that because in many cases, judges get it wrong. And we like the ability to try to express our frustration, the fact that the Constitution is not followed, by allowing us the ability to do this interlocutory appeal, which does really no harm other than give us expanded power. We're not being greedy. We're not asking for all gun crimes, only certain types, particularly ones where individuals who are already prohibited due to a crime of violence, or due to the fact that there's a firearm drug trafficking, or due to the fact that they are prohibited in some way which the state already prohibits, is barred from a firearm. So not your wear, carry, transport, not your general misdemeanors, the real serious ones. We think this is a public safety issue. We think it's about time that we get given this power, and we'd ask for your support on this bill. Thank you.
Good afternoon, members of the committee. My name is Carrie Williams. I'm here on behalf of the Office of the Attorney General to urge this committee to issue a favorable report on Senate Bill 484. First, I'd like to thank Senator Cassidy for bringing this bill before the committee. Senate Bill 484 would expand the crimes in which the state is allowed to file an interlocutory appeal. And just to be clear, if the state cannot file an interlocutory appeal, it cannot appeal at all, because there is no right for the state to appeal as from a final judgment in a criminal case. So this is the only opportunity, if there is a legal error in the suppression hearing for a gun crime, for us to be able to try and rectify that legal error. Courts and Judicial Proceedings 12302C4 already allows the state to file interlocutory appeals for crimes of violence and certain drug crimes. And in that statute, there are protections that for the defendant when the state pursues that interlocutory appeal. First, the state has to note its intent to appeal within 15 days. Ordinarily, it's 30 days for most other appeals. And as Mr. Potashnik said, they have to certify that it is not for delay and that the evidence suppressed is material to the prosecution. The appeal must be heard and decided no later than 120 days from the receipt of the appellate record in the appellate court. Except in crimes of violence, defendants shall be released on their personal recognizance pending the results of the appeal. And except in homicide cases, if the state loses the appeal, it must dismiss all of the charges in the case from which it took an appeal. So there are consequences for the state that prevent it from taking appeals when we're not certain that the judge has made a legal error. Because of that, in the last 3 years, there have been 6 interlocutory appeals that the state has taken, and the state has prevailed in all 6. In all 6 cases, the Court of Special Appeals reversed the ruling of the suppression court and sent the case back to be tried. So for those reasons, the Office of the Attorney General urges this committee to issue a favorable report for Senate Bill 484. Thank you.
Mr. Chairman, I would like to just also point out the difference between this bill and the governor's, because I do have an amendment that I would be offering in committee on this one. That the bill as you see it before would add in appeals for possession of regulated firearms, unlawful possession of rifles and shotguns. The governor's bill adds on to this possession of firearm during in relation to, possession of a firearm during in relation to drug trafficking crime, firearm possession, restriction on possession of ammunition, restrictions on sale, rental, and transfer of regulated firearms, straw purchases, sale, transfer, or disposal of a stolen regulated firearm, transporting regulated firearms for unlawful sale or trafficking, knowing participation in straw purchase, and removal or alteration of identification mark of a serial number on a firearm. So those are what the governor's bill adds on top of what we have in.
Okay, got it. So the laundry list you just mentioned is not your amendment. Is that your proposed amendment to your?
Laundry, that additional laundry list would be in my amendment, so that my bill
Mirrors.
would conform to that piece of the governor's crime prevention bill.
You had me at the initial bite, man. Okay, all right, appreciate it. Thank you.
All right, thank you.
All right. Questions from the committee? Seeing none, thank you both very much. And that'll conclude, thank you, Senator Cassidy. That'll conclude the hearing for Senate Bill 484. We'll now move on. What are we going to do? Senator Carter, are you ready with 441? Yes, sir. Okay. You have your, all right, so we'll go on for Senate. Yeah, okay, absolutely. Take your time.
Is Tiara here? So she's not here at all. So she's not pulled Deb up? Okay.
So actually, I'm sorry, a little adjustment. I think we've got everyone here for Senate Bill 387. I see the Attorney General's here. Sorry. I know, I'm sorry. All right, thank you. All right, now we're now on to Senate Bill 387, and we'll start off with the sponsor panel with our attorney panel. We'll start off with our Attorney General, Brian Frosch, and then we'll go to Senator Lee afterwards, and then we'll hear from Assistant Chief Hale, and then Richard Warley. So
sounds great. Mr. Chairman, do you prefer mask on or mask off?
we've had people with the mask on, but
that's fine. That's great. So, ladies and gentlemen, you've heard bills similar to this in past years. But this has to do with ghost guns. Senator Lee has been a leader on this for a number of years. And just to catch you up in case you missed the memo, ghost guns are unserialized guns. They're made from kits. They're sold widely over the internet. And they are an increasing threat to public safety for two reasons. First, they're increasingly used in crimes, and you'll hear this from all the law enforcement officers that follow us. The recoveries from crime investigations of ghost guns have gone up by orders of magnitude in the past couple of years. Chief Aziz, the chief of Prince George's County, and Commissioner Michael Harrison have testified on the House side, and they both reported that ghost guns have gone way up. I think in Baltimore City, there were 12 guns seized in crime investigations in 2018. They're on track for 700 this year in the city. Last summer, they did a takedown of an organized crime unit, and they seized 15 ghost guns and 40 kits, polymer 80 kits, that had been acquired by the folks who were in this narcotics ring. It is literally the gun of choice for criminals these days. The second major problem with ghost guns is that kids are getting them, and they're using them. Less than 3 weeks ago, a 17-year-old kid goes to Magruder High School in Montgomery County and shoots a 15-year-old kid, allegedly, with a ghost gun. He got it with a credit card, bought it over the internet, and same thing a year ago in Montgomery County. There was a 14-year-old who's accused of killing a 20-year-old with a ghost gun. Why are they so popular? You know, they're very easy to get. There's an adage that on the internet, nobody knows you're a dog. Nobody knows you're a kid. Nobody knows you're a violent criminal. So if you've got a credit card, you can get yourself a ghost gun delivered to your doorstep. And if you're a violent felon, if you're a 14-year-old, they'll come to you. You won't have to go through a background check. You won't have to prove that you're an adult. It's cash and carry, and the guns are already 80% made. The manufacturers advertise that you can put these together in an hour or two, sometimes even less if you're really handy. So they can be assembled easily, used easily, and if they're used in a crime, they can't be traced. You find a ghost gun at the scene, that's really, there's nothing except perhaps fingerprints that connects you to the perpetrator. These guns have been outlawed in 10 states and the District of Columbia. Our bill will treat these kits as firearms. That's what they are. It'll close the loophole in Maryland law. It'll keep them out of the hands of kids. It'll keep them out of the hands of violent criminals. And we hope that you will take action on this very important public safety measure. Mr. Chairman, I'm happy to take questions now or later or whenever you like.
Excellent. We can do that. Actually, we'll take the questions now so your schedule's tight, and if that's satisfied, then we'll move on to Senator Lee for her presentation.
Sure.
Senator Castley, go ahead.
Mr. Attorney General, good to see you. Thanks for coming in.
Nice to see you too.
So I'm just curious because, you know, we've been struggling with the rising homicide rates and I think the General Assembly as a whole and trying to, you know, there's been a lot of different approaches. We had the governor's crime bill here a few hours ago, I guess, it's getting late. And over the past month, we've looked at a bunch of various bills. But this is the one that you chose to come in on was a ghost gun. So I'm just curious as to why. Why you're picking this particular avenue as opposed to the other various approaches that are being looked at?
Well, I mean, the governor's approach is to increase the penalties, and I think we've proved repeatedly that that doesn't work, not by itself. And this is something that is a clearly identifiable problem. It's a problem that's mushrooming, exploding, and there's an easy fix to it. You want to buy a gun, get a background check, show that you're an adult, show that you're not a violent felon, and we know that we can reduce crime that way. And so, I mean, this is highly targeted, and we believe it'll be highly effective. So that's why we're pushing for this. It's an easy one. I mean, look, you'll hear, I believe, from Republicans and Democrats in law enforcement that this is the way to go. These guns are a real threat.
But, so I know that I saw a bunch of, I think the Second Amendment folks had submitted Freedom of Information Act requests to various counties and I think state police as well, looking for data. And that was something that we had asked for early on in this body was data, because prefer to have a data-driven approach as much as possible. I mean, you have to, at some point, the data is just not there. We recognize that, but particularly when it comes to killings and all, we're looking for data on this. Do we have that hard data now of, you know, we have, here's all the murders in the state of Maryland, and then how many of those are committed with ghost guns versus stolen guns versus we don't know, it's a gunshot, but we don't know what it was. Are we able to quantify that yet?
Yes and no is the
Okay.
answer. I mean, and Mayor Scott is here, I'm sure he'll tell you what the numbers are specifically in Baltimore City. But as I said in my testimony, we see the use of ghost guns rising in crimes. And not just rising by 10% or 15%, but by hundreds of percentage points. And it's year over year, it's getting worse, and the trend is really alarming. So can we say that X percent of the gun crimes are committed with ghost guns yet? I don't think so. I mean, maybe that the Maryland State Police have that information, but I don't think so, and they don't have it for a couple of reasons. Number one, once somebody's shot, you can't tell whether they're shot with a ghost gun or a serialized gun. Unless the gun is found at the scene, it's very difficult to figure out whether the weapon that was used was a ghost gun or not. If they can identify the gun later on and say, okay, yeah, that was a ghost gun, those are the crimes that they can keep track of. And as I said, it went from 12 3.5 years ago in Baltimore City, on track for 700 this year. And those are just the ones they can identify. So no, I can't give you, a complete analysis.
Yeah.
I'm not sure anybody can. But we
Yeah, I
can
just
point
wish
to
that
a
somebody
really
could
alarming trend.
put some, I look at, the data that I'm looking at a report here that says that Baltimore's, of the past 7 years, 48% of the known homicide suspects have a prior violent crime arrest, 42% face previous gun charges. It seems like that kind of encapsulates the essence of the problem here about why the murder rate is so high, because if 48% of the known homicide suspects have prior violent crime arrests, if they weren't committing that, then 48% of the crime would go away. So half the crime is violent crime is being committed by people with violent criminal past. It seems like that ought to be that bright shining beacon that says, here's the problem, here's the problem, here's the problem. But obviously ghost guns don't address that. And I'm just curious if you see anything aside from the ghost gun legislation that ought to be being pursued by the General Assembly this session to try to address really the immediate side, try to reduce the crime.
And this is right in your lap too. I understand that the parole and probation offices, state parole and probation offices are understaffed, overworked, and that many of the 40% that you're talking about are people who are supposed to be supervised by the state of Maryland. And they're not, in large part because they don't have the personnel to do it. So, I mean, that's right within your wheelhouse. I would go for that.
Yeah, I've heard the parole and probation argument as well. The challenge we have is they have no arrest power, and they're not with people, they're not babysitters. They check in periodically to make sure, are you getting a job? Are you living here? Kind of basic stuff. And in between those visits, they can rain terror, and then you come back for the next visit. In between, there's terror rain, and parole and probation has no ability to interact on that. They can't interject there.
Well, I'm not sure that their authority is too small, but I know their resources are too small. I mean, look, this is what parole and probation's job is supposed to be about. They're supposed to keep control of people who have been deemed appropriate for release. And they play a role in whether or not those folks get released. They make recommendations to the judiciary. So, I think ghost guns is an easy, clear winner. I think parole and probation is, maybe a shade below that, but I think it's a good place to look next.
I appreciate you. I'm sorry, I didn't mean to cut you off. Did I cut you
No.
off?
Just want to keep it on the ghost guns in the bill.
Yeah, I didn't mean to, if I did cut you off. Well, thank you for your testimony. I'll listen, I'll try to understand what you're saying, but I just, in all candor, when I look at, we haven't quantified this as the real problem. I'm not saying it's not a problem, we haven't quantified this as the root cause of this dramatic increase in murders over the last 7 years and even more over the last year. and on the ghost gun side, and the parole and probation, they were there doing the same job for the past 7 years, and all of a sudden this year, in the last, year, suddenly this huge dramatic increase, but we've got the same parole and probation people doing the same job. Baltimore City has more parole and probation agents than the rest of the state. And so, we'll listen. I appreciate you coming in, but.
I mean, my understanding is you have fewer parole and probation people than you did 7 years ago. I think that's significant. And with respect to ghost guns, we're not at the top of the curve yet. What terrifies me is the steep arc of the curve that we are seeing.
I just don't want to be chasing ghosts. I'd rather really get something done.
All right.
I'm with you.
All right. Obviously, our crime problem necessitates a comprehensive approach, and there you go. All right. Senator Heddleman.
Mr. Chairman, thank you for being here, Mr. Attorney General. I wonder if you could, we often hear about the issues of crime in the city, but I wonder if you could shed a little light on whether you see ghost guns as being an urban problem, suburban problem, state problem, or national problem?
It's all over the state, as far as I can tell. I know specific instances in Prince George's, in Montgomery, and Baltimore City, and I believe you'll hear from the State's Attorneys Association that they're seeing it all over the state. If there are law enforcement officers from elsewhere in the state, you'll hear it from them too. It's something that everybody in law enforcement is concerned about. I'm sorry, I don't mean to mean every single person, but many people in law enforcement are very concerned about it.
Thank you.
Excellent. Thank you, Mr. Attorney General. Seeing no further questions, thank you very much.
It's a pleasure to be here in person again.
It's a pleasure to have you here in person, the former chairman of the committee. That's good stuff. All right, Senator Lee.
Yeah, thank you, Mr. Chairman, and thank you, Attorney General Brian Frosch, for making this one of your highest priorities this year, and for being a champion of gun safety. We are so grateful to have you as our Attorney General. I just want to say that this bill, SB 387, has been in the works for a number of years. It's been brought by Delegate Lopez and I think that its time is ripe right now. As you heard, there's already been 5 ghost guns that have been found in my own county, in Montgomery County, in schools alone. And that's particularly troubling that now kids are able to access ghost guns and do some damage against their fellow students, but also other individuals they encounter. And that's particularly troubling. And there's been an increase. And I don't want to hear about another gun tragedy where we're all offering prayers and thoughts. No, we don't want to just do prayers and thoughts. We want to do something about this. And this is an easy way that we can do. We can put a dent in at least their access to these very easily accessible guns that can be assembled readily. So this is just a ban on unserialized parts used to build a ghost gun and create a clear and comprehensive prohibition based on pending federal rules that will define firearms more accurately to include frames and receivers that can be readily finished and built into a working firearm. This is not the same bill that you've seen in the committee past years. It's been streamlined and revised to work alongside the pending changes to the ATF rules, changes that will finally clarify the term firearm that includes completed weapons, finished frames, receivers, and unfinished frames and receivers. This bill makes the change identical to Maryland law, clarifying that the term firearm applies to completed firearms, finished frames and receivers, and unfinished frames and receivers. When the federal rules are finally finalized in the upcoming weeks, or perhaps in June, they will ensure that all federal laws applicable to firearms, including serialization and background check requirements, are also applicable to unfinished frames and receivers, the core building blocks of untraceable ghost guns. Manufacturers who produce these unfinished frames and receivers will have to mark them with a serial number, and it'll be illegal for licensed gun dealers to sell them without a background check, just like any other firearms. By updating state law, this bill would ensure that all Maryland's strong gun laws apply to unfinished frames and receivers. The new federal rule will also create a new class of federal firearm license for those who want to engage in the business of serializing self-made firearms, ensuring that those who wish to build their own firearms can comply with the federal law when doing so.
Our job as state legislators got much easier because we have a framework for which to define an unfinished lower receiver, anything that can be readily made into a functional firearm. Our definition is meant to mirror the forthcoming federal definition to be interpreted in accordance with the extensive guidance contained in those regs. This is not only to ensure clarity and consistency in the application of the law across the state, but also alignment with the clarified federal law. Like the federal law, our bill does not prevent people from building their own firearms if they want to do so. It simply requires that the gun they build will be marked with a serial number. And let me tell you, this is not a great burden. So they can be traced by law enforcement in the event that they're lost or stolen or used to commit a crime. It's helping our law enforcement be able to solve crimes, but also our state's attorneys to prosecute those crimes. It also expands on the federal definition to include items that are marketed to the public as a firearm, frames, and receivers. This will help ensure that the law reaches those who modify their products in an effort to evade the new federal and state definitions of readily, so they can go on and selling these deadly parts and kits with no background checks, no questions asked. The hard work of years that past has been distilled into a simple value judgment. Should guns be serialized in Maryland subject to laws we passed to keep guns out of dangerous hands, or should we let them haunt us like ghosts? Solving crimes is not easy, so should making solving gun crimes a top priority. This helps with our effort, as law enforcement will attest today, and with the witnesses that are here today. They'll give you a more detailed account of how this affects them and how they're better helped by this bill. This bill will help prevent gun crimes by cutting off the supply of these kits and these parts that are currently a choice of weapon for violent felons, gun traffickers, violent extremists, and those who want to wreak havoc. I just want to say that I'm troubled by the shooting at Magruder High School in our own county. And we have to do something about this to just finally close this dangerous loophole so that our other gun safety laws will be effective. And we need this bill. So we just want you all to know that this is a good way, as the Attorney General said, an easy way. And we want the ability to be able to solve those crimes. And just in closing, I want to say that this legislation simply outlaws the possession of non-serialized parts used to build an untraceable firearm. Those parts known as unfinished frames or receivers, and they would be considered contraband unless they are required to have been marked with a serial number as required by federal law. Thanks to changes in the ATF rules, we expect those requirements to be in place at the federal level by the time this bill goes into effect, hopefully. People can continue to buy unfinished frames and receivers and use them to build firearms if they wish, but those parts under this bill and under federal will have to be marked with a serial number and cannot be purchased without a background check. And those who have previously purchased those unfinished frames or receivers or used them to build unserialized gun can keep those parts and firearms so long they have them engraved with that serial number. Licensed gunsmiths and dealers can provide engraving services in both the bill and federal law for allowed practice for building your own gun, so as long as they're serialized. And so that's just the skinny. And so please work with us to protect Marylanders, to keep these dangerous firearms out of the hands of children and violent criminals and sterilize them, and to protect our generations to come. So this won't cure all, but this at least will put a dent in the easily accessibility of these guns. Thank you for hearing my testimony, and I respectfully ask your favorable vote on SB 387, and I will entertain questions if you have them, or unless you want to hear from the other witnesses who actually deal with this on an everyday basis. Thank you, esteemed colleagues.
Thank you, Senator Lee. All right, Senator Carter has a question.
Mr. Chair, my question is short. I know we have a lot of witnesses, so I won't take up a lot of time. I appreciate the bill. I've read through the bill. I think it's generally a fair bill. I have but one question about the reason
it appears that accountability is the same under the law, making it a misdemeanor to violate this, whether one would be a dealer or seller versus a receiver. And I was just questioning the efficacy of that same level of accountability when in most areas of law, we look at someone that's a seller or a dealer of something, we hold them to a higher standard of accountability than a receiver or a possessor. So I wanted to know the rationale for that and if that's something that we could discuss, or is it fixed?
Are you saying that the penalty should be a greater penalty?
Who's Senator Carter?
We talked about earlier in the letter bill, the concept that someone selling in mass or a major profiteer versus, you know, a person who's maybe young, maybe one time, one part. That's not the same thing, in my mind.
Did you want to answer that? Yeah.
It's the only time you hear Senator Carter say that penalties should be higher.
The good news is, Senator Carter, this isn't alone among Maryland's criminal laws. So with respect to this law, if you sell 40 of these things illegally, you're subject to 120 years in prison. 3 years for each time you do it. There are other laws that also penalize the illegal possession and sale of firearms. So, there are 5-year penalties for knowingly possessing a stolen gun or stealing a gun, and a raft of others. I think this fits, reasonably well into the architecture of the criminal law that exists now, but obviously it's in your hands, and you can decide how hard you want to hit them. We think 3 years and a misdemeanor is appropriate. There may be situations in which somebody doesn't have to go to jail for something like this. But it's a very serious problem, and you're right to be concerned about levels of responsibility.
At least that'll make you a prohibited person. So. All right. Seeing no further questions from the committee, General Frost, Senator Lee, thank you both very much.
Thank you very much.
Excellent. Okay, next we'll bring up Congressman Brown, Mayor Scott. We've got Assistant Chief Hale, and then Richard Worley, if you all want to come on up. In that order.
Thank you, Mr. Chairman, and members of the Judicial Proceedings Committee. I'd like to thank you for giving me an opportunity to appear before you today, and I really want to thank the sponsor of the bill, Senator Lee, for introducing this. I have submitted written testimony to the committee, so instead of reading my written testimony, there are just 3 points that I'd like to highlight. As legislators, whether on Capitol Hill or in Annapolis or any state house around the country, we often bring to our work our personal experiences that motivate and inspire us to make a change and make it a difference. So why am I testifying about ghost guns? Perhaps it could because of what I read about the incident at Magruder High School, which certainly caught the attention of the state, or maybe the fact that in 2019 the ATF took 10,000 ghost guns off the streets, and that number is only increasing. But my experience was a little different. Ghost guns and banning them isn't just about keeping a lethal firearm that's assembled at home, perhaps, out of the hands of people that knowingly or intentionally or want to do violence. 3 years ago, my son bought a ghost gun. And I came home, and he was sort of proud of what he had purchased. And he showed me a box, and I said, "What is it?" And I looked at it, opened it up. I spent 30 years in the military working with small arms. And I looked at this, and it looked somewhat like plastic, synthetic, and I realized so quickly what it was. My son's a good boy, has no intention of doing harm to anyone, but he wasn't mature enough at that point to understand what he was buying. Had he kept it, he could have assembled it, and who knows what would have happened with that ghost gun. It motivated me to step up on Capitol Hill, and the second point I wanted to make is I'm co-sponsoring two bills on Capitol Hill to ban ghost guns. The truth of the matter is we probably won't get much done in Congress to ban ghost guns because I don't think we're going to get the majority that we need, particularly in the U.S. Senate, to make progress. The ATF, as Senator Lee mentioned, is promulgating a regulation to expand the definition of firearm to encompass firearms that are assembled from kits or generated through 3D. I think that's a good step forward. But if we're really going to make progress on gun safety, and this is my third and final point, Maryland has to do what it always does, which is lead. 10 years ago, right now, you or others who are here before you were debating gun safety regulations in the aftermath of Sandy Hook. Couldn't do anything on Capitol Hill. No other state around the country was able to do what Maryland did. We passed comprehensive background checks, required training and fingerprinting, banned assault weapons, large capacity magazines. Is every gun violent death or injury out there the result of an assault weapon? No, but taking them off the street certainly helped. Is every gun-related death in Maryland going to be associated with a ghost gun? No, but taking them off the street is going to save at least one life. So Maryland has demonstrated the ability to lead. I'm here today simply to weigh in strong support of SB 387 and the House companion HB 425 and urge you to adopt and pass this bill to make our streets safer. Thank you, Mr. Chairman.
Thank you very much, Mr. Congressman. All right, next, Mr. Mayor.
Good afternoon. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. As you know, I am Mayor Brandon Scott, here testifying in strong support of SB 387. First, I want to thank Senator Lee and Attorney General Frost for sponsoring this important bill. Ghost guns continue to be a huge challenge for Baltimore City, and I see this bill as a part of a multifaceted approach to get illegal guns and violent offenders off our streets. Over 300 ghost guns were seized in the city in 2021, and that represents 15% of all guns seized last year. Over the past 3 years, the numbers that we seized have been increasing each year, going from 30 in 2019 to 128 in 2020, and again over 300 last year. In just the first 28 days of this year, 2022, we seized 32 of them versus 17 last year. Last year, we partnered with HSI to take down a firearms trafficker in Baltimore who had the ability to create at least 40 of these unserialized weapons, and we knew he was going to sell them to violent criminals on our streets. But takedowns are simply not enough. We will continue to do them each and every day in partnership with the ATF and all of our law enforcement partners. But as long as people who are not legally allowed to possess a firearm, children, or non-violent offenders have the opportunity to obtain and build these in the comforts of their own home and use them as tools of death, we will continue to have a major challenge on our hands. This legislation, if passed, would help all Maryland jurisdictions deal with the increasing challenge and uses of these untraceable ghost guns in the commission of violent crimes. This bill, in my opinion, shows that we are serious about this issue as we work to limit the impact of ghost guns on violence. Statewide problems require statewide solutions, and we know that the majority of weapons are used in crimes in my city come from other places, and in our state come from other places, and we have to continue to press down on them. In conjunction with this legislation, we will continue to double down on all our other efforts. Firearms that do not have serial numbers and or registration have no place on our streets, and it should not be easier to purchase and build one of these ghost guns than it is for me to buy medicine at CVS. This is common sense legislation that demonstrates a commitment to keeping our residents safe by holding those who use these guns and build these guns and traffic these guns responsible. This is not about going after hobbyists or legal gun owners. I am proud to work with Attorney General Frost, Senator Lee, and everyone in the General Assembly to send a clear message that we are going to get ahead of the curve and be serious about ghost guns. And I stand ready for any questions. Thank you.
Excellent. All right, thank you very much, Mr. Mayor. Just a quick question. I know you mentioned some of the numbers from the past couple of years, but how many arrests have BPD made this year so far?
Gun arrests?
Yes.
Gun arrests this year, give me a second, 174, 35 in the last 7 days.
35 in the last 7 days.
Yes, sir.
It's incredible. Okay. Thank you very much. Mr.
Thank
Mayor.
you.
Next, we'll hear from I see our county executive from Montgomery County has arrived. Welcome. Good to see you in person. There you
Yes, it's nice. I'm 2 days down here now. It's really good seeing human beings again down here. And welcome the opportunity to testify today. For the record, I'm Mark Elrich, County Executive of Montgomery County. I want to thank Chair Smith, Vice Chair Waltstreicher, Senator Lee, and the other members of this committee for giving us the opportunity, giving me the opportunity to speak briefly today. We know that gun violence in America is a public health issue, and like our pandemic response, we have to take action if we're going to get this under control. I applaud Maryland Attorney General Brian Frost for his pledge to have ghost guns banned in 2022. I want to recognize Senator Lee for her tireless commitment to advocating for strong legislation. In my effort to explore this issue, I went on a bunch of gun sites. I now regularly get email telling me how to buy a ghost gun, showing me the exploded diagrams. I can get the videos on how to put it together. I have special assembly equipment. If I want to get it, I can buy things that help do that. They've got 3D printing instructions online and polymers they'll sell you to work with your 3D printer to build these guns. They advertise all the things you could have done wrong that would keep you from getting a gun, and then say, but it doesn't apply to the building of the gun. This is ridiculous. This is why your effort here is important. It is too easy for a kid to go online where it says how old you are, just put whatever age you feel like in there, and proceed through the process. The fact is that if somebody has a thrill out of assembling a gun, there's no reason that you don't require the kids to be sent to a licensed firearm dealer, like a gun is sent to a licensed firearm dealer, where they'll look for your identification. They'll make sure you've got a fire gun and a handgun license in the state of Maryland. So if you want the thrill of building them, you don't have to buy them clandestinely. You shouldn't have to go through these places that'll sell them to anybody. So if you're a hobbyist, there's a way to accommodate hobbyists. But these guns, let's face it, they're not a problem because of hobbyists. They're a problem because of who these guns are going to. And we've got to put a stop on it. It doesn't keep you from getting it. It just says if you want to get it, you should get it. If you're going to get it anyway, you should get it legally. And this is a plague. We've got, I think, 5 already in the county. This is, it's not Baltimore, but it's coming up. And I think as kids hear about this and they see how easy it is, the role models who have these guns and get them are going to set the standard for other kids to get the gun. If you realize you're not going to get in trouble trying to buy this, then you're looking at people who are going to be able to get a hold of it. And if I really want to be secretive, I can take my cash, I can turn it into Bitcoin, and I can do my purchase with Bitcoin and maintain an amazing amount of anonymity. So I urge you to please pass this bill, pass it soon. I know there are people who don't like it. Nobody's rights are infringed at the end of the day. Nobody's gun rights are lost. Our right to be protected, and as a public elected official, my obligation to protect the residents of my community would be better served if this legislation is passed. So thank you very much.
Thank you very much. All right. Next, we'll hear Assistant Chief. Thank you.
Good afternoon.
Good afternoon.
Vernon Hale, Assistant Chief, Prince George's County. Please allow me to take a moment to speak against guns with no serial numbers, also known as ghost guns. The appetite for ghost guns has grown exponentially in my county over the last 5 years. We've experienced an increase in recoveries and violence associated with those weapons year after year. Our records indicate, as an example, 2016, 1 ghost gun recovered. 2018, 17 ghost guns recovered. 2020, 164 ghost guns recovered. 2021, 264 ghost guns recovered. 2022, year-to-date, 43 ghost guns recovered. Since 2019, we've identified at least 13 homicides, 10 robberies, and over 20 aggravated assaults associated with ghost guns alone. Many of these individuals were young people, children with guns. Juveniles are increasingly acquiring and possessing these weapons. Just in the past few weeks, this year alone, we've arrested 4 individuals for drug possession. One of those arrestees was in possession of a Polymer 18 ghost gun. Another arrestee apprehended in a stolen vehicle and in his possession a Polymer 18 ghost gun. We conduct a search warrant at a drug dealing location and yielded yet another ghost gun. Traceability. Traceability continues to be an important part of our collective fight against such weapons. One of the main factors ghost guns impacting crime is that ghost gun parts and kits can be ordered online without a criminal history check or even an ID. This gives an individual who has been convicted of a crime or is prohibited from possessing a firearm an alternative means of acquiring these weapons. Technically, possession of the ghost gun kit is not a crime unless it is fully converted into a functioning firearm. Ghost guns are not serialized, therefore not traceable, adding to the already large volume of gun cases being processed and investigated in our county. Tracing allows law enforcement to identify those responsible for tracking firearms within our state and coming from other states. Sometimes they lead to tracing back to linking various crimes together. We support legislation that seeks to make this state safe, our county safe, and our municipalities safe. Thank you for allowing us to be the voice of law enforcement and the victims of these violent crimes committed with ghost guns. I think it's also important to say that this year alone, we've arrested 5 juveniles with ghost guns already. 2 of those were violent crimes, 1 a fatal shooting, 1 a carjacking. So it's exponentially going, and these are young people getting them as well. Any questions from me?
Excellent. Thank you very much, Assistant Chief. And we have, I think, 2 questions. I saw Senator Sidnor and then Senator Castley.
Thank you. Actually, this question is for the congressman. See if maybe he can help me. So on page 5 of the legislation, and I'll read this to you. It says, a person may not purchase, receive, sell, offer to sell, or transfer an unfinished frame or receiver unless it is required by federal law to be and has been imprinted with a serial number by a federally licensed firearms manufacturer or federally licensed firearms importer in compliance with all federal laws and regulations applicable to the manufacture and import of firearms. The question I had is that unless it is required by federal law to be, does federal law already require an imprint with a serial number by a federally licensed manufacturer? Or do you know?
No, I can't speak to that. What I can do is just reiterate the point that Senator Lee mentioned, which is ATF is going to promulgate a rule to expand the definition of firearm to include these assembly kits, and then that may very well then meet the requirements of the bill. But I would certainly suggest that you and your staff look at federal law to make sure that what you're passing is not contingent upon something coming out of Congress.
And that's what I'm trying to figure out, because it would put this bill in 2 different postures. If it's contingent, then that means that it's an outright ban. If it's not contingent and this is already there, then it's not a ban, but really just a bill saying that all weapons need to have serial numbers. At least that's my read. So thank you.
Okay.
Senator, so if it comes from an FFL, then it has to be serialized. If you're making this at home and you get it from a private enterprise, private company, you don't have to serialize it right now. The ATF is promulgating reg. It's going like the notice and comment period right now.
Right.
Yeah.
So this is just a serialization type.
Correct. Yeah, effective, what, 2023 or something, January 1st, 2023. Right. Senator Castley.
Question really to either of you gentlemen. I appreciate you both sticking around to answer questions, Congressman Chief. I mean, I realize the mayor and the county executive are busy folks. They spoke and ran, but you guys, so you're here. We appreciate that. So we had a fascinating discussion before this bill on the size of the crowds that we get in bills. And it was interesting that we had the governor's crime bill was in here about 3 bills or so ago, and I think there was 2 people in the audience. And now we have this one here is pretty crowded. You can see out there the attendance. So obviously there's some will here behind this one. But you know, as I look at ghost guns, they're equally available. I mean, they come in the mail, as the congressman testified. He can live anywhere in the state, and yet we're seeing violence peaking in certain areas. Your county, Mr. Chief. Baltimore City, the mayor's county, it's peaking there, which would lead you to say, well, it's not just the ghost guns. Ghost guns might be a problem, but that's not the overwhelming problem. And we've had year after year where senior law enforcement advisors have come in and told us the main problem is that there's a lack of consequences for bad behavior, and that's the problem with, that's causing the proliferation of crime. And then I stated earlier today that 48% of the known homicide suspects in Baltimore have prior violent crime arrests, and 42% have faced previous gun charges. And it just seems like that is the root of the problem, that if you take those folks out of the equation, there is no problem anymore. Your crime is at a manageable level. So I'm trying to understand, and the Congressman, your testimony was very riveting, that your son, I don't know how old he was, but I assume he's old enough to order online and probably use a credit card, but that, certainly that raises some levels of concern, right? But here we are in this crime epidemic, and we're trying to focus at least some of our efforts on really addressing what is it we got to do this year to drive these murder rates down that we're talking about, and yet the attention's on that we're seeing right now is on ghost guns. It's not on the holding people responsible for criminal behavior, existing crimes. So maybe you can just help me understand why this is the vehicle of choice here, because clearly by the support we're seeing with the Attorney General, Congressman, Mayor, Police Chief, that why you all view this as the vehicle to try to drive down the murder rate in this state, particularly in the urban jurisdictions, because it's really not going up in the outlying areas. Crime is pretty holding still, so. Thank you.
I'll speak to that. I mean, look, I've always looked at public safety, and part of that is driving down violent crime. It's like a puzzle. There are a lot of different pieces that you've got to put together to create that puzzle, that image of the level of safety that we want to achieve in a community. And I was testifying on Monday in the House Judiciary Committee about the legalization of cannabis. That contributes to many things: public safety, equity, economic development as you're generating revenues and investing in disadvantaged communities. That's going to help drive down crime as well. There are a lot of things that the General Assembly works on from time to time. I wouldn't necessarily say that ghost guns should be considered at the exclusion of anything else. It's just something that right now, for many of us, where there's an alarming concern because of the rate of increase. And while it may be a smaller percentage of the firearms that are in the community, on the streets, causing death and harm, it's a growing number. And it makes sense to, proverbial nip it at the bud. So I wouldn't let the number of people testifying be an indication of what's important and what's not important, but this is certainly an important issue.
From a law enforcement perspective, I'm sure you saw the press conference with Chief Aziz, who I'm here representing, and Chief Conti, and the county executive and the mayor, us in D.C., and all the stakeholders, the state attorney's offices, the attorney generals. This is not the only tool we're looking at. We're looking at accountability, which was the primary focus of that press conference, was accountability. I think this is one of those tools. The folks buying these guns and selling these unserialized weapons are not being held accountable. So this is all about accountability from a law enforcement perspective. And if I can't trace those guns, how do I get the numbers you're asking for? Because I can't trace them. And so if you want me to get the totality of it, I got to be able to trace the gun once it comes in. And so that's the entire intent, is all about accountability.
I understand. I mean, I just thought the governor's bill seemed like about personal accountability too, that hold people responsible for the crimes, but didn't seem to have the support. I'm just curious why, but I understand what you're saying.
Yes,
Thank
sir.
you. Thank you, Chief.
We'll go to Senator West and then Senator Watson.
Thank you, Mr. President. I want to pick up on what Senator Sidner was saying a few minutes ago. I've been reading this bill, and it repeatedly talks about required by federal law, in compliance with all federal laws and regulations. And I assumed that the federal law was in place and the regulations were in place, but based on Senator Sidner's questions, I now have a question about the federal law and the regulations which this bill relies on are in effect. Do you all know whether or not the laws, federal laws and federal regulations that this bill is contingent upon are in effect right now? Or if they're not in effect, do we have any assurance that they will be in effect by January 1st, 2023?
I see the signaling that the Attorney General wants to get in on this, but.
Oh, that'd be great.
Absolutely.
Welcome.
He did
Brave,
run from.
brave general indeed.
The congressman is saved by the bill.
It's a good question, Senator West. It's confusing perhaps, but if you look at it carefully, what it says
Wait a minute.
is that
Can we hear
unless
him?
it's permitted by federal law.
You're really low. Could you
Yeah,
move
I'm
the microphone
sorry.
closer?
Yeah,
It's the man, okay, I know.
sorry.
Sorry.
The language that you're referring to is confusing, but if you look at it, what it's saying is unless there's a federal law that says that you're required to put a serial number on it, you can't get one of these in Maryland. Okay? So if there's no federal law, you can't buy an unserialized weapon in Maryland.
Okay, well, what about the part of the bill that says on or after January 1, 2023, a person may not possess a firearm unless, and then you have the same federal laws referred to. Would that, if the federal laws have not been adopted, would that criminalize anyone in Maryland who has such a
Yes.
device after January 1,
Yes.
2023?
So you can't own one unless there is a federal law that says it has to be imprinted, et cetera. So, I mean, if there's a federal law, maybe we won't need this. But if there's no federal law, we certainly will. And it's phrased awkwardly. The unless is confusing. But I think that it's clear once you read it 10 times that, it's saying no federal law, no unserialized guns are allowed.
Got it. Thank you very much. That clarifies that. Appreciate it.
Thank you.
Don't go too far.
Yes, I'm online researching ghost gun parts, and I just had a question. So the bill is very, very specific on an unfinished frame or receiver. And so I just want to make sure if I got a ghost gun kit and I had a ghost gun manufacturing ring where each person just held, a plethora of one component, this bill would ensure that no matter how many people parts of this were dispersed, no one person could have an unfinished frame or receiver. Is that correct? Okay, thank you.
All right, looking to the committee for further questions, seeing none. Thank you to the panelists, Congressman, Assistant Chief.
Thank you, Mr. Chairman, members of the
Thank
committee.
you all. Always good to see you all. Excellent. All right, next we'll hear from, is Mr. Worley here? Yes. Okay, sorry, we called you up early, sorry. Come on up. And then is State's Attorney McCarthy here? Excellent. Welcome.
Thank you. Good afternoon, Chairman Smith, Vice Chair Waldstreicher, members of the committee. Thank you for allowing me to testify today in favor of SB 387 today to urge the adoption of the bill to help with the devastating impact of these weapons have had on the violence we've experienced in Baltimore City. Over the last few years, Baltimore has seen a frightening increase in the amount of ghost guns that we've recovered. In 2018, we recovered 12 ghost guns. In 2021, we recovered 345. That's a 2,775% increase in the amount of ghost guns recovered in the city. Unfortunately, this dangerous trend has continued into 2022 as we recovered, as of today, 51 privately made firearms as opposed to 19 of those such weapons last year. At least 13 guns recovered this year were in the possession of convicted felons. 17 of the ghost guns recovered this year were possessed along with CDS, and 4 of the recovered ghost guns have been connected directly to violence through a knife hit. We could tell stories forever about these weapons, but last year we had a 17-year-old who fled from officers with a polymer 89mm gun in his backpack that was along with a CDS. He's not even old enough to even purchase a weapon. We also had a 20-year-old who was developing and displaying characteristics of an armed person. Officers went to investigate. He took off running. We chased him, ended up getting him with a polymer 80 handgun. Due to the lack of regulation of these ghost guns, we've seen a great increase. I was born and raised in Baltimore. I've been a police officer in Baltimore for 23 years. I've never seen so many guns on the streets of Baltimore as I've seen over this last 6 or 8 months. And we've even talked to some of my officers out on the street, and they're like, almost everybody they stop has a weapon of some sort. And it's not usually a ghost gun, but about 25% of the guns we're recovering now are ghost guns because they're so easily accessible. So with that, I just urge you in favor of Bill SB 387. Thank you.
Thank you very much. Thank you. And we'll take questions at the end. When all
Okay.
three-
Yes,
And,
sir.
Councilman, if you can come, please join the panel as well. Yes, please. Thank you.
Thank you.
Good afternoon. My name is John McCarthy, and I'm the State's Attorney for Montgomery County, Maryland. I'm here in strong support of Senate Bill 387, but perhaps more importantly, and this, I think this does go to Senator Cassidy's questions, because I'm also here representing the State's Attorneys Association for Maryland. And I stand here to tell you that unanimously, every state's attorney, whatever county you are from, the county or jurisdiction that you're from, your state's attorney is in favor of this bill because of issues that they have identified in their community. This is not a bill that is dividing anyone who does what I do anywhere in the state about the need for this bill to pass. This is not a controversial bill. I do salute Senator Lee, who just walked out of here, and the former Attorney General. Look, I've been here on these gun bills going back to 2013, and there's some moms who are demanding action that are sitting behind me that were here back in 2013 as well. If we do not pass this bill, I think we're going to render what was done by Jamie Raskin and Brian Frosch back in 2013 moot, because we're going to take the teeth out of those gun safety laws that were passed years ago that was designed to make people in Maryland safer. I see that there's 4 primary reasons to support this bill. One, I think that it is unquestionably contributing to the rise in violent crimes throughout this state. There is an increase, undisputably, in the number of prohibited persons possessing handguns because of this. Children are buying these guns. Look, I think the most poignant thing I heard here today was Congressman Brown's story, which points to the fact that children can buy these guns. And from experiences I have in Montgomery County, I can tell you they can build them and they can use them. Look, if you have a PayPal account, a credit card, gift cards, you can go online and buy this gun without even telling them your age, such that the first person who committed a murder in my jurisdiction with a ghost gun was 14 years old. There were 3 guns. We don't have the same numbers as some of the other jurisdictions, but I can tell you in my county, in 2 years, we've gone up 5-fold. I can tell you that the first murder that was identified in my county with a ghost gun was committed by a 14-year-old boy who bought it, built it, and then used it he tried to kill 4 people. He was successful once. It happened on a basketball court. I think this bill makes common sense. It's needed and has uniform support from my colleagues around the state. Just this week, we've had 3 more guns seized off the streets of Montgomery County in the last 2 days. All ghost guns, all possessed by children under the age of 18. This bill is desperately needed. I think COVID's played a part in this. Kids are on the computers. They're learning how this is done. They live their lives on the computer, and they're spreading information to each other, and that is spreading the word. And it was mentioned by somebody else. I think it might have been Brian Frosch. We're not at the top of this hill. We're still going up. And next year, if we come back and this is not dealt with, we're going to be talking about bigger numbers again. There's absolutely no question about it. Thank you.
Good afternoon. Thank you, Chair Smith and Judiciary Committee, for giving me the opportunity to talk on behalf of Senate Bill 387 on traceable firearms. My name is Mark Conway. I am the chair of the Public Safety and Government Operations Committee on the Baltimore City Council. As many folks before have already told you, this is a very important bill in the control of guns. Baltimore in particular, as you are under no surprise fully aware, is going through a very violent pandemic as we speak.
We have had over 330 murders in the last year, and have had over 300 murders for a number of years. Of course, guns play a significant role in an ability for someone to kill someone else. In Baltimore, guns are the primary tool of choice for homicides. In my district and across the state, we see the trickle down of the gun violence epidemic in our communities, in our schools, and in our businesses. I think particularly the testimony of Attorney General Frosch and Congressman Brown alluding to the ease of young people being able to get these guns in particular, I think is a very important consideration. Just this week, two teenagers were shot, one of them killed. With less regulation, we're going to continue to find this problem snowballing. As Colonel Worley just alluded to, the police department is seeing a significant and alarming rise in the acquisition of ghost guns from gun arrests, such that we've seen a 2,775% increase in ghost guns recovered and seized from 2018 to 2021. I don't need to belabor the point, but I think it's incredibly important that we take those things into consideration. I urge you to support Bill 387. Thank you.
Excellent. Thank you very much, Mr. Council Member. So we've got a couple questions. I saw Senator Huff, and then Senator Bailey, then Senator Castley, then Senator Watson, then Senator Zidmore. Christmas tree today. All right, Senator Huff.
I have a question first for State's Attorney McCarthy. So I saw the story, too, about Magruder High School. I guess my question was, is there a state or federal law that prohibits them? I know you said they're getting around it apparently online, but is there a state or federal law that would prohibit them from ordering these parts? Because that's what my first reaction was.
I don't think, well, if you went online, Senator, to buy this gun, the person, or did it online, no one asks you your age. They just want to make sure that you have the ability to pay for it. That's the only thing. Do you have the money to pay for it? That's the only, does your credit card go through? I'm not aware of there any federal law right now that exists that makes it illegal for them to ship the gun to someone in Maryland. I will say it is illegal for someone under certain ages. They're prohibited. By age, we prohibit people from legally possessing firearms, but because they're not going through the background checks, we don't trigger that.
So I guess my question was, because I thought the way, obviously, because they order the pieces, and then they can assemble them. And so if they order these pieces, I guess my question was, if you're, a minor underage, I mean, a handgun, you're not even allowed to possess till you're 21. So if you're underage, are you allowed to be ordering these parts? I just didn't know the answer to that.
Theoretically, I guess theoretically, I'd say ordering the parts is probably legal. Once you assemble the gun and now are in possession of the handgun, then it becomes, I guess now it's illegal. You put it together and now it's a handgun and you're underage. Your possession of it, once assembled, would be illegal. Ordering the part would not be illegal.
Okay. And I a question for the Colonel, and thank you, because today is Gun Day, and we've been having all these discussions on gun statistics and everything all day, trying to figure out, we've had a number of bills. So it was interesting to me, though, so you said 25% of what you are apprehending right now, or you're getting on the streets, are ghost guns. So the remaining 75% are what?
They're just most of them are, well, I shouldn't say most of them, several of them were stolen. Some of them they're in possession of people who have a right to have them, and just used them in commission of a crime, or they were carrying them on the street. But for the most part, when we catch someone on the street and they're in possession of a weapon, it's not their weapon.
That's what I figured. I mean, that's sort of been, and that was what, it's helpful to know that, because that's what a number of the other bills that we were getting at today were, the stolen ones, and then people who are not supposed to be in possession of them. They didn't legally obtain them, and that's what you're finding a lot on the street too. So
Yes.
that's helpful to know. And just lastly, are these ghost guns, a lot of the opponents that'll come in today, at least you had in the past, are people that are building rifles. What are you encountering on the street, though? Is it you're encountering handguns, you're encountering rifles? What are you
The
seeing?
majority are handguns. There are some AR-15s that we've encountered, and what happens is when you get to a question that you brought up, you get all the parts together, and when you put them together, I was told when you put the weapons together, it still won't operable. You actually have to drill you have to manipulate, you have to drill, but you can do it relatively easy. So when you get the pieces, it's not like if you put a puzzle together, it automatically start working. You have to use a drill to drill down on some of these, basically to drill a couple holes, and then you've got a fully functioning handgun.
Okay, and so I guess on the instances like the Magruder and the others, these kids were able to figure out and do that on their own?
I'm sure there's something on YouTube that shows you how to do,
Yeah, and that's
just about anything.
Yeah, that's the problem we've had too, is you can't ban that kind of stuff. We've run into that in the past. All right, well, thank you. Thank you for answering.
Thank you, Mr. Chairman. Mr. State's Attorney McCarthy, could I ask you a question?
Yes, sir.
So in reading in the bill, it's talking about the unfinished frame or receiver, that even if it's unfinished, right, what I heard is that is then illegal if you have possession of an unfinished.
Right, possession of an unfinished frame standing alone, not assembled, are you talking about putting the two parts together?
Unassembled.
Unassembled, that would not be illegal.
The Attorney General just answered that question, and he did not answer that the same way.
Maybe I'm misunderstanding. Are you talking about under current law or under this bill?
I'm talking about this bill.
Oh, under the bill, it would be illegal under the bill. I apologize. I think I'm going back to the prior question.
Okay. And that's where I've got a big question. I mean, I was a armorer for years. Some of my best friends worked at Beretta. We could take a block of metal and in a matter of minutes make a frame. A lot of those people have those same machines at their house. So if that's the case, right, if you have a block of metal that looks like a frame, right, what requirements are we going to put in here that says, oh, whoa, you have a block of metal that a frame could be machined out of? Right, I see nothing in this bill that says there's something, if it's finished and it has to have a serial number, that's different. But the way I read this, it says when it reaches a stage in manufacture where it may be completed or assembled or converted to be used as the frame receiver of a functional firearm. So they still have to do some form of work with it, right? They still have to machine it.
Yes.
So that's my question. Where do we go from the simple block of metal that a frame would fit into that to be illegal?
Well, I think the primary bill is directed towards the distributors of these guns who are multiplying in number. The vast majority, and I think there are thousands of these guns that came in to Maryland last year. I think the bill is designed to stop the flow. You're talking about an individual who has.
So I'm not disagreeing with, what I'm saying is, if if that's the intent, then that should be the wording in the bill, right?
Again, I would yield to potentially the senator. Again, I think the idea is to stop the flow from the manufacturers who are shipping these things into the homes of children and prohibited persons. Not people who have individual skill sets where they can basically build their own guns themselves.
But the thing that we do here in the Senate, right, and that's very important, we want to protect people, but we don't want to criminalize people that are not criminals, right? We don't want to criminalize them. And so we have to make sure that we hear this all the time, right? So cuts both ways. Thank you.
Okay, thank you.
Senator Watson.
Just to follow up. Sorry about that. Just to follow up. So currently, under federal law, you can mill and assemble a firearm from scratch or a kit that has no serial number for your personal use and personal use only. Is that true?
Yes.
Under current law, right? Okay.
I think you can It is not illegal to order one of these guns currently under current law. That's correct.
Okay. And this bill says that if you order one, even if you have it for personal use in the home, not carrying it outside the home, but for home protection, it still has to be serialized.
Yes, there's no distinction for that in the bill.
And just to clarify one more time, just to make sure I got the answer I was looking for, out of all the components of a ghost gun, having by itself standalone, without being assembled at all, an unfinished frame or receiver, that is illegal based on this bill, correct? Is that right, Senator Lee?
That are not serialized.
That are not serialized,
Yeah,
got it. Got it.
One of the parts of the bill that I didn't speak to is the fact that the serial number being on these parts that will then allow the police to trace it the way they can trace a conventional weapon during a typical police investigation is absolutely essential to effective police work and the solving of many crimes. And the lack of the serial numbers, which if you go back to the manufacturer, who did you sell this particular gun to, there'll be a way for us to know that it was sold to John McCarthy or Senator Ron Watson.
Got it.
Bought this gun.
So one more question for you, Chief. So I'm just curious that if we got folks who can go online, get the components of this, put it together, what would it take for me, what do I need to show to go out and get ammunition for one of these?
I don't think you need to show anything. You just walk into just about any store and purchase ammunition.
So there's no age requirement?
I believe it's 21 still.
21.
You have to be old enough to purchase ammunition.
So anybody off the street can just show any driver's license, show at age of 21 and get ammunition. Is that fair? And the reason I asked is because I was working with Delegate Lopez, and we had bounced around the idea of, doesn't matter how many ghost guns you got, if there's no ammo, you really have gotten rid of the threat. But would it be an overreach if you started putting some additional criteria on the purchase of ammo, right? So I have my wear carry, I got online, purchased some ammo, boom, it's sitting on my doorstep. Not to say somebody couldn't have come and taken it, but it's too easy to get. And I'd be curious, I'm sure we'll pass this bill and put this in place, but if the metrics doesn't show that we're really making a dent, we're going to have to look at some more draconian measures on this thing. And I want folks to, be prepared to have those hard conversations, because there was a lot of pushback just to have that conversation a year ago.
Yes, sir.
Thank you.
Thank you very much. The question that I have goes back to that same paragraph on page 5. Now, of course, maybe you could help me. The prohibition is against the purchase, receipt, the sale, the offer to sell, and the transfer. But I'm curious of the guns that you've recovered, or that you've heard that other jurisdictions have recovered. Was there ever someone that was caught creating one of these guns? Because again, you have the equipment that's there, and I'm seeing that as something that doesn't seem to be covered by this bill.
We have had, we actually did have an individual who we arrested, prosecuted, who became a gun manufacturer in Silver Spring. And he was operating out of a car repair shop, and he was manufacturing AR-15s and handguns, and he was selling them largely to prohibited persons out of a garage that was located in the Four Corners section of Silver Spring. So, yes, we have had manufacturers making ghost guns, specifically targeting and distributing them to individuals that otherwise would have been prohibited. We have successfully prosecuted that type of case.
Okay, because I was about to ask if that person wasn't selling them and he was just maybe making them for his or her own personal use. Would the language under this bill be sufficient to
Are
prosecute?
you talking about now or after the bill is passed?
After this bill, after this language, after this bill is passed?
I would defer,
Since the regulations are now being developed to define what a firearm is and to include those unfinished frames and receivers that can be readily converted to a firearm, you would, even if you have it at home and you built it yourself, you still have to get a serial number put on the firearm or on the frame or receiver under this bill.
But again, my question is about the creation of them. Correct, for yourself.
This does not prohibit you from assembling a gun yourself like a hobbyist, but you still, under this law, have to go and get a serial number put on it.
Thank you, Mr. Chair. I've got a couple of questions. So the state's attorney indicated that he believes all the state's attorneys support this bill. Does anyone up there on the witness panel have any knowledge where the fraternal orders of police stand on this, either county by county or statewide?
I can speak for my county. And in Montgomery County, I have the full support of the police departments in Montgomery County. I cannot speak for the different police agencies around the state.
I wonder if the
can speak
police-
on behalf of my brother state's attorneys. They all support this bill.
I wonder if the police chief up there knows where the fraternal orders of police stand on this.
I believe I'm not 100% sure, but I believe he's in support of it because it's officer safety for our officers. Just the fact that we're basically encountering these guns all the time on the street.
Okay.
So I haven't spoke directly to Mr. Mancuso, but.
Let me come to my other area that I want to ask about, and that is there's a lot of opposition here, much of it coming from people who have hobbies in the basement of their houses and they make guns. So let me ask the state's attorney first. You're a good lawyer. Do you think if you put your mind to it, you could draft an amendment to this bill which would protect folks who have workshops in the basement where they make these guns from scratch? They don't buy them on the line, they just make them from scratch.
When I read this bill, Senator, I never saw this bill as prohibiting people from continuing to be a hobbyist. I didn't read this bill in criminalizing people who wanted to continue to have that hobby.
Well, it does unless they can put a serial number on it, right?
Well, they would have to abide, they would sit, if I wanted to buy a kit and put it together with my grandson down in the basement, because that's the hobby I'm engaged in, I'd have to comply with the law. I would buy it from a company that would sell me, the parts would be serialized when I got it, and there'd have to be a background check to make sure that I was an eligible person to receive that, and then I can still possess it. We're not barring the person obtaining the parts.
Okay.
They
But
just have to do it consistent with the
if I'm a
statute.
hobbyist and I make the gun from scratch in the basement, how would I go about trying to get a serial number?
I think, Senator, I think that there was a,
Hold on.
You can go to an FFL and get it serialized, put on, or an entity designated by the federal regulations authorizing that particular entity that's authorized to put serial numbers on firearms.
Is that expensive or time-consuming? Does it done quickly and cheaply?
I think the fair market value will rule. You know, I think this might become a service that is provided, and whoever provides the best deal, the market rules.
Thank you.
I guess I'll get back to the sponsor, because I've not seen something drafted this way, and that's why I'm curious. Is a person may not purchase, receive, sell, offer to sell, or transfer a unfinished frame or receiver unless it is required by federal law to be and has been imprinted with serial number. So right now, it's not required by federal law to have a serial number, correct?
What constitutes a firearm where you would have to have a serial number or a background check? So they're defining it as a unfinished receiver or frame that can be readily converted into a functional firearm. And then you have to get.
But as of right now, we're talking about prospective regulations. I don't know where they are in the process. And I know there's a whole comment period. It may take a while. And it strikes me as it's odd that we have legislation that is saying as required by the federal government, but right now the federal government doesn't require it. We're thinking hypothetically they will. So is this law and this requirement, is this all hinging on a prospective federal regulation that may or may not happen?
Regulations will be finalized by June of 2022. And then that will enable us to, the Maryland law will enable us to enforce the federal law.
Well, the federal government doesn't need us to enforce the law. I mean, they have a federal law. Here ever, maybe there's another time where we've based a law that we're going to pass here on a prospective federal regulation. Something happened similar with the rapid fire triggers, but what the federal regulation basically, I thought that just superseded what we did here, was my understanding.
So the way that it reads, and maybe someone knows this because I don't know this, but can FFLs right now do this? Can they legally can they serialize weapons? If I brought my M9 to an FFL on Spring Street, could they create it? Can they do that? That's what it turns on. Because if not, then you are indeed probably waiting for the federal regs to come into place.
Or it's like a ghost law.
His response was that basically, yeah, these would be outlawed until those regulations come into effect. And if they don't come into effect, then it remains outlawed. This was sort of a...
That was my question.
You weren't here when the Attorney General testified, but I think he was pretty candid on that this would outlaw it for now until those regulations go into effect. If they don't come into effect, it stays outlawed.
That's my understanding, and that's what it says, is that it's hinging on these federal regulations, in which these federal regulations don't exist. Okay?
All right. Seeing no additional questions from the committee, thank you all very much. Thank you.
Thank you.
Yeah, I'll stop doing it, yeah. All right, so we'll hear from Mr. Benjamin. Mr. Paler. Mary Pat Lowe. Yes. Yes. And is Ms. McGrath here? We'll start with one more, do four at a time. All right, welcome.
Thank you. And good afternoon. I am Peter Benjamin. I live in Garrett Park, which is in District 18, which is Vice Chair Waldstreicher's district. I'm a volunteer with the Montgomery County Local Group of the Maryland chapter of Moms Demand Action. In past years, you've heard testimony about the exponential growth in the use of ghost guns. Police have now reported that that pattern is verified, and you heard testimony to that effect, and testimony that says the previous estimates might have been understated. Ghost guns are used by those who are ineligible to buy a gun, including children, and they're easily available as kits on the web or from others who've purchased them on the web and built them. A teen who is angry at another teen can get a ghost gun to settle a score. Someone who would not pass a background check can purchase and build a ghost gun. A person can create a plastic gun with a 3D printer and bring it undetected into a legislative hearing into a school or onto an airplane. I support SB 387 because Maryland has set up a strong set of protections to ensure that guns are only sold to those eligible to have one, and ghost guns undermine that system. I urge a favorable report on SB 387 to make it illegal to purchase, receive, sell, or possess a ghost gun. Thank you for giving me the opportunity to talk to you.
Chairman Smith, Vice Chairman Wallstricker, good afternoon. Thank you for giving me the opportunity to address the committee today. My name is Perry Paler. I'm the Deputy State's Attorney for Prince George's County. I also serve as Chief of the Guns and Drugs Unit. The Prince George's County Police Department has noted a steady increase in the proliferation of ghost guns over the last 2 years. Because the receivers are not serialized, these guns, as currently configured, cannot be traced. This facilitates these guns falling into possession of persons who are prohibited and cannot legally possess a handgun. In 2019, 27 ghost guns were recovered from Prince George's County. In 2020, 164 ghost guns, and sadly in 2021, that number escalated to 264 ghost guns. Passage of this bill would create a legal requirement that unfinished receivers in Maryland have the same serialization requirement as if it was a finished receiver. This would greatly assist law enforcement in preventing prohibited persons from possessing firearms. The State's Attorney for Prince George's County requests a favorable report for SB 387. Thank you.
Hello, my name is Mary Pat Lowe. I live in Westminster in District 5, and I am a volunteer with the Carroll County Local Group of the Maryland chapter of Moms Demand Action. I am a retired Defense Department employee and a mother of 2 adult daughters. I support SB 387 because ghost guns threaten our public safety, thwart law enforcement investigations, and allow criminals to bypass Maryland's strong gun laws. Ghost guns are becoming the weapon of choice for violent criminals, extremists, and gun traffickers. This bill will address current gaps in federal law that have allowed for the proliferation of these dangerous DIY guns and harmonize Maryland law with pending ATF regulations. Thank you for your time.
Good evening. My name is Amy Yontoff McGrath, and I live in North Potomac, District 15. I'm an active volunteer with Maryland Moms Demand Action and serve as the chapter's student liaison, working with high school students across the state. Ghost guns pose a unique danger to students, making this bill incredibly important to them. And because they were due in school today, they sent me to share their voices in strong support of this bill. Boo Salami from Glen Burnie says, easy access to ghost guns cause terror in the community, knowing that just anyone can get a gun and pose a danger to our neighborhood. J.K. from Baltimore, who knows ghost guns are on the rise, adds, if youth get their hands on ghost guns, common disputes will be resolved with deadly guns. And just how easy is it to acquire a gun, you might ask? Well, the students will tell you. AJ in Silver Spring reveals, one day in class, I saw another student purchase pieces for a ghost gun on the computer in front of me. Until then, I never realized how close I could be to such a scary thing. So it's no surprise that there's so many ghost guns that have made their way onto school grounds just this year. In Howard County, in Baltimore County, and 5 so far in Montgomery County. Fiona of Gaithersburg pleads, students deserve to feel safe while attending school, but the frequency of shootings with ghost guns, such as the one at Magruder, prevents this from becoming a reality. Kashana in Baltimore seeks assurances that people will go through the right channels to get guns. And Lily from Bethesda insists that students deserve common sense gun legislation, which includes banning ghost guns. Students have waited 4 years for a bill like this to pass. 4 years is an entire high school career. It's so much of their childhood. On behalf of these students and 1,200 others belonging to Students Demand Action, I implore you to act now and pass this bill. Thank you.
Excellent, thank you very much, and seeing no questions, thank you all for your testimony. All right, next we'll hear from is Karen Herron. Nicole Hollywood. Is Ms. Shapiro here? Ms. Shapiro still here? And is Ms. Cyphers here? Ms. Shapiro, there you are. Is Maura out there? There you are. Hey. Hey, no worries, no worries. Please, thank you. Welcome.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and distinguished members of the committee. I am Karen Herron, Legislative Director for Marylanders to Prevent Gun Violence. MPGV urges a favorable report on SB 387 to ban ghost guns in the state of Maryland. As others on the panels have and are testifying, the numbers of ghost guns turning up in crimes and investigations around the state have skyrocketed. I would like to highlight one of the most concerning elements of the ghost gun problem, that these guns are too easily accessible to those who are too young to otherwise acquire a gun. Together, with poor storage of firearms, way too many guns are making their way into the hands of young people. A 14-year-old Maryland boy, armed with an untraceable gun, opened fire on an outdoor basketball court in August of 21, killing one young man while he shielded his young siblings and wounding 3 teenagers. In September of 21, a Chesapeake High School student in Essex was apprehended for bringing a 9mm ghost gun to school. And in January, a 17-year-old shot and injured a 15-year-old student at Magruder High School in Montgomery County. The shooter managed to hide in plain sight with the disassembled gun in his backpack for hours until SWAT tracked him down. Subsequent investigations determined that the teen purchased components online that were delivered right to his home. Mental and behavioral health experts are highlighting the alarming state of youth mental health and begging for officials to take more action to provide resources and to help youth and to take steps to reduce youth access to guns. It makes no sense for us to have a system of laws designed to make sure that guns are kept out of the hands of people who are either too young or otherwise prohibited from owning them to only allow this easy workaround. MPGV urges a favorable report on SB 387. Thank you.
Good afternoon. Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I am Melanie Shapiro with the Maryland Network Against Domestic Violence. MNADV is the state domestic violence coalition that brings together victim service providers, allied professionals, and concerned individuals for the common purpose of reducing intimate partner and family violence and its harmful effects on our citizens. I'm here testifying in support of Senate Bill 387. We know that higher rates of firearm ownership correlate to a higher rate of domestic violence homicide. We also know that the risk of homicide for women increases by 500% with the presence of a gun in the home. According to the Bureau of Justice Statistics, 1 in 9 background check denials are connected to domestic abuse. Yet these items, these guns, are not subject to the necessary background checks. We have laws intended to prevent prohibited persons, including those subject to extreme risk protective orders, as well as civil protective orders under family law. And it's impossible to know how many prohibited persons have ghost guns because they're untraceable and the owners did not undergo background checks. We believe that Senate Bill 387 will help reduce the number of prohibited persons in possession of these items, and we urge a favorable report.
Thank you. Hi, good afternoon, Mr. Chairman and members of the Senate Judicial Proceedings Committee. I'm Maura Cyphers here on behalf of my client Giffords. There's, I think, 1 or 2 points I want to make on their behalf, so I'll try to keep it brief. I'm sorry they couldn't join you here today. They've got an incredible law center that is a resource. If you have questions about what's going on at the federal level, they'd be happy to discuss with you. As you've already heard today, Ghost guns are an urgent public safety threat. And I think highlighting what the federal government is doing in this space is really important, because this bill is going to complement what we expect to come down through the Biden administration. In May of last year, the AFT proposed a new rule to change the federal definition of firearm. This rule would acknowledge that ghost gun parts are firearms, and as a result, they would be regulated as such, subject to a background check, carrying serial numbers, and that will help close the loophole that thus far ghost gun companies have exploited. The proposed rule was introduced May of last year. ATF collected comments, feedback from the public until August. They haven't issued a final rule, so we're still waiting on that. Several weeks ago, the acting director said they're expecting final rulemaking to come out around June. And really, we can't wait that long. This bill is going to close that loophole. And then if and when the federal bill goes into effect, in addition to closing that loophole with the sale of ghost gun parts, it will also require that gun dealers who have ghost guns to serialize them, but not for members of the public. So that means this federal rule will not address the existing stock of ghost guns here today in private hands in Maryland. So that is really, I think, one of the most critical and important pieces of this legislation today, and we'd urge your favorable report. Thank you very much.
Thank you for your time. My name is Nicole Hollywood. I live in Salisbury, Maryland, in District 37, in Senator Eckhart's district. I'm a volunteer with the Maryland chapter of Moms Demand Action. I'm also a gun owner, a survivor of gun violence, a mother, and an educator. I took the day off work from my university and drove nearly 2 hours one way from my home in rural Maryland because I support SB 387. I support SB 387 because ghost guns are available to anyone with a credit card, including prohibited purchasers, like domestic abusers, and we need to do all that we can to ensure that we are keeping our community safe. I understand firsthand that domestic abusers far too often use firearms to coerce and terrorize their victims. I have used the court to obtain a protective order for myself and my children, and I appreciate that Maryland law makes it illegal for someone to have a firearm if there is a valid civil protective order issued. But with the prevalence and ease of access of ghost guns, domestic abusers are able to circumvent state law and easily obtain a firearm with no background check to prevent their purchase. Thank you for your time, and I ask you for a favorable report out of committee.
All right, thank you all very much. We have one question from Senator Huff.
Yeah, I'm just curious if anyone knows. We've been debating a lot about people ordering the parts, but I'm looking online as you all are talking. It seems there's people that are making them out of 3D printers and stuff like that. So what percentage of these are parts that people have ordered and they're assembling guns versus they're just home making them with, and if they're home making them out of 3D printers or parts from hardware store, there's really not much we can do on that. What percentage of these are ordered versus 3D printer made?
I don't know. I'd be happy to find out.
All right, and I guess just the last question. I'm looking at this federal reg, and there's some controversy because Congress in the Gun Control Act of 1968 basically said that it seems that Congress is saying we have possession of the law when you talk about receivers and this part of the gun. And so it just strikes me that if this gets caught up and if it goes to court, it gets struck down or it gets stuck for years in controversy, I mean, don't you think that that's problematic, that we're creating a law that is hinging on a federal regulation?
Well, no, because I think what's proposed in this bill creates a really effective backstop to at least ensure we're doing the right thing here in Maryland.
So you're comfortable with, we've had multiple testimony come in and say that we're not banning these, we're not stopping it, we're just saying you're serializing it. But if this federal regulation is struck down, never goes forward, or stuck in court, you're okay with saying, look, these are banned, they're not happening then? Because I'm just trying to, we've gotten conflicting testimony, if you've noticed today. We had some people say, we're not banning it, we're just saying a serial number. But if the federal rule doesn't go forward or gets struck down in court, you're okay with banning it, that's your position?
Respectfully, Senator, I'm not comfortable speaking on behalf of the entire gun violence prevention community, but I'll go back to Giffords and we'll get some of their federal experts
Okay.
on the phone for you.
Yeah, whoever wants to answer.
Well, I mean, I think, so there's a couple things that come into play here. So, the way this legislation is designed, it's meant to work in conjunction with the federal regs, as you stated.
Yeah.
It is also meant to operate on its own. But it is important to make the distinction. It is not saying that hobbyists cannot create firearms. They can create firearms as long as they use a serialized frame or receiver. So the hobby can continue. You just have to abide by our existing gun laws to do so.
Well, and then, but, okay, so here, when I'm reading the federal reg, it says, when Congress, this is the controversy, when Congress passed the Gun Control Act 1968, it specifically regulated firearms, including the frame or receiver. So there's going to be a court case. If this reg goes forward, it's not the end of the day, because I'm already reading, there's going to be court cases challenging that reg. My reading of the bill says you cannot purchase one of these parts unless the federal government, as required, puts this serial number on it. Well, the federal government is not going to require the serial unless this reg goes forward. So if that reg is struck down in court, never happens, you cannot, my reading of the bill, you cannot build one of these. You're done.
You would have to utilize one of the existing serialized frame or receiver parts that you can currently purchase online. So you can buy a frame or receiver that is unfinished, and you can buy one that's finished. If you buy the finished one right now, it's considered a firearm. So a hobbyist would need to buy the serialized version in order to create firearms under this piece of
Okay,
legislation.
we'll have to ask them if they're selling the serialized, because you see
can
my.
look online. There-
Do you see my problem with what I'm saying, though, is that it says as required by federal law. I guess this is, aside from guns or whatever people think on it, it's just, I've never seen something where we're hinging it on a federal regulation, which could get struck down in courts. I mean, the Supreme Court could look at this and say, you overstepped the 1968 Gun Control Act, boop, gone. And now we've got this statute in Maryland law that was hinged on this reg, so it's interesting. All right, thank you.
Yeah, I mean, just this is a question I was asking before, and I was trying to understand. So you'd have to rework this section so that because it says it has to be in compliance with all federal laws and regulations to be applicable, which is what you're identifying. So I guess you'd have to rework that, and I don't know what other unintended consequences that causes, but that you'd have to rework that, because you're right. I mean, the default position would be that all unserialized firearms would be illegal in Maryland, and there'd be no way to get them serialized.
Because there's no federal
Correct. Correct. So you'd have to rework that section of it. Okay. Yeah, got it. Senator Lee, would you like to comment?
Yeah, that's something we're going to try to work out with the Attorney General's office as to this language so that there's complete clarity on this issue.
Thank you, Mr. Chairman. I'd just like to ask if any member of the panel supports the governor's Violent Firearm Offenders Act of 2022. Anybody support that? Thank you.
All right. Seeing no further questions, thank you all very much. Thank you. All right, next is Ms. Morris here. And then Denise Reed, Ms. Reed. Is Mr. Ali here, Saqib Ali? And then we'll do Christopher Apple. And we have Danielle Veith. Welcome.
Thank you. My name is Laura Morris. I live in Annapolis in District 3. I'm a volunteer with the Anne Arundel Local Group of the Maryland Chapter of Moms Demand Action. I'm also a survivor of gun violence. I was shot by my ex-husband in 1981 due to a domestic violence dispute. I support SB 387 because looking at ghost guns through my survivor experience, an abuser who may be prohibited from legally purchasing a gun could buy a ghost gun to harm or kill their partner, their dating partner, or perhaps their entire family. It's estimated that 2/3 of all mass shootings begin with a domestic dispute. All guns must be subjected to background checks to keep Maryland families safe. Thank you.
Good afternoon, distinguished panel. My name is Chaplain Denise Reed. I am here today as a mother, survivor, and great woman of faith. I am asking the committee to pass Senate Bill 387 out of committee. My only loving son, Tavon Terrell Waters Sr., was shot while stopped at a light on October 18, 2006. When I got the frantic call from his grandmother, my world stopped. I gathered my 6-month-old baby girl and rushed to the hospital. The doctors told me my 23-year-old baby was paralyzed from the neck down. The Lord blessed me with 2.5 heart-wrenching years with my son before he died April 1st, 2009. As difficult as it was nursing one baby while keeping watch over another's hospital bed, I'm grateful for every minute. A senseless act of violence took my son from me, and senseless acts of gun violence continue to plague my Baltimore community. This epidemic does not hit all communities equally, but repeatedly impacts the same families and neighborhoods, inflicting and deepening individual and community pain. We have seen exponential growth with ghost guns in my beloved city, as mentioned by my Mayor Brandon Scott. On last Saturday, February 12, 2022, my 11-year-old great-great-niece, Life, saw her friend get shot in Annapolis, Maryland. With every step I take in memory of my beloved son, and in memory of my uncle and his girlfriend in 1984 who was killed in Baltimore, my 15-year-old cousin in 1988 was killed, my nephew was killed in 2020 in Baltimore, my mother was shot in 1992 in Baltimore, my sister in 1995. Just like ghost guns, it is a cancer that has to be cut out. According to the New York Times, since 2016, 25,000 ghost guns has been confiscated. Thank you for your time.
Mr. Chair, Mr. Vice Chair, distinguished committee members, good evening. My name is Chris Apple. I'm a resident of Columbia, Maryland. I'm here to tell you today that I'm also deeply concerned about ghost guns. I don't think people should be so easily able to buy them, especially children, especially former violent offenders. I think it is a loophole in the law which is not only exploitable, but is currently being exploited. We've heard testimony today that we're seeing increasing numbers of these guns turn up. I think it only gets worse from here if we don't take some kind of action. And I think that we need to take some kind of action to keep Maryland kids safe, to keep survivors of domestic abuse safe. I don't think this is tantamount to a ban. I think this is imposing the same regulations on kit guns as have stood for pre-assembled guns for the last couple of decades. So it's only requiring that they be serialized, they be traceable, that purchasers pass a background check. Almost 90% of Americans support background checks, and there's high support for other similar public safety measures. I can't imagine that too many people would have a problem with getting their weapons serialized. I even spoke to a few friends of mine who are firearms owners, and they said they did not think that they would have an issue with doing that. I think the bill will address a critical loophole. I think it improves public safety, and I urge a I urge a favorable report for this bill. Thank you very much.
Good evening. Hi. My name is Danielle Veith, and I'm a longtime volunteer with Maryland Moms Demand Action. I live in District 18 with my 2 kids. We all know there's no one solution to gun violence, but halting the rise of ghost guns is a critical piece. Frankly, all we're talking about is another background check loophole. As a state, we've decided certain people shouldn't have guns, and your job is to stay ahead of their attempts to evade our strong gun laws. Maryland has long been a leader on gun safety, but we're falling behind. For the last 4 years, we've come before you saying ghost guns are a rising threat and our nation's fastest growing gun safety problem. Unfortunately, it's continued to increase exponentially, further complicating our already grave public health crisis of gun violence. I'm not an expert, but I am frustrated because we saw this coming. Between 2016 and 19, the 4 years before we began to advocate for regulation, 12,000 ghost gun kits were shipped to Maryland. What did we think was going to happen? Today, the still hospitalized Magruder student is in our thoughts, but I want to remind you that 4 years ago yesterday, a student at a different MCPS high school in Clarksburg was arrested for bringing a ghost gun to school. With a daughter headed to high school next year, the inaction between those two events really taps into my mama anger. Ghost guns are not a right. They're favored by white supremacists and traffickers, and when criminals are this far ahead of regulations, we have a problem. Literally, children are lapping us on this. I understand it's complicated and earlier versions of this legislation were flawed, but we have a responsibility to do the work to get it right. I believe the sponsors have done that. There's no reason why this bill can't become law this year. Maryland should be leading on gun safety, not trying to keep up. I'm here today to support SB 387 because this can't wait. Thank you.
Thank you very much, Ms. Heath. Just a reminder, just if we could keep decorum here, do not laugh or make comments or outbursts during testimony. This has to be a space that we can engage in vigorous debate and exchange of ideas, but just by always being respectful. Ms. Reed, I really appreciate, you can sit there. I just wanted, because I really appreciated your comments and your testimony, and Ms. Heath, you made some of the same comments and alluded to the urgency of this growing need. And we did see this coming. And I guess, you know, as a policymaker, I've struggled with how we approach our gun safety laws, because we always get, you know, on one end you get the Violent Offenders Act, which is the governor's bill, which goes way too far and is, I think, misguided in some areas. But maybe the question needs to be asked: what is applicable? What could be useful from any all the panoply of legislation we've got before us? What could be useful to help us get out of what we're in, this epidemic that we're in? And where you veer into really uncomfortable water is kind of where the public safety meets race and class, and that's like the space we're in, and that's what it's hard to navigate when I think you have advocates that come in on some bills but not others, because it's uncomfortable to talk about some of the other solutions that are being proffered. And I guess it's what you said really spoke to me, because you kind of hit in on that and identified that, look, a lot of the laws that we put in place for gun safety would disparately impact Black and brown communities, because so too is the violence disparately impacting Black and brown communities. And so the impact of some of the legislation we've got before us would be to put more Black and brown young men, essentially, in to jail on both ends. And so it's just an uncomfortable, obviously, what the governor's proposing would do that, and so too, to some extent, with this bill. And so I guess it's just an uncomfortable space to be in, and I'm just struggling with it mightily, because I'm trying to be a good policymaker and make good policy, and just what you said really spoke to me, and it just piqued my interest. And I think it's identified a struggle that all of us are having, because whether you're a Republican or a Democrat, we all want to see a safer community. We don't want to infringe on anyone's lawful Second Amendment rights. It just elevated the level of debate and discussion, because it just highlighted the complexity of this issue. And I hope that all of you all know that every senator around this horseshoe is working in earnest to solve these problems. But it's difficult, and I thought your comments highlighted that. So thank you for that. Senator West and then Senator Cassidy.
Thank you, Mr. Chair. So first of all, for Ms. Reed, earlier we got testimony from, I think it was the mayor of Baltimore, or
Yes, sir.
that last year 375 ghost guns were confiscated on the streets of Baltimore City.
Yes, sir.
How many of those ghost guns do you know were confiscated from white supremacists?
Well, I didn't allude to white supremacists.
I'm sorry, I meant, Mrs. Reed, I was talking more about the other lady, Miss, is it?
Veith.
Veith, Mrs. Veith. Yeah, you allege that they're possessed by white supremacists. So of the 375 ghost guns confiscated in Baltimore City last year, do you know how many were possessed by white supremacists?
Obviously don't have that number, and I don't think it's important whether they happened in Baltimore City or not. The story that I was alluding to, I was just trying to find, there were two, I have a list here of the different stories that we've read recently, and so I was just trying to find the specific one. But January 2020, the FBI arrested 3 white supremacists in Maryland ahead of the MLK Day gun rights rally in Richmond, who, quote, planned to start a race war.
So
and
that's 3 people.
were in possession of fully automatic homemade machine gun.
Okay, so it's 3 people, but the testimony we got earlier was that there were 375 ghost guns apprehended in Baltimore City. So you made a rather blanket statement about white supremacists.
No,
I don't want to belabor
That's
it,
not
but
what I
wouldn't you admit that many ghost guns are not owned by white supremacists, but by other people?
Absolutely. What I
Okay.
said was that they are favored by traffickers and white supremacists who don't want the police to be able to find.
I think we'd find that they're favored by lots of groups, and maybe white supremacists are one of them. Second question,
Personally, was a
Senator.
concern to me.
Senator, second, also for you. Senator Watkins earlier predicted that we would pass some variation of this bill, but that the number of murders in Maryland, in Baltimore in particular, would probably not go down as a result of our passing this bill. So if that's the case, and I noticed none of your members of your group were here earlier when the governor's bill to try to put repeat users of firearms illegally in jail for longer periods of time. None of you were here to testify on that. So if Senator Watkins is right in his prediction that we'll pass some variation of this bill, but that the murders will not diminish, is your group going to come in next year and support the governor's bill to try to put people who use guns illegally in jail for longer periods of time?
So we've had this conversation a lot for the last few years about the governor's bill, and I have mentioned that our organization does not take a stance on that bill one way or another. 2 things that I would say, this is not the last legislation we'll be here to advocate for. It's a piece of the puzzle. It does not solve it. And I lost my train of thought, sorry.
Okay, well, that's a good answer. Thank you.
Yeah, I think that what you're referring to, Senator West, was this, I think it was in early 2020 members of what they call the base, a white supremacist group. They were arrested in Maryland, and they found in their possession homemade assault rifles and more than 1,500 rounds of ammunition. Is that what you're referring to?
Yeah, that's right.
Thank you.
And I just remembered what I was going to say, if that's okay.
Sure.
It was actually to tie back to what Chairman Smith was saying about how we get this balance, right? And, you know, the reason why, or at least part of the reason why our organization has not taken a stance on that bill one way or another is because we really do intend to focus on prevention versus punishment after the fact. And I think that that's really part of the key. You know, in addition to coming to Annapolis and doing all of this, we spend a lot of time in Baltimore City doing, you know, crime prevention through environmental design and other things like that, which are other pieces of the puzzle.
Mr. Chairman, may I address some question to you?
We generally don't go, this is usually a one-way street, but since you asked so nicely. Go ahead.
Yes, sir. My nephew that I alluded to that was shot in
Yes.
Annapolis in 1991 is in relation to what you said about the governor. We just cannot throw them in jail.
Yeah.
It's been over 35 years. He works at the lighthouse right down here on Hudson Street, a few minutes from here. And it's been over 35 years that we had to lift him up and nurture him and love on him. He was just up for a big promotion as the facilities of maintenance at Hudson Street. My sister was on drugs. She gave them up. She since, passed away from HIV using drugs. So it's not just the mere thing of throwing them up. The great orator Frederick Douglass said, it is easy to build a child and repair a broken man. So we must nurture their souls, not just throw them in jail. I'm sure you're all aware of the adverse childhood experience, so we must nurture them other than throwing them in jail. And that's what we did for my nephew.
No, I appreciate that, and that's in therein lies the question about the balance, because you want to hold people accountable. You obviously don't want to just be in a state that just over incarcerates. Obviously, we want to learn from the mistakes of our past, but yeah, and that's why I asked the open question. So I really appreciate that. Thank you.
Yes, bless you. Thank you all.
Do we have another Senator Kelsey?
Yeah, I'd just like to know if any member of the panel does support the governor's repeat violent crime offenders act of 2022.
I think I already answered that.
Okay, thank you.
Repeat that again, sir?
I just wonder if any member of the panel supports the governor's bill, the Violent Firearms Offenders Act of 2022 that we heard earlier today. Any member support that bill or any part of that bill?
I answered that question earlier. I don't know.
For you, the whole panel.
For myself, I would not say that I indirectly support it, because I know some people, we have to incarcerate them, but I would also support building the whole person other than just throwing them
I
in jail.
understand. Do you support any part of the act? The governor's bill, you support any parts of that?
No, sir.
Okay,
I'm not familiar enough with that act to support or oppose it.
okay. Thank you.
Additional questions from the committee? Okay, seeing none, thank you all very much, and
Thank you.
thank you for your patience today.
Thank you for all you all do for our great state of Maryland.
Thank you. All right, I think we have one, is Ms. Bledsoe still here? Oh, here, please. Favorable with amendments.
Thank you. I'm Jan Bledsoe. I am the Chief Deputy at the Baltimore City State's Attorney's Office. And the best part about going so late is all the hard questions, I hope, have been handed out. I know, right? And all the statistics have already been given to you all. So I'm not going to go over that. What I will address, though, is the confusion about 5703B1. If you go to the next section, it'll say "or," and then it gives you in B2 what we are after. We believe that B1 should just be stricken. I don't think that there's any reason to put into a bill a proposed legislation, and it makes it confusing. We would like 5703A to begin this year. As you've heard the statistics from Baltimore City, it's increasing beyond our belief. And we would like to amend B, the date, to be October of this year, 2020. And that's it. We support your bill. Uh-oh.
Excellent.
Here come the hard questions, I know, I can
Here we go.
tell.
All right, here we go. Senator Castley.
I can tell.
Can I just ask if, again, my same question, if your office supports any aspect of the governor's Violent Firearm Offenders Act of 2022?
Actually, I was texting that very question because I heard you ask it. So I can't give you an answer on that because I was coming down here to talk about the ghost guns bill. But I will be happy to call you and tell you.
Thank you.
Thank you. I'm going through the bill. I'm on page 5. So what you're suggesting is that we eliminate B1 and just have B with 2.
That's correct. So under 5703, where it says it has A, B, and C.
Yeah.
Yeah, that you would take out B1.
B1.
That makes it clear.
Okay.
And then on B, instead of January 1st, we would want all this to happen this year,
Okay.
as well as A.
All right. Thank you.
Sure.
All right, seeing as no more questions, thank you very much.
Well, thank you very much.
Thank you for your patience. All right, so that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And first up, we'll have Mr. Pennick, Mr. Boston, Ms. Mooney, and Ms. say, and Mr. Spiker, is Mr. Spiker here?
Mr. Chairman, Mr. Spiker is tied up in the legislature in Virginia.
Got it, understood, thank you very much. Well, Mr. Jocelyn, since you're here, come on up. Mr. Boston as well, thank you.
Mr. Chairman, thank you very much. I'm Mark Pennock. I'm the president of Maryland Shall Issue. We are in opposition to this bill. I've been testifying before this committee and indeed most of the General Assembly since 2013 when I was part of an expert panel on the Firearm Safety Act of 2013. Never once in any bill have I submitted 17 pages of single-spaced testimony describing all the flaws, and I'm only scratching the surface when I submitted that here. There are severe Second Amendment and due process problems associated with this bill that are truly bill killers. And I won't go into that here, but you have my written testimony that details that along with the case law and the reasons. So what I really want to stress here today is that this bill basically criminalizes a huge segment of existing gun owners who have done nothing wrong. Literally nothing wrong. They are hobbyists who have never committed a crime, and yet as of January 1, 2023, they will be criminals even though they may not know of this requirement. The practical difficulties of converting their existing guns, the home manufactured guns that lack a serial number, are profound. Detailed in the testimony, but I want to mention it here. To get a serial number that's compliant with federal law, Section 923 of Title 18, you have to have expensive equipment that only Class 7 manufacturers, FFLs, have. So all the other federal firearms licensees are not going to have that equipment. There's only relatively few Class 7 manufacturers in Maryland. This bill, and there's nothing in federal law that will possibly require them to engrave anything or control what they would charge if they're willing to do so. At the practical reality, the thousands of homemade guns here cannot be serialized in compliance with this law. I wanted to stress as well that there is a way out here. DC, in response to a federal lawsuit filed by Dick Heller, no less, came up with a compromise, and it's described in detail in my written testimony, that would allow the existing manufacture of homemade guns by individuals legally. All they have to do is ascribe a number and check with the Metropolitan Police Department whether or not that number is unique. That number will be reported to the Metropolitan Police Department. That number is ascribed onto the homemade gun, not necessarily in compliance with Section 923I, which is highly technical, and it no longer becomes a ghost gun. They can continue to manufacture homemade guns. They can keep the ones that they have without necessarily becoming criminals. Now, it is literally quite impossible for the thousands of homemade guns here to be serialized by 07 manufacturers between now and January 1, 2023. It just isn't going to happen. And if you don't extend that deadline or change that legislation, you'll be criminalizing thousands of individuals unnecessarily who've done nothing. They'll just wake up on January 1 and they will be criminals for doing nothing. That's a severe due process problem on the Supreme Court's decision on Lambert, but it is also fundamentally unfair. But finally, I wanted to stress something that's been stressed again, but this problem with kits goes away when this federal regulation is enacted into law, because the kits will go away. They will no longer be sold in interstate commerce. So unless that rule that the ATF is about to promulgate actually is invalidated, and we can argue about whether it will or not, but it certainly will effectively end the interstate sale of ghost guns. But it won't end, that rule will not end what this bill defines as an unfinished receiver. And that is my block of aluminum, because it reaches only firearms or unfinished receivers that may be readily converted into a finished receiver. And then they define what that means, and this bill does not define it. It's hopelessly vague. And this bill does not, contrary to what you've heard, purport to incorporate the federal definition for a readily converted. It simply is silent on that. So right now, it's completely undefined. But then the bill goes on to say it means any article that is sold or marketed as an unfinished receiver. Well, my block of aluminum would make me a criminal as of January 1, 2023, because it was sold or marketed as a 0% receiver. Now, I'm guaranteeing you that the problems in Baltimore and elsewhere in the state with ghost guns do not involve 0% receivers. It simply takes a very expensive equipment to take that 0% receiver and convert it into an unfinished receiver, much less a receiver at all. So this is a vast overreach, and that part of the definition of unfinished frame of receiver is not in the federal regulations. So this bill goes way beyond the federal regulations into regulating something that is relatively harmless and which is not causing a problem, but will effectively put me in prison if I don't get rid of it as of January 1, 2023. That's insane. That's bad policy. This body should not be in the business of criminalizing innocent people unnecessarily. So with that, I would urge you to rethink this bill and to basically rewrite it. Adopt what the D.C. government has done in response to the federal lawsuit. And yeah, this bill will be challenged, so you can expect a huge challenge. And bring it into compliance with the Due Process Clause and bring it into compliance with the Second Amendment. These guns are protected by the Second Amendment. And you're basically criminalized into simple possession of these guns in the home, the heart of the Second Amendment. So with that, I urge an unfavorable report.
Thanks. The your question. So for DC, so I suspect the mirror would be MSP would house these new numbers that they would generate. Now, is this prospective or is this retro? Would this go back to everyone from 1968 all the way up to 2022? What are we talking about? Because
No,
they're not going to be relics. They're not going to be curios. They're all going to. So what's you talking forward or backwards?
It's
or both?
forward.
Okay, got it.
So as I read that provision, it's kind of confusingly written, but it's
Is that how DC did
forward.
it? Is that how
It's
DC?
designed to allow the continued manufacture at home.
But is DC prospective?
Yes.
Okay. Do you think you can't predict the future, but I mean, let's say we wrap up. Are they even done with the notice and comment period for ATF regs?
I'm sorry.
Is the ATF done with the notice and comment period for the regs?
Yes, it is done, and
Okay.
it's notice and comment closed in August.
Got it.
They're now reading all the notice and comments, and some of the comments have been by major manufacturers. For example, I'll give you an example of just a pragmatic one. The M17, the Army Standard issue, is a 6-hour 320, doesn't have a serial number and what most people would think to be the receiver. It's the hand grip. There's a little window there, and the ATF considers the trigger assembly, which is engraved with the serial number, to be the firearm. You look through that little window into that engraved metal, and you see the serial number. But this bill would arguably take that hand module and make it into an unfinished receiver because it looks like a receiver. And that would put me in prison too, because I own one.
Based on your, I don't know if you've looked at the comments and whatever. You can't predict the future, but what do you think the probability of the regs being challenged?
Well, I'm certain the regs will be challenged. Whether or not to be successful, I used to defend regs when I was at the Department of Justice, so I have a good feel for this. They will be challenged. I think it will be hard to be successful in that challenge, especially if the ATF responds to some of the comments made by major manufacturers over some of the internal inconsistencies associated with that. The real problem here with this bill is that it's really vague. So you don't even know whether or not you have an unfinished receiver or not, because you don't know what's readily converted. And the bill makes no attempt to define that for you. And that's a huge problem.
Senator Kelsey.
Thanks for coming in. So I did a lot of research on this issue, and it just seems to me that this broad term ghost guns really covers I'm talking about two different categories. The one is those aluminum or metal, a metal receiver that you have to mill out and appears to take a lot of skill to do. The other that, like Congressman Brown was talking about, are these box you get in the mail. It's got everything there, and then you have to remove a couple of pieces of plastic that you just sort of drill those out. It takes a matter of minutes. You clip those out, and then you assemble the firearm.
So, yes, I agree with that.
Does, looking at those two extremes, I mean, to me, those are really the two extremes of this.
I would agree with that, too.
So, do the Second Amendment folks, do they have an interest in protecting those kits that you can get in the mail, clip a few pieces of plastic out, and then assemble a firearm? Is that something that we want to protect?
So I think the ATF is on solid ground when it wants to classify the kits as readily convertible, because under federal firearms law, if receiver is something that can be readily converted. And they have a definition for that, and they're going to change that definition. And it's fair, I think, in my view, to at least take a kit and say that's readily convertible because it is so easy.
Yeah.
And one of the factors that the rules, the ATF rules are going to articulate is how easy it is to convert that into a finished receiver.
Right.
The problems we're seeing around the state and elsewhere are because of the kits,
Exactly.
not because of my block of aluminum.
Right, and my question is that, my question there is just, we have a lot of Second Amendment folks that are, and a lot of them here today, and they've testified here before on bills, and they talk about, these are skilled craftspeople. They manufacture these things. They're very quality weapons. So taking those out of the picture right now, these kits, do the Second Amendment advocates, do they defend those as well? Do they want to purchase those kits as well? Or if this law really isolated itself to that piece of it, which apparently is the major problem, these are made out of a plasticky type of material, or do you all have any problem with if those are taken off?
I don't have a problem with regulating the kits. Because kits allow people to easily evade all the rest of the statutes.
Yeah, and honestly, that's what it occurred to me when I watched the video. They just, you got the box,
Yes.
and it wasn't a lot of skill. The only tools you needed was a DeWalt hand drill that everybody has in their home, and you knock out a couple of pieces of plastic, and within 30 minutes, you're assembling a Glock.
So it's perfectly possible, in my view, for the ATF rule, which bans kits, basically, unserialized kits, and makes them have to be serialized, for that rule to stay on as to kids and then suffer attack under other parts of the rule which are less than clear. So the rule is complex, but the kits is an absolute ban under the rule.
Okay.
And frankly, I don't think a lot of people have any problem with that at all.
Okay.
I can't speak for everybody.
It's those kids, I think, is causing a lot of us, even the pro-Second Amendment folks, some problems here when we watch that, people order these things by mail, and within a half hour, without anything, no check, even their parents, as the congressman testified, even their parents knowing, they've assembled a Glock in the basement. And it's not a high-quality Glock. I mean, it's not something that a gun enthusiast would want to purchase, but it's certainly good enough to put together and take to school and kill somebody. So
Right.
trying to focus on that particular problem, which is the bulk of the issue, seems that we could tailor the bill
that's
towards
like
that.
99% of the issue.
Yes.
So in my written testimony, I block quote a brief submitted by the Department of Justice and the ATF on that very issue.
Okay.
And talk about 80% receivers. It's not a legal term, it's just a rule of thumb.
Right.
They have long since said that those are not readily convertible into receivers because it takes a lot of skill and ability to put one of those together.
Right.
And it does. If you drill the hole in the slightly wrong place, it's scrap.
Right.
So that's one class of lower receivers that are going to be banned by this. Another class of lower receivers, unfinished receivers, are going to be these undefined, readily convertible things, which goes beyond kits. We don't know what it encompasses. We might be surprised. But I wish that if you're going to have a readily convertible ban, like this legislation does, then you at least ought to refer back to federal law on this so that we have some measure of certainty. Right now, that reference back to federal law as to what's readily convertible is absent.
Yeah. No, and your description, it's pretty vague. I don't dispute that at all. Thank you very much. I appreciate it.
Sure.
Senator West.
Thank you, Mr. Chair. Mr. Pennick, it's always a pleasure to have you before us because you really know what you're talking about, and I have the impression we're getting the straight response from you or questions.
Absolutely.
So I think the last colloquy was extremely significant. I'm focusing increasingly on how we rewrite this bill to ban kits, but to allow the hobbyists to continue to pursue their hobby and not be turned into criminals because they don't have serial numbers. But let me talk about the serial numbers for a minute. Assuming I'm a hobbyist and I manufacture guns in my basement, I got lathes and things down there, how would I go about trying to get a serial number on my gun? I think you had a suggestion, but it was complicated, I didn't grasp it.
So there's serial numbers, and then there are serial numbers that are compliant with 923I of Title 18.
Right, and there are only a couple of those in Maryland, and it doesn't sound like they're in the business of allowing me to walk in there and hand them a gun that I made and
Right.
put a serial number on my gun.
Right. So my expectation, and I know a lot of 07 manufacturers, that they're not going to do it because the legal risks associated with doing so are too high.
Right.
And the
Right.
costs of doing so are too high.
Right.
So you're just not going to get an 07 doing the 923Is types of engraving. Now, you can have a different kind of engraving, which is you get to Etch-a-Sketch and you etch a number or imprint a number onto your homemade gun.
Like with a sharp object, you scratch it on there.
Well, right, and it could be anything, and that's the kind of etching or engraving that the DC bill allows for future manufacture. Now, that's perfectly appropriate because then that bill, the government knows that you have that. It's been serialized, albeit not to 923.
Where would you call to get the serial number?
Well, they check with the Metropolitan Police Department and make sure that the number that they actually pick out themselves isn't a duplicate number. But they don't care because the government now knows what your serial number is and then can trace it. So if it shows up at a crime scene, they look at their database and say, oh, well, here's this number. That was manufactured by individual Y.
But let me pursue that a little bit. So I live in the Montgomery County suburbs. I call the DC Police Department. I give them a number. They say, no, it doesn't match anything we've got. But then if I sell the gun to a friend who lives in Dearborn, Michigan, and it's stolen and used, is the Dearborn, Michigan Police Department going to be able to get in touch with DC and find out?
Yes, because the number that is required to be imprinted there will include something that's a reference to DC and the person's, I think, social security number or some other unique number that is traceable.
Okay.
So it's just a matter of the technical compliance with what's traceable.
And so this regulatory regime is set forth in a DC statute right now?
Yes, I quote it and I cite it in my written testimony.
Okay, good, that's helpful. And then finally, you're a lawyer. Do you think you're capable of taking this bill and proposing an amendment to this bill which would segregate the kit guns on the one hand and make them illegal, and at the same time protect the people who in the basement are making guns because they're hobbyists?
Wow, that's a big job.
Well, the bill is not
I'll tell
long.
you a few examples where I would start.
What's your hourly rate?
Yeah, well, not high enough. The first thing I would do is I would drop out anything that isn't a firearm under federal law, and just to get rid of the reference to sold or marketing to be an unfinished fragrant receiver. Second, if I was going to regulate readily converted articles as receivers, and hence firearms, I would then make sure that I was using a definition that everybody understood that was consistent with, indeed identical with, what the federal government is using. That will provide a level of certainty and consistency across the board.
That makes sense.
So you're not trying to reach my block of aluminum here. You're trying to reach things like kits. And the federal government's going to define the kit. And that probably is going to survive judicial review.
Do we have the draft of the federal regulations now?
It's published, yes.
It's published, so that our bill drafters could look at that.
Oh, absolutely.
And could use that language. All
Yes.
right. Okay.
So, and the next thing I would do, I would not criminalize existing owners. Now, understand that existing owners, the presumption here is that they're already law-abiding, because an owner who has an unserialized firearm who's a prohibited person is already violating state and federal law. Indeed, it's a federal felony
Right.
that you possess that.
So your grandfather in existing.
Yes, so you don't
homemade
need to serialize
guns.
those, because they're not a problem right now.
Okay.
So the people who are committing the crimes that they're collecting these guns with on the streets of Baltimore are already illegally possessing these crimes, and they can be charged with those crimes quite successfully. And that would eliminate those guns.
Right.
And will also provide an incentive not to carry them. So you don't have to criminalize the average Joe hobbyist in the street who's just doing his thing in the basement, because it's just not necessary. You can make it for, you can future serialize his guns for the future. That way he can continue to manufacture it.
Good.
So-
Thank you very much. This has been,
Thank you.
to me, very helpful.
Senator Huff.
Yeah, thank you, because we, unfortunately, not to pick on the proponents, but we constantly have a hard time getting answers of the specifics on these gun laws from a lot of the proponents, so I appreciate your knowledge on this. The only thing, actually, you answered literally everything I had with the exception of one question, because I asked the proponents of it. Explain to me this idea about minors being able to order parts and stuff like that. Is that accurate?
Yes.
Really?
Yes. They can order it because these kids are not considered to be firearms, and they're just any other item of commerce. That's what the ATF is about to change.
Got it. So,
And,
so
like-
that is accurate then, that this teenager at Magruder or whatever, he basically ordered, he's 17, he ordered the parts for a handgun and he built it in his basement himself, and it sounds like it's pretty easy to put these kids
with
together.
the kids to make it relatively much easier than it was in the past. That was the whole idea of the kids, to make it easier than the past.
Okay,
So yes, that's why the ATF is about to regulate them, and I have no problem with that regulation. By the way.
okay. And I know the rub has always been people that are highly skilled and they're building, you know, rifles and stuff, and what you're saying, and it sounds like the clear rub is these kits, there's probably a common agreement that that's a problem, but then you've got hobbyists and people that takes a high level of expertise, have built these, and these are normally rifles that they're building, correct? These
Well,
are
they can
not.
build both. It's equally complex. The rifle has more parts, and you still have to buy the barrels and the trigger assemblies and all the rest of the stock to make a finished rifle or a finished
And so
handgun.
they've bought these because they're not currently required if it's for personal use to put a serial number on there, and then the argument is pretty clear that there's nobody who's even going to do a serial number on these. So if you pass these, I don't know what you're going to do, is go around and tell them they got to put their gun in a smelter? I don't know what, I mean.
Well, if you pass this and they can't get it sterilized, they have to be destroyed.
Yeah.
Or, dispossessed. I mean, I'm going to have to take my block of aluminum and maybe give it to the committee, which would be a rich result because this bill doesn't contain any mens rea requirements, so everybody who wanted that committee rule, knowing that block of aluminum was there, would be equally a criminal because they would be constructively possessing that block of aluminum.
Okay. Thank you. That's clarifying.
So I see no further questions. I am delighted to ask any further. Again, we ask for an unfavorable report. Thank you.
Mr. Chairman, members. Yeah, what he said, right? Mr. Chairman, members of the committee, I'm Frank Boston III. I'm here on behalf of the NRA, and we respectfully oppose this bill. Before I begin my testimony, Senator West, the FOP has no position. I represent the FOP, as you know. There's no position. We enforce the laws, and we don't make them. We just enforce them. But we took no position, okay? On behalf of the NRA, we oppose this bill. As already mentioned, the ATF is expected to release a new federal rule regulating receivers in June. Deviating now could result in Maryland being out of step with the federal regulations. It's best to wait until a new rule comes down and mirror the new federal rule afterwards. More importantly, if the committee does proceed with the legislation is far more likely to be used to target current lawful gun owners and hobbyists rather than the criminals. As a result, Senate Bill 387 is overly punitive. With a misdemeanor penalty of 3 years, this legislation will result in a loss of an individual's federal firearms rights. At a minimum, the bill needs to be amended to 2 years, to a 2-year penalty, which would avoid potential federal repercussions. If you look at 18 U.S.C. 922, it talks about that 2-year requirement, and in the definition of 18 U.S.C. 921, it basically says, under federal law, if you get convicted of a misdemeanor in any state and it's less than 2 years, you don't lose your license to, carry under the federal law. This bill, because it has a 3-year misdemeanor, would take away your rights to carry under federal law forever. So the bill, at the very minimum, needs to be amended to be consistent with 18 U.S.C. 922 and 18 U.S.C. 921. The third point I wanted to make is Marylanders have always enjoyed the right to use, to make their own, I can't even read my own writing, I need my glasses off, to make their own firearms and have done so. The legislation would outlaw the possession of homemade firearms already owned by Marylanders. In the NRA's view, Senate Bill 387 amounts to a gun confiscation. Marylanders who retain the possession of their newly illegal property could be convicted or lose their federal arms rights. So, the other amendment, which was talked about, we would ask for some type of grandfathering clause. Under the bill, it only only applies to, it grandfathers prior to 1968. And otherwise, it isn't effectively a ban, Senator Huff. You asked that question, and everybody says it's just serialization. No, unless you are a federally licensed firearms manufacturer or a federally licensed firearms importer, it's a ban, because no one else can put serial numbers on it. So it is a ban. So, to the law-abiding citizens, to the hobbyists who had built these guns, just being in possession of them, and it makes them a criminal. And let's face it, how many people will know that they even have to get rid of it or do something with it? Not many will. And as a result, they can get up to 3 years, which takes away their federal rights to still own a gun, because under 18 U.S.C. 921, the state misdemeanor has to be under 2 years. So, at the very minimum, we would need to, we'd ask for 2 amendments: grandfathering for law-abiding citizens, and then second amendment would be make it consistent with the federal law and make it 2 years.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland. As you've heard, this bill rides totally on the reference to the federal statute, which is yet to be enacted. We don't know when, we don't know how it's going to be enacted, we don't know what it will say. The dealers don't know, so they don't know whether they can do it or not. It's unfortunate that the Attorney General of Maryland was so blasé when he admitted under pressure that yes, if the federal law doesn't come in, this is a ban. That means, yes, everyone is a criminal. Now, the law-abiding citizen who did it committed no other crime. He owned it because he could. The criminal owned it because he had to, because he's already prohibited. So who does this bill impact? It impacts the law-abiding citizen who now has a prohibiting offense that will ban him from owning a firearm for life. The criminal is just going to shrug it off because he's already banned. No harm, no foul, doesn't bother me. I'll just keep on doing what I'm doing. We've taken a broad brush. We're using a sledgehammer to drive a tack. I believe that the penalties are excessive. If you are absent any other underlying crime or prohibition and you've built your own firearm it shouldn't be any more than a fine at best. If you're a prohibited person and you're in possession of that, very clearly, you intended it for nefarious needs because you otherwise wouldn't have gone to that length to get it. I'm concerned that the dealers, they don't know what they can imprint. The manufacturer is supposed to put his own serial number on it, but this bill says that it has to be a hybrid of the dealer and the person who brought it in. There are no protections in here for the dealer, who may end up being sued because somehow he's tied in as being a quote-unquote manufacturer by virtue of the fact that part of his serial number is on that firearm. We've done nothing to protect the law-abiding citizens. We've used this blanket approach, and once again, we've got another bill that's answering a perceived problem. And as the Congressman mentioned, we did Firearm Safety Act of 2013. If you look in my written testimony, you will see a chart based upon state data that proves that that was a failure. It's about time we started looking at the root cause and not at the objects. As Senator Sidnor mentioned, we're talking about the firearm and stealing firearms and so forth. We focus on the object, which is why we fail. We should be focusing on the actions and looking at why those actions occur, and then finally we'll be able to identify how to solve that problem. Until then, we're just going to add one more bill to the 26 we've already passed since 1988. We ask for an unfavorable report. Thank you.
Thank you. If I'm a very skilled gun maker and I totally make my gun from a raw block of metal, beautiful, high-quality handgun, can I sell that to people? It has no serial number on it. Can I lawfully sell that to someone, to a purchaser? Obviously, somebody who is legally can purchase a weapon.
There are some very, very limited circumstances under which you can do it. But technically, that would make you a manufacturer if you start selling that product.
So the folks who currently, the very skilled artisans who are making these handguns in their home workshops, they're just making those for themselves? They don't sell those?
They would have to, if they were to transfer it to someone else under Maryland law, existing law, it has to have identifying marks on it, or the state police would not approve the transaction. So yes, they would have to have a serial number on it.
Okay, thank you.
Thank you, Mr. Jocelyn. In our long conversations with Mr. Pennick, what I got out of it was he would be happy if we grandfathered all current homemade guns and eliminated the illegality associated with them that this bill would impose. He would be happy if we followed the D.C. law about acquiring serial numbers, which hobbyists could put on their guns that they make at home. He would be happy if we banned kits, but we followed the draft federal regulations and used the same language to define kits as opposed to hobbyist guns. And I think Mr. Boston said that we should reduce the penalty from 3 years to 2. If we did all those things, could you live with a bill that would do that stuff?
On the penalty, I would, for the law-abiding citizen, absent any other criminal activity, no more than a fine.
Okay.
For a person who is already prohibited and is using the firearm, I think we need to elevate the crime. Do we think criminals would then imprint theirs and tell the police, oh, by the way, I have it? I think there's some constitutional issues under the Fifth Amendment that probably would get away with not having to do that, so that they could beat any charge in that respect simply by saying, I would have incriminated myself by admitting I'm in possession of this firearm, which I'm prohibited from owning.
Okay.
So I don't think that particular avenue would really give you what you want. The tracing concept is really overrated when you break it down and look at it in pieces. If you have a firearm that was built and serialized, and let's limit it to handguns just to make it simple. You purchased it before Maryland put in its waiting period registration system. Maryland doesn't know who owns it. If it shows up in a crime, they have no idea where it came from. If you purchase it after registration, Maryland knows who owned it, but until 1996, you could legally transfer it to someone else. So it may, between the 60s when the registration was put in and 1996, have passed through 6 or 8 hands, and there's no breadcrumb trail.
Right.
All they're going to come back with is and say, hey, you know that firearm you bought in 1968? Well, guess what? We want to talk to you. And then you better hope you have a bill of sale that says, well, I sold it to Joe Blow, but Joe Blow's dead now, so we don't know. If the firearm never had a serial number at all, it's a dead end. If it had a serial number and it's in the system, it goes only back to the last known legitimate owner. And the whole benefit of that is maybe the owner will get his property back.
I think the concept is to grandfather in the guns that were manufactured before this bill goes into effect, so that they would not be covered by this bill. And nobody who owns one of those guns would therefore be criminalized by this legislation.
There would have to be a mechanism to document when they acquired it, and none of that is in this bill at this time.
Okay. All right. Thank you.
Thank you, Mr. Chairman.
Good evening. Thank you all for still being here and still plugging away. It's very much appreciated. I'm myself, Carla Mooney from 29C. I'm a wife and mother. My kids are not teenagers anymore, they're adults, but I do understand and I do feel the sadness in the room for those who came here with the sympathy stories, the problems, the teenagers getting these guns. But I think the root causes there are not the guns. I'm really sorry. The root causes have to go a lot deeper than that. It's those wives and those mothers and those fathers that need to be a part of their children's lives to keep them from wanting to use violence to kill somebody when they don't agree with them. As a teenager, that's a root cause. Our kids don't have any consequence. This gun bill does not bring any change in that situation. If we outlaw them, they'll find another way because they think that's okay. I request a unfavorable report on this untraceable gun bill, SB 387. Thank you again for the time today. It's appreciated.
Excellent, thank you very much. Seeing no further questions for the panel, thank you all. Just as a note, so for the proponents, the first panel, we did not time them. So for this panel, out of fairness, we did not time this panel. So from here going forward, everyone will be timed for 2 minutes. But just out of the interest of fairness, that's why we did that. Okay.
Mr. Chairman, I appreciate that.
Thanks.
Thank you.
Appreciate it. Mr. Hodge is next. Mr. Kasuba, Ms. Novotny, and Mr. McGuire. Did I skip Ashley? And then is Ashley here? Done it? Come on forward. Thanks.
Mr. Chairman, Senators, my name is Darrell Hodge. I'm a resident of Arnold in District 33. I oppose this bill. It is unworkable. It is unnecessary. It's unworkable. I have a federal firearms license. It is a Class 3 license. I cannot engrave a serial number. I don't know any firearms licensee who can inscribe a serial number. It's not a simple matter of going to the local gun store. They can't do it. It's not a simple matter of going to a local gunsmith. They can't do it. This bill is unworkable. Basically, it is also unnecessary. We talked about, oh, the children are buying these kits. The minute the child removes the first part of metal, the minute the child drills one small hole in this receiver, in this unfinished receiver, they have committed a crime because they have now made a gun. They are in possession of a gun. It's already a crime. We don't need to make it more illegal. Criminals, same procedure. If they buy the kits, great, they own a kit. They own a piece of plastic. They own a piece of aluminum that's partially drilled out. But the minute they go to remove that first bit of plastic or that first bit of aluminum, they've committed a crime. They're in violation. We should be prosecuting those crimes. I've built a ghost gun. It will fire one time. Then I have to take it apart. I've swapped out the extractor. I've swapped out the ejector. I can't make it run consistently. My written testimony includes reference to a reporter in California who went through hours to build his ghost gun. He went to his neighbor. They could not make it run consistently. While some 14-year-olds are doing this in half an hour, super. I'm taking a half an hour to polish my parts. I'm taking 2 hours to drill out the holes and remove the plastic tabs. I'm trying to make a precision firearm. If I wanted something that would fire one time, maybe you could do it in half an hour. This bill, I cannot comply with it, and I will not comply with it. Thank you.
Good afternoon. I'm Katie Novotny, coming to you from District 35B. Thank you all for staying here. We're starting to get a little late. There's a number of issues with this bill. We've already covered a lot of ground, a lot of the major issues. So I'm just going to touch on a couple key points. So in all the testimony of the proponents, it's talking about kits. However, this bill doesn't just cover kits. It's sweeping up any homemade firearms. And kits can be a problem. I don't think anybody's arguing that there is a problem with people acquiring these kits and manufacturing. However, there are legitimate, people buying kits and making them for themselves for legitimate purposes. So, it's not just criminals buying kits, but I do understand that those are one of the problems. Something that I don't think has been addressed is that there are people who have made homemade firearms, either through kits or, completely from scratch, that have already serialized these. They've registered them either with the Maryland State Police as a pistol or with the ATF as maybe a short-barreled rifle, whatever. They have, gone through a process that is there, to register these. And right now, there's no way for these people, if they did not have it engraved by a FFL manufacturer or importer, if they've had it engraved, say by a machine shop, maybe it meets the standards of depth and height and everything, but it wasn't done by the proper person, they have no means to comply with this. The firearm's already been serialized, already been registered. They don't really have a way to do that in any other method. So I request an unfavorable report. Thank you.
Hi, my name is Thomas Kashuba from Ellicott City, registered Democrat. Had this bill started with a person who commits a crime with a homemade firearm shall have 3 years added to their sentence, I would have believed that this was about criminals, but it doesn't. What I see this bill is aimed 100% at the workshop craftsman. Even after 2 years into this pandemic that we have here, the state of Maryland has yet to vaccinate 100% of its population, but yet in less than half that time, we expect to have all the homemade firearms serialized. Now, this goes all the way back to the 1960s. Something that my grandfather could have produced, it was okay for his entire life. Something that was passed to my father, for his entire life it was okay, and now, during my life, it's not okay? I wonder what kind of innocuous hobbies that I might be doing now will land my grandchildren in the future in prison. Another thing, I'll say what is normally kept quiet. I will say it out loud. In my written testimony, I had placed a survey done, Real Clear Politics, and it said that 66% of Republicans believe that once the government has lists of firearms, it will lead to confiscation. 40% of Democrats believe that. That's exactly what this bill does. It reaches all the way back to 1966, over 50 years ago, and develops a list. I find that to be disturbing. I hope that you find this bill unfavorable. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is James McGuire. I'm from Frederick, Maryland. In 2019, I provided testimony to the Anne Arundel County Gun Violence Prevention Task Force. I met Adrienne Mickler, who is the Executive Director of the AA County Mental Health Agency. She's pretty much a qualified authoritative expert on violent behavior. She put up a slide, the very first slide she put up had a bullet on it that said, "We do not have a gun violence problem, we have a violence problem." She understood the root cause. The root cause is violence, not the item. But if you insist on blaming the item, let me rather than the violent individual. Here are a couple of examples from Maryland recently. August 7th, 2018, in Baltimore, Dion Dixon bludgeoned Randolph Cockrell to death with a brick. In September 9th, 2019, in Bladensburg, Chung Young Oh attacked her neighbor, Hua Cha Pak, beat her to death with a brick. August 30th, 2020, in Baltimore, Kenneth Burke bludgeoned an unidentified individual with a brick. Using the logic of SB 387, we are experiencing an epidemic of brick violence. Serial numbers applied to masonry products will somehow prevent crime and make our communities safer. And possession of evil, unserialized masonry products should be considered a criminal act. Now, people laughed at the prospect of brick violence, baseball bat violence, or sharp stick violence when I first proposed it. And it is silly to go and blame the item instead of the violent individual, right? Sticking with the 387 serialization requirement, a gentleman in Silver Spring, Mr. Al-Katana, used his fully serialized SUV to murder his wife and drove over her repeatedly. I'm at a loss to explain why the serial number on the SUV failed to prevent this heinous act of automobile violence, in spite of Mr. Frosch's assurances that serial numbers will prevent crime. Mr. Frosch can engage his tracing fetish until his mustache falls off, but it won't prevent a single act. I request an unfavorable report.
Just be respectful with their testimony, please. All right.
Chairman and members of committee, my name is Ashley Dummett. I am 20 years old and I am a senior from Washington College. I am here today to testify against SB 387 as it is a very clear violation of our Constitution. It violates the Second Amendment and it will not actually solve any of the gun violence problems that we are experiencing in Maryland and also throughout the entire nation currently. These firearms, so-called ghost guns, have been around since the start of our nation. Our nation was founded on people making homemade guns to be able to protect themselves. That is how our nation was formed. The increase in these ghost guns is not because of their increase in production. It's the increase in crime of people that are taking these guns and using them illegally. These guns, in the possession of restricted citizens, are already illegal. Making them have to serialize them, they're not going to serialize them. These are criminals that are already doing this. Two-thirds of the guns that were found in violent crimes in Baltimore are found to be from out of state already. What is to stop them from buying these kits out of state, even if they're already illegal in Maryland? They're just going to do the same exact thing. All this bill is going to do is criminalize the law-abiding citizens that are making these guns for their homemade self-protection and also for their hobby to be able to pass down to their children. By this law, I have guns that I am waiting to be passed down to me that I will not be able to actually bring down to this state if this law gets passed. It's unconstitutional. It is a violation of our rights as Americans, and I urge you to be an unfavorable report of this bill. Thank you.
All right, thank you all very much. Looking to the committee for questions. Seeing none, thank you all. All right, next we'll go with Mr. Belizak, Mr. Gentry, Mr. Groves, and Mr. Andrika. Got it.
You see Andrika?
Andrika, yes, sir.
Oh,
yes.
What was the last name?
Gross.
Oh, okay, sorry.
Is Mr. Gross here? All right, we'll start off with this and we'll keep going. Go ahead.
All righty, I'm John Belazic from La Plata, Maryland. You know, criminals have been getting weapons for as long as there's been criminals. You know, and then you talk about the crime in Baltimore and PG County. Well, look at a map of Maryland. 80% of Maryland is not PG County. It's not Baltimore. You know, I mean, as far as I'm concerned, if we just built a wall around Baltimore, PG County, Montgomery, and maybe even Annapolis, you know, 90% of Maryland's crime would not exist if we just took it out of our statistics. You know, and now we come back to these kits. It's like the way it's always been is if you're legal to own it and possess it, you are legal to make it for your own personal use. It doesn't matter. It's an 80% kit. You have to do work for it. I've completed just about every configuration of these kits, and I've actually manufactured things that I've that nobody's ever seen before. The chairs you're sitting in are readily convertible into a firearm. It's like it's not rocket surgery. The problem is, it's like you have bills like 533, members of this committee are opposed to any penalties for criminals who are out there murdering people in the streets, and you want to release them out because it's disproportionate, that's your things, while, you want to make criminals of people like me. When I testified to this committee 9 years ago, and y'all went ahead and passed your assault weapons ban, between the time I testified before this committee and October 1st when it went into effect, I probably completed several dozen completed receivers. I actually documented them with notarized documents so I can prove that they existed before the ban took effect, and I can legally build them into any legal configuration before the ban took effect. The thing is, you're not addressing crime. You're just trying to make criminals out of decent people in this state who don't commit crime, while you release criminals hand over fist. Okay.
If you could, Mr. Balls, you could briefly conclude.
Okay.
Okay. All right. Thank you.
Nicholas Andraka, District 27B. I oppose Senate Bill 387 because it does absolutely nothing to address possession of firearms by prohibited persons while aggressively going after lawful gun owners. This bill would make law-abiding Maryland residents who possess legal firearms instant criminals. This would make it illegal to scratch build your own firearm after January 1st, 2023. Senate Bill 387 makes it a misdemeanor up to 3 years for possession of an unserialized or homemade firearm. Does anyone with half a brain think that the repeat violent criminal out there is going to care about a misdemeanor? Who that commits a robbery, murder, or kills a police officer are going to worry about that? But a misdemeanor charge up to 3 years will make a law-abiding owner ineligible to ever own a firearm again. That is the real intent of Senate Bill 387, disarming lawful Maryland residents. I oppose Senate Bill 387 because it does not deter the prohibited persons. As far as Magruder High School shooting, one only has to look at that famous video of the parents coming out of the courthouse to see where that problem was. And a simple age verification on these so-called ghost gun purchases would stop that, because gun laws work, right? Maryland Democrat senators have routinely blocked crime bills that would impose longer sentences for felons caught with firearms for persons using firearms in crimes, while defunding the police, barring local cooperation with federal law enforcement, reducing and eliminating bail, et cetera, et cetera. For those reasons, I oppose this bill.
Good afternoon. My name is Patrick. I am from Carroll County in Westminster. I am a hobbyist. I spent a lot of money on tools, equipment, research. Nothing works right the first time, I do it again. And I just feel like you're all taking that away from me. I'm a war veteran. I went to Afghanistan. Ever since August, that's helped me forget what has been happening. And I feel like I just, just got to get my mind off of it. Also, there are no edgers in Carroll County, so I don't know where to put a serial number on it. They can give me such a short window of 6 months. What if I can't make that fulfillment? I had to destroy these guns that I made, and I spent a lot of money on, that I can't even get serialized because you make the window so short. And the last thing I gotta say is a question: if I find a gun my grandfather made up in his attic and it doesn't have a serial number and I don't want it, and I go turn it into the police station, am I gonna get arrested for possessing an unserialized firearm? And that's it. Thank you.
Where'd you serve in Afghanistan?
I was at Fob Shank from 11 to 12 with the First Armored.
Yeah. Thank you for your service.
Thank you.
We have a question from Senator Huff.
Yeah, just very much. And thank you for your service as well.
Oh, thanks.
Just a question, because there was some, and it sounds like you're, what has been talked about as a hobbyist, but you're putting, time and skill into this. It's not these kit guns that people are doing with the DeWalt in the basement in an hour. It sounds like yours, how long is it taking you to build one of these?
2 months, 3 months, and then I go test it, and then I go to range, and if it doesn't work, I gotta go back and figure out why it didn't work.
Okay.
And that could take like another week, and then go back again, fails again, and I gotta go back to the drawing board.
So are you building handguns or rifles, or what are you building?
I'm building rifles, I'm not
Rifles.
into handguns.
Okay, so you're building rifles with it, and then do you have you had to purchase professional and tooling equipment for this, or?
Yes.
Okay.
The stuff from Harbor Freight is too cheap.
I'm just curious your thought, because it seemed like from the first panel, and that's why I want to ask you, because you seem sort of like the person that we're talking about, someone who's a hobbyist, but this is like a serious hobby. So, what is your thought on the difference between these kit guns that were talked about versus what you're building?
Well,
because it seemed like there was a general sentiment, these kit guns are a problem, that's what these kids are doing, and that we should deal with those. But then, how do we deal with somebody like yourself that has put a lot of time, money, and this is basically you have an expertise into doing it?
yeah, well, what I do, it's pretty expensive. If I mess up, that's $400 I just threw away.
Do you have a thought on these kit guns?
These kit guns, they're new. They're kind of like a workaround to, a completed firearm. You have to do background check to. I mean, a kit gun too, it's not as easily as convertible as some would think. It's you could still mess it up and waste a whole bunch of money. And you still need good tooling. And, you can't just use a Black & Decker drill you buy at Walmart. You gotta actually use a real good tool to use it with. I mean, these kit guns are just a bunch of parts in a box that require skill to assemble it together. And I don't see any difference.
Okay, and just one last question. So the equipment that you have, I mean, just an estimate, what does that kind of equipment cost?
Hundreds, thousands. You go try to find a good lathe, that's like $5,000–6,000 used, if you can find one, and a good quality drill press, that's another $1,000. And then you can't buy cheap hand tools. You gotta buy really good ones, like Snap-on or Craftsman. A set of Snap-on screwdrivers, I just bought some because I'm a mechanic, it was about $300.
All right, so we're already at close to 7,000. So would it be correct to say that it's about $10,000 in equipment? Was that about a correct estimate?
Yeah, that's about right.
Okay.
They actually like build one correctly and have it not blow up in your face. I mean, you gotta buy others like headspace gauges to make sure that the headspace is right so it doesn't blow up, because there are specific gauges and measuring tools you have to buy because everything is to a specification or a measurement. You go outside that measurement, let's say if your headspace is too far out, that round could blow off in the receiver and kill
like
somebody.
blow up in your face too. All right, thank you very much. I appreciate it. It's very enlightening.
All right, Tina, thank you both very much. All right, is Mr. Gross here? All right. Mr. Weber. Carlin Weber. Mr. Ditello. And is Mr. Bailey here? Mr. Bailey? Yes. And then we'll bring up Mr. Burke. Is Mr. Burke here? Yeah. Come on up.
Good afternoon again, members of the committee. Evening by now. My name is Daniel Carlin Weber. I am a Baltimore City resident in District 46. I am a handgun builder, and I'm also a firearms instructor. I understand that this body hears every day about which people to throw in jail and which people to show mercy to. I'm not personally in the business of deciding which people are sacrificial lambs to the criminal justice system, whether it be over homemade kits or regular firearms. If you refer to my written testimony, I actually allude to the history of Maryland's firearms laws and how draconian they've been, and how many people do end up incarcerated for the exercise of their Second Amendment right, or merely just possessing a gun in general. I understand, as someone who looks like myself, I am probably not going to be the people the police are looking for to enforce this law against. This law is draconian. It's strict liability. If you have an unfinished frame or receiver that isn't serialized in the prescribed manner, if you have a homemade firearm and you don't manage to get it serialized in the prescribed manner, you go to prison, 3 years. That's wrong. That is dead wrong. And I understand full well it is probably not going to be people like me who bear the brunt of that. A lot of these people who talk about homemaking firearms, they'll say, I'm not going to comply. Are they actually about the life of being so stern? Maybe, but probably not. In 1972, this body sought to criminalize the wearer, carrying, and transport of handguns without a license. And they made that license very prohibitive to get. People were flippant in 1972 about the realities of what gun control actually looked like. The Washington Post, if you refer to my written testimony, have an article in there called Frisking for Firearms. They're flippant, saying, oh, there's some concerns about this being disproportionately enforced against the black community, but we think guardrails can be put up. Here we are 50 years later, and last year you guys spent a year focusing on trying to restraining police misconduct, and I don't think that work is done. And here we are talking about another strict liability bill that's just going to throw a whole more classes of Marylanders into prison. For all these reasons, I urge an unfavorable report. Thank you very much.
First of all, I'd like to thank all of you for your time. I know it must be we're pretty late in the day. I'm Nick Ditello, District 5. I share a lot of the views that Danny just said. I think this is going to harm a lot of people. One thing I'd like to start with, though, is I noticed that Mayor Scott and Senator Lee, I noticed you mentioned that the hobbyists wouldn't be hurt by this, that it wouldn't affect us. We could keep doing what we were doing. But I think what Hugh and Wes brought up is a valid point, that it's going to be outright illegal to continue what we're doing in 2023 under the plain text of the bill. I also noticed that there was a very strong emphasis on the kits. But what about people like me? What people like me that 3D print firearms? Does it matter that our what we've built will likely not be able to be serialized easily? It'll probably destroy what we've built and put time into. It's not just these kits, it's the milling and the printing out of the raw materials. And Senator Lee, when you mentioned that you streamlined the bill, I think a problem with that is that you streamlined it such that it went from a civil penalty with a simple fine, to actual jail time. I'd like you all to just look around at the faces in the room. There's a lot of people that they were scared to testify even. The few that made it out here, I'd like you to look into their faces and know that these people might be going to jail just for possessing what was legal the day before. We're putting everything on the line here to tell you, before it's too late and these people, innocents, are put in jail. And I'm very concerned that the damage that this will cause is just another tool that the police will use against innocent people that we're not trying to hurt others. And for that, I urge an unfavorable report. Thank you.
Good evening. My name is Joshua Bailey. I'm a lifelong Baltimore resident and veteran. Murder is a felony. You know, if you are a prohibited person in possession of a firearm, it's a felony. Carrying a firearm without a concealed carry permit, concealed, is a disqualifying misdemeanor. These ghost guns that are being confiscated by police are being confiscated at crime scenes. If this was a law saying that it's illegal to possess an unserialized firearm if if this were a law saying that it is illegal to be in possession of a unserialized firearm while in commission of a crime, we'd probably be home by now. This crowd wouldn't be so large. But after 2023, under the plain text of this bill, after 2023, there's no avenue for any hobbyists to legally build their own firearms without being in violation of this law. I live in Baltimore City. I've been robbed at gunpoint. I've had coworkers shot. There are people in my neighborhood who would face, who have done less time in prison for armed robbery than I could face under this legislation. For this and reasons others have cited, I urge an unfavorable report to this legislation. Thank you.
Michael Burke, District 46, experienced law enforcement officer, 21 years military veteran, firearms instructor, and investigator. Unintended consequences. Number one, everyone in the state of Maryland who owns a shovel after this law is enacted becomes a criminal. I will happily forward the video on how to turn a shovel into an AK-47 with simple hand tools. Unless, of course, you serialize every shovel in the state of Maryland, in which case those shovels will then become compliant with this statute. Serial numbers. Under the plan set forth in the statute, you might as well amend it to say engraved with a unicorn horn. There are no individuals or businesses who are going to get into the business of engraving serial numbers on privately made firearms. You drove the largest 07 FFL manufacturer in the state, Beretta, out of the state to Tennessee with the Firearms Safety Act of 2013. There are a few left, and they're not going to open their doors and put their expensive machinery available to the hands of the hobbyist or the typical 14-year-old drug dealer standing on the street of, Cross Street Market. Those serial numbers are simply not going to be available. They're not going to happen. So everyone who possesses a privately made firearm becomes a criminal. My first privately made firearm I built in the 70s when I was a teenager. It was a kit gun. It was a reproduction of a Brown Bess musket. I would have to have that serialized. I'd love to also entertain any questions because I can answer some of the questions on serial numbers that were raised earlier but not actually answered.
It's just one question for anybody that has experience with these kits that the Attorney General was discussing. Is it true or is it false that if you take one of the kits and make a gun, it can only be used one time? Is that false?
That's false.
And so how often do you think you could use it before either the polymer melts or you have to just totally make another gun?
You could take a polymer 80 kit from most of the manufacturers and use it for the next 1,000 years without breaking it or common malfunctions.
Okay.
Because they're built to the same standards as a regular commercial Glock, except that they require machinery at the home level to finish the last 20% of the manufacturing.
Okay, thank you.
All right, seeing no further questions from the committee, thank you all very much. All right, looks like we have one more witness, Ms. Ditello.
Hello, thank you all for having me. My name is Lydia Ditello. I'm a Marylander born and raised. I've lived and worked in the state my entire life. I'm currently registered as a Democrat. I support social justice, limiting abuse of police power, racial equality, LGBT rights, and women's rights. I'm also a firm believer in gun rights for all and the decriminalization of nonviolent crimes. The two main reasons I'm here today is because this would be an additional law on the books that punishes someone based on possession, not any violent crime. Secondly, I was incredulous to hear the extremely steep penalties. 3 years in prison and a $10,000 fine per weapon out of compliance is just very surprising and out of this world to me. In comparison, there's only a 30-day jail time for theft of a handgun. I think of the gun hobbyists I know and of the many new gun owners in Maryland, some who may not be educated enough yet to know that they would be out of compliance at great peril to them. I find it to be an unbelievably cruel punishment. My fear is that this law would easily cause the over-incarceration of nonviolent citizens than to stop a crime from happening. There's no question that violent crime is a huge and tragic issue, especially in our great city of Baltimore and throughout Maryland. It's also no question that Maryland and Baltimore City have incredibly strict gun control already. And I do have to wonder why we don't focus our efforts to stop the root cause of crime, raising wages, supporting small businesses, creating equal opportunity, focusing on mental health. I could think of many other ways. Instead, this bill targets your constituents who have chosen to arm themselves lawfully, as of today, and puts each and every one of them at risk of being thrown in prison. For me personally, this would be more likely to put myself, family members, and friends in prison for owning an object. To conclude, please vote unfavorably on this bill. Thank you.
Thank you very much, Ms. DeCello. Looking for the committee for questions, seeing none. Thank you very much. All right, and with that, that will conclude the testimony for Senate Bill 387. Thank you to Senator Lee and to the panelists. We'll now move on to, I see Senator Salling, you're here. I know it's going to be quick, so Senator Salling will present us with Senate Bill 504. Welcome. No.
Thank you. Thank you, Mr. Chair and Vice Chair and Committee. For the record, I'm Senator Johnny Ray Salling, and I'm here to present this bill, which would give equal right protection to those babies still in the womb. We know that life begins at conception. Abortion ends life. It is simple as that. Babies, no matter what stage of development they are in, across our state and nation, are being killed every day because of laws that allow this to happen. It does not make sense, and it needs to stop right now. We say it's okay to end life in the womb, but we outlaw ending the life of crime who have killed vicious others. We say wear a mask because your actions could harm others, yet when it comes to a life in a mother's womb, her actions to end that life, in many instances, are loudly defended, supported, and championed. I understand that this issue is complicated and that people approach this issue with all different sides. But we should not wrap around rights of one part of society around the ideas of taking other life. Because abortion ends life. And if we are going to continue to allow these laws to persist, we need to be clear and be honest with ourselves and our constituents on just what really happens. There is no simple answer to this, and I believe we can work together in ways that we honor God and believe that life is precious. We love life, and we should never take away it from the little ones. We should look forward to bringing this to life, and I thank you so much for this opportunity, and I hope and pray that you can support this bill. Thank you, Mr. Chair, and thank you, Committee.
Thank you, Senator Selling. All right, so that'll conclude the testimony for the proponents of the bill. And we'll now switch to the opposition panel. So we'll have Ms. Ruth, Mr. Apple, and Ms. Shoemaker. Welcome.
Good afternoon, Chair Smith, members of the committee. My name is Lori Ruth, and I am the legal director at the Women's Law Center of Maryland. Oh, I'm out of breath. Excuse me. The Women's Law Center is celebrating its 50th anniversary this year. We've been advocating since 1972 for the rights of and protections for women in Maryland, including protecting women's bodily autonomy. It is perhaps ironic, or perhaps not, that 50 years after our founding and 49 years after Roe v. Wade, we are here opposing SB 504. SB 504 is in direct contravention of federal law for the past 49 years. And 30 years ago, Maryland placed question 6 on the ballot, asking the public to weigh in on a woman's right to choose. Question 6 passed then, and the support for women's right to access to abortion care today, 30 years later, is just as strong, if not stronger, by all measurements. SB 504 is not the will of the public majority in Maryland. Abortion care is health care, and health care is a human right. We must protect a woman's right to make these difficult and personal decisions in consultation with medical personnel without criminalizing any pregnancy loss, leading to possible arrest, investigation, and prosecution. This constitutionally protected decision, this right, if removed from women, impinges on a woman's liberty, equality, and economic security. Women should not be relegated to being merely a host for a fertilized egg deprived of any freedoms. We urge an unfavorable report for SB 504. Thank you.
Good evening, Mr. Chair, Mr. Vice Chair, distinguished committee members. My name is Chris Apple. I'm a resident of Columbia, Maryland. I'm here tonight to ask you to oppose this bill. Unplanned pregnancy and abortion is a public health issue. It is a very sensitive situation for anyone to find themselves in. We should treat each person in such a situation with respect and dignity, and we should all be careful to seek data-driven actions that will help those people in that situation. I think that this bill does not take the right approach. I'm not a public health expert, but I have researched the bill a little bit. I have found some studies that say that making abortion laws more restrictive does not correlate with lowering the rate of abortion. And so this bill may not have the intended effect. In fact, some states that tightened abortion laws actually saw an increase in abortion rates in the years following that tightening. This will, in addition to not solving the problem it sets out to solve, it may put parents in jail, parents who have other children, and they can no longer provide for those children. I think other measures would be more effective. Research has shown that equitable access to contraception and comprehensive sex education does lower the abortion rate and the unplanned pregnancy rate. And I would like to see Maryland invest in those instead. That lets Maryland empower people who are in this very delicate situation, helps them prevent getting into that situation rather than punishing them once they are already in it. And that will help folks have more autonomy over their own bodies. So I respectfully urge an unfavorable report for this bill. Thank you very much.
Good evening, members of the Judicial Proceedings Committee. My name is Heather Shoemaker. I'm Senior Counsel and Director of Abortion Access with the National Women's Law Center. Thank you for allowing me to testify today. The National Women's Law Center is based in Washington, D.C. We're a nonpartisan, nonprofit legal and advocacy organization dedicated to the advancement and protection of women's legal rights and opportunities. At the Law Center, we use the law in all its forms to change society and drive solutions to the gender inequity that shapes our culture, to break down the barriers that harm all of us, especially those folks who experience multiple forms of discrimination. And we know that access to reproductive health care, including abortion, is vital to one's liberty, equality, and economic security. And as such, we strongly oppose efforts to ban abortion, like the bill at issue 504. By banning nearly all abortions in Maryland with minimal exception and criminalizing that care, this bill would not only be harmful, it defies the unambiguous case law that has protected the right to abortion for over 49 years. Beginning with Roe v. Wade, the Supreme Court held that the Due Process Clause of the 14th Amendment protects a woman's right to decide to have an abortion, and the state cannot ban abortion prior to viability. After viability, the state cannot ban abortion when it's necessary to preserve the life or health of the woman. And the Supreme Court has repeatedly affirmed the central holding in that case, including as recently as 2020 in the June Medical Services v. Russo case. All of the states, Alabama, Arkansas, Louisiana, Oklahoma, and Utah, that have attempted to enforce a similar law that bans abortion at conception or fertilization have been stopped by court order. And for those reasons, I would urge an unfavorable report on this bill. Thank you.
All right, thank you all very much. Looking to the committee for questions. Seeing none, it's been a long day, so I appreciate you all for hanging out with us. With that, that'll conclude the testimony and the hearing for Senate Bill 504. We'll now switch over to Senator Carter. Senator Carter, which one would you like to take first? Senate Bill 441.
Good afternoon, members of the committee. Mr. Chair, thank you for your patience in this long day of bill hearings. I apologize for having this bill so late. I promise to do my part to be as brief as possible. I want to bring up my panel, which would be Yannette Emanuel, who's here from the ACLU, Deborah Levy, and Sam from Baltimore Legal Action. Hold up. Got it written here somewhere.
Baltimore Action Legal Team.
Sam Blau from Baltimore Action Legal Team, and Lydia from CASA. Hopefully this bill won't be too arduous. This bill is really an extension of what we've passed before. It's a local bill, and our delegation has not yet voted on it, but we have heard the bill. I'd ask for you to keep an open mind. This bill is not about whether or not you believe there should be civilian oversight. This bill is about the fact that we've already created a mechanism in last year's legislation that created two mechanisms for civilian oversight: police accountability boards and charging committees. But in Baltimore City, we already have an existing structure called a civilian review board. Prior to my coming here to the Senate in 2018, for 2 years, I was the director of the office that housed the civilian review boards and my office staffed the civilian review board. That was a very tumultuous time because it was right after the Baltimore consent decree. And the consent decree specifically referenced the civilian review board as an impotent body that needed more power and more authority. And so I used my time there to try to fight for that to happen, but I was met with nothing but resistance at that time from the then Baltimore City Solicitor. During that time, there was such an inherent conflict of interest with the city solicitor being counsel to both the Baltimore Police Department and the Civilian Review Board that it was impossible to do anything to really get the Civilian Review Board to live up to its mandate and be able to function in a way that served the people of Baltimore. And so this bill would transform the existing structure, the Civilian Review Board, into what we contemplated last year when we passed House Bill 670, which is part of the Police Accountability Act of 2021. And House Bill 670, of course, created these police accountability boards, and so the bill simply would take the necessary steps to do that. I have written testimony. It's good testimony. Because of the hour, I thought it was better just kind of explain where we are and let my witnesses talk. I also want to briefly touch on the fact that there's more than 30 people that I saw that signed up to testify, written testimony in favor of this bill, mostly Baltimore residents that have a stake in this. And the only opposition comes actually from Baltimore City, from the mayor's office and the city solicitor. And in listening to their opposition and reading their opposition, they contend that they're not really ideologically opposed to this. They kind of feel like they just don't want us dictating how they do this. And so I've had conversations. I think there's some chance that we could have some middle ground on this. I'm not really sure. But I just want to stress that this legislative body created the Civilian Review Board. This legislative body created the police accountability boards and all the legislation. And so the bill as we have before us, the Civilian Review Board bill, it actually defers to the public local laws that already govern the Baltimore City Civilian Review Board. And I think that's important because the opposition is going to testify that somehow we're having a constitutional violation by stepping over the authority of the city. And that's just absolutely, I disagree with that vehemently, and I'm happy to follow up with any legal cases or memoranda that you'd like to see to do that. From my written testimony, I just want to emphasize a couple of things. The Civilian Review Board was created by this body in 1999. It's been a toothless tiger, an impotent body ever since that time. People in Baltimore have been screaming out and crying out for more authority, more ability to have oversight over the Baltimore Police Department. We know of all of the things that we know that have happened with the corruption in the Baltimore Police Department, the gun trace task force, the fact that it's under a federal consent decree right now because of all of those problems. But even before 1999, something that I found very interesting is that all the way back to the 1960s, my father and the NAACP and members of the Goon Squad and other civil rights activists cried out and demanded a civilian oversight body because of then police excessive force and corruption. They were not able to achieve it at that point, but here we are today in 2022. I think there's been a recognition that we needed to make reforms, and we did. And now the next step is to really understand that if we truly believe that people should have a say and a stake in the public safety in their community, the next step is naturally to take an existing structure, civilian review board, and help it transition to be the body that Baltimore City residents really need. And with that, I'll stop the testimony and I'll take any questions. Thank you.
Thank you, Mr. Chair. So last year, we passed a bill to take the control of the Baltimore City Police Department away from the state of Maryland and confer it on the Mayor and City Council of Baltimore. And it's still in the works. It hasn't formally happened yet because the city, I think, has to change the charter or do something in order to accept the new responsibility that we tried to give them. So why don't we wait for a time to see whether or not the Mayor and City Council embrace their ability to control the Baltimore City Police Department rather than devolve that sort of responsibility on a different organization?
So for a couple of reasons, my answer is for a couple of reasons. Number one, this does nothing to interfere with that. If you realize the local control bill that we passed, this actually kind of coincides with that because it still gives Baltimore City the same authority as we passed in the Police Accountability Act. So I guess my answer is this. We don't know how or when that's going to happen, but in the meantime, we have this impotent entity that is resourced but not functional to its maximum capacity, and we have an ability to do something about it now. I'd also point out that, I think I might have lost my train of thought, but I'd also point out that even with the local control bill, the department is still governed by the state laws that we passed that apply to all police departments throughout the state.
Okay. I just
So
thought
I
that
think there's just not a reason, there's not a good reason to wait. We need the action to happen now.
But is it possible that if we enact your bill, that there will be a conflict down the road between the Mayor and City Council trying to exercise the authority we gave them in last year's bill, and this organization trying to exercise the authority we would give them in this bill? Isn't it possible that they would clash? And we could end up with litigation in the city about who really controls the police department?
So I don't think so, because this isn't about control of the police department. It's about what we contemplated in the legislation about civilian oversight. So I don't think so, but your question is important because it gets to the city's opposition. They don't phrase it in the way that you did about the local control possibly being at odds with this, but their opposition contends that even though they are well aware that they are obligated under law to create police accountability boards by July of this year, they'd simply rather we not tell them that they have to take the existing structure and utilize that to transform into that. They'd just rather figure it out for themselves, which kind of doesn't make a lot of sense because the existing structure already is existing and resourced, and if we don't do anything about it, it's continue to be like a waste of resources.
Okay, great, thank you.
Thank you, Mr. Chairman. Could you talk a little bit about how or whether at all this intersects with the consent decree?
It actually helps the city live out the mandates or edicts of the consent decree. The consent decree specifically addressed the Civilian Review Board and its need to have more independence and more resources. That has not happened in the more than 3 years since the consent decree has been signed. And so part of the reason why it hasn't happened is that the city and the city solicitor's office won't let go of control of it. And specifically, I could go on about this, so I'll try not to be long. Specifically, rather than even when the consent decree was signed, rather than utilize the existing civilian review board, which is staffed and resourced, they created a whole different entity called the Civilian Oversight Board, and that Civilian Oversight Board dissected the Civilian Review Board and basically concluded everything that everybody here is going to say, that it needs to have more authority, it needs to be better resourced, and it needs to be independent of the city and not have the same counsel as the police department.
So, I can follow up. So there are two entities now, one that is.
No, the Civilian Oversight Board was a temporary board.
And it
that just
doesn't
was
exist
designed. It was designed to look at the existing Civilian Review Board and give opinions about it, but it wasn't a continuing board. I think there might have been some effort to extend it, but it's not a permanent body.
Gotcha. Okay, thank you.
Yeah, thanks. Well, thanks, Senator Carter. I was just like, so the MPTSC is in the midst of promulgating regs for the PABs and the ACCs for the 24 jurisdictions going out. And I know, my jurisdiction has had some, as they've gone forward with the PABs, they're still kind of struggling to understand what the administrative charging committees is like alphabet soup, but the ACCs are going to look like because the regs aren't there yet. I think they're working it out, but my question is, so does this then, the Civilian Review Board, does this get like subsumed into the PAB and it kind of turns into this hybridized, and it works in conjunction with the charging board?
Yeah, so under the bill, under the intent of the bill and the language of the bill, the Civilian Review Board would simply assume the same responsibilities as does the Police Accountability Board, but it would retain its existing powers and authority as well. So there are some things that the Civilian Review Board has been doing that we didn't spell out for Police Accountability Board. So the idea is that the Civilian Review Board wouldn't lose any power. It would just assume those responsibilities. And of course, as you know, the Police Accountability Boards have the ability to utilize its members for the charging boards, and that will be the same. Nothing would change.
I was just looking at the functionality. I mean, and then another one is just like, this highlights one of the things. I mean, I know we had conversations about uniformity throughout the state, 24 jurisdictions, and then now this being kind of different in the city than it would be in the county, and so on and so forth. But I act in deference, since we've done what we've done, we set up with our framework. I act in deference to you as the senator from Baltimore City and the other members of the delegation from the city. Just wondering, where are they on this? I have no blessed idea. Like, just where are we in this process? Do we need a delegation letter? Are you all like, I don't know.
Oh, so we haven't voted yet. We heard the bill last Friday, and we could ostensibly vote on it this Friday. I have offered to have a meeting with the city to see if there's any middle ground, so we might do that before the vote, but, so the answer is I don't know yet.
Yeah, excellent. No, I mean, yeah, just whatever you all do, so you let me know. All right. Sarah Castley.
I'm just going to be really blunt. Here's the challenge I have. We had the LEOBR was there. It was functioning in all of our districts. And then, primarily from Baltimore City's advocacy, there was exceptions made to the LEOBR, which Governor Schaefer said, when he was governor, was going to undermine legitimacy of the LEOBR, but they went ahead with that anyway. And it really trashed the LEOBR system in those jurisdictions, like Baltimore City, Prince George's, Montgomery, that took advantage of these options to localize it. So after then moving forward last year, most of our jurisdiction came in and said, the system in our localities is working very well. And we were told, no, you can't we're going to have one size fits all. You're going to have to conform to what Baltimore City wants. And so you came in here with the bill and standardized it throughout the state, which has caused a lot of problems. I know in my jurisdiction where accountability is actually down now because of this one-size-fits-all approach. Now Baltimore City comes in and says, let's go back to like we did LEOBR 20 years ago, 25 years ago, and now we want exceptions. We want to be treated differently. So after pushing a one-size-fits-all bill on all of our jurisdictions, which has undermined police accountability in our jurisdictions, Baltimore City comes back in and says, well, we want to be accepted from parts of that. I just find
So
this
your
approach.
account is just a little bit different than mine, Senator Castley.
Mine's the history. You can make it
well,
up. But
no, but so first of all, when we repealed the Law Enforcement Officer Bill of Rights, a part of the new restructure was specifically naming these civilian-led or civilian participating groups, the Police Accountability Board and the Charging Board. And so that's in the law. And so
Yeah, so
we're
let's
not
stick
asking
with
for an
it.
exception. We're saying that we're like a little bit ahead of some jurisdictions like maybe yours because we already have an existing structure that is capable of taking on these responsibilities, where some jurisdictions like yours may not have any existing structure, so you have to start from the ground up. But we don't have to, so we're saying, since we don't have to do that, don't let us, because the people of Baltimore have been screaming out
Why not
for
start from
civilian
the ground
oversight
up
before.
in conformance with the existing state statute? Why do we need to
And
change
so,
it?
to be quite honest with you, I did in my initial bill, so that's also not correct. In the initial bill that I sponsored to repeal the LELBR, I absolutely had civilian oversight as contemplated in this bill there. That is not what this body chose to pass. This body chose to pass the other bill, creating the police accountability boards and the charging boards. And so that's where we are. So that's the actual account.
This bill is bringing back language that was specifically struck by the General Assembly from the last year's bill.
So that's not correct.
Okay, I thought that what you were just saying, that
It's not
that this was
correct.
in there, but it was struck by the body, and now you're coming back with this bill.
No. Let me try that again. My initial bill that I drafted that repealed LELBR contemplated this idea of civilian oversight. Not this bill here, not anything before us right now. We didn't do that. We created police accountability boards in our restructuring of LELBR. The bill now here that I'm coming with today, it says, hey, since we all, well, those of us that voted for it, passed the restructure that created police accountability boards, Baltimore doesn't have to start from square one. We have a starting point because we have an existing structure that's resourced and staffed. It simply needs to be able to function as the Police Accountability Board as contemplated in HB 670, which frankly started as a House bill, not a Senate bill at all.
So why make this local bill? If we're going to allow flexibility in how people do this, why not just grant blanket flexibility statewide that people make up their own rules?
Okay.
I mean, because what you
That's not
said here,
what this
look, the bill says,
Okay,
notwithstanding
there are
any
only two
provision-
jurisdictions in the state of Maryland that have any existing civilian review or accountability board at all. So this only would even potentially apply to those two jurisdictions, but I'm not asking about any jurisdiction other than my own. And I started out by saying that this is a local bill.
Yeah, this says notwithstanding any provision in the current law that the public laws of Baltimore shall govern the powers. So we're saying whatever's in the current law on civilian review boards, Baltimore is going to be an exception to that, and they'll make up their own rules, whatever their own system, whatever the city comes up with.
So that's not what we're saying.
It says notwithstanding any provision of this section, the public local laws of Baltimore shall govern the powers and duties of Baltimore City Civilian Review Board and membership of the board, and shall determine the accordance.
So we've already established what these boards will be. What this is doing is saying that we're not usurping any existing power that the city already has. That's what this is saying. That we're saying that we aren't superseding what the city already controls or has authority to do with its public and local laws. And actually, that's an important point, because I think the city comes in here and says that that's exactly what we do, but you've just pointed out that this bill does not do that, if that makes any sense. So anyway, I would say it's a local bill, and I just asked the body, the committee, to defer, listen to the testimony and defer to the will of the delegation. Thank you.
Senator Carter. All right. Whichever panelist you'd like to have come up.
Good evening, Chair Smith, Vice Chair Wallstreicher, and members of the committee. My name is Yanetta Emanuel, Interim Public Policy Director at the ACLU of Maryland. The ACLU of Maryland is in strong support of SB 441, which would ensure that the CRB structure and authority remain intact while giving it the additional powers and scope of the police accountability boards as mandated by the Police Accountability Act of 2021. This bill would just simply allow the CRB to expand the category of complaints it can investigate when it absorbs into the Police Accountability Board. And additionally, it would allow that it would appoint members to the Administrative Charging Committee and Trial Board. And most importantly, it will make sure that the CRB will be able to retain independent counsel and have adequate funding in order to carry out its duties. You have my written testimony, so I will use this time to address the opposition's remarks. First, the city will claim that SB 441 will take away the city's local authority to appoint members to the boards and commissions and undermines local control. That is simply not true. SB 441 does not take away any power from the mayor because it does not change the process for appointing the CRB members who are selected by the mayor and approved by the city council as prescribed by the statute. Furthermore, HB 670 gives local jurisdictions little power over the structure of the police accountability boards. They only populate the board, but the duties and responsibilities are already spelled out in HB 670. And any additional staff hired by the CRB will not be considered members of the CRB. More importantly, the reason that the 99 statute went through the state legislators because Baltimore City did not and still does not yet have local control. So when the city claims that they can do this locally, the reality is that they can't, and so they're limited in the powers. They're limited in their powers of what HB 670 allows them to do, which is again primarily appoint its members. Next, the city will argue that the CRB is not an independent legal entity and doesn't have the power to obtain independent legal counsel. The CRB is an independent agency. The Maryland Court of Appeals, the Maryland Court of Special Appeals already established this in 2006 and stated that as such, and that the city's, and it's also listed on the city's own website. Lastly, since its inception, the CRB has had to obtain legal counsel support from the city solicitor's office, which is an inherent conflict to have the same person representing the city, including the Baltimore Police Department, also represent the independent agency providing oversight for the city. The public witnessed this in 2018 when the city solicitor's office tried to force the CRB to sign a confidentiality agreement out of concern that their findings would be public and damaging to the PPD. The Gun Trace Task Force report and the DOJ consent decree make it clear that this type of inherently limited legal support has made it needlessly difficult for the CRB to hold police accountable, inform the public, and focus on their responsibilities. SB 441 is essential to achieving maximum police accountability in Baltimore City and the most efficient way to reconcile the CRB and the PAB. For the foregoing reasons, the ACLU of Maryland urges a favorable report on SB 441, and I'm happy to answer any questions the committee has. Thank you. Can I go?
Good evening, Chairman Smith, Vice Chairman Waldstreicher, and the rest of the panel. It's very nice to see you all in person after last year testifying over Zoom. Nice to meet you. My name is Debbie Levy, and I'm the Director of Special Litigation with the Office of the Public Defender in Baltimore City. I've had the pleasure of meeting many of you last year as I testified in favor of major police reform, which this committee courageously passed. Senate Bill 441 is nothing more than an extension of and a natural outgrowth of those sweeping police reforms. As I was testifying last year, I heard from many people that police corruption is a problem unique to Baltimore. And while that is not actually true, one thing that we can probably agree on is that police corruption is particularly pervasive in Baltimore. Last year, we had the knowledge of the Gun Trace Task Force convictions. This year, we have the benefit of the Steptoe report, which is a 660-page independent study of the origins and pervasiveness of corruption in Baltimore City. This was a study that was commissioned by the city and the police department together, and independently, the study concluded that A, it could not start with examining the Gun Trace Task Force because the corruption in Baltimore City runs so deep and for so many decades and pervades every aspect of the police department, they had to go further. The study concluded that not just is it pervasive and has been there for decades, but sadly, the department's Internal Affairs Division is systemically incapable of adequately addressing the misconduct of its own officers. As I provided in written testimony to you and slides, the Internal Affairs Divisions in Baltimore City is unable to recruit properly or train properly investigators who can investigate their own. The Civilian Review Board has the power to investigate misconduct different than the charging committee that Senator Smith was asking about, and it would like to retain that ability. The Civilian Review Board has existed in Baltimore for years, and it has given community members a way to express concerns and sound necessary alarms. Although it's a toothless tiger, there is comfort in the ability for the citizens of Baltimore to go outside of the police department to lodge a complaint. There is goodwill that's conferred by the Civilian Review Board that we don't want to abolish, and we want to eliminate redundancy. The citizens of Baltimore need their concerns to be continued to be addressed by the CRB, and without this bill, the goodwill and important history of the CRB will likely disappear. Specifically, this bill would broaden the categories of investigations the CRB can undertake to parallel the police accountability boards. It would continue to confer subpoena power on the CRB, which already exists by statute. This combination is necessary to provide Baltimore with much-needed independent oversight for intense and pervasive police corruption. As a result, we urge this committee to provide a favorable report.
Good evening, Chair Smith, members of the committee. My name is Samantha Blau. I am the Policy Director with Baltimore Action Legal Team and a resident of Baltimore City. The Baltimore Civilian Review Board is an independent agency. This was established by the Court of Special Appeals back in 2006. As an independent agency, even if viewed as an unincorporated association, the CRB has the legal ability to sue, to be sued, and retained independent legal counsel on its own behalf. And yet, the City Solicitor's Office continues to maintain that the Civilian Review Board is not a legal entity and that it cannot contract for independent legal representation. The City of Baltimore currently maintains that the CRB as a department within the Mayor's office. The City Solicitor provides legal counsel for both the Police Department and the CRB, even as the Review Board is meant to hold police accountable for misconduct. Facially, the Maryland Attorney's Rules of Professional Conduct state that an attorney shall not represent a client if the representation involves a conflict of interest. A conflict of interest exists if the representation of one client will be directly adverse to another client. Practically, past conduct of the City Solicitor's Office has established that they defer to the interest of the Police Department. The City Solicitor's Office has ordered the Police Department not to send complaints against BPD to the CRB. The solicitor has pressured CRB members to sign a confidentiality agreement, and members who have exercised their rights to refuse to sign were then rejected access to complaints against officers. Additionally, between 2013 and 2015, BPD failed to forward more than 2/3 of police misconduct complaints to the CRB. In some cases, complaints have been withheld from the CRB for over 12 months, rendering them moot, an action that has shielded BPD from public accountability. If the CRB remains under the legal counsel of the City Solicitor's Office, its ability to meaningfully provide justice for the public will suffer. Baltimore Action Legal Team believes that passing Senate Bill 441 will strengthen the CRB and give it space it needs to operate as intended as the police accountability boards were intended.
Good evening, Chairman and members of the committee. My name is Lydia Walther Rodriguez, and I'm the Region Director of CASA in Baltimore and Central Maryland. CASA is the largest member-led organization fighting and advocating for immigrant rights in the state of Maryland in the Mid-Atlantic region. We are pleased to provide a favorable testimony for Senate Bill 441. CASA members have been constantly coming here to the committee and testifying on their accounts of police misconduct, abuse, and brutality. For many immigrant families, police misconduct oftentimes goes unaccounted for or underreported due to the distrust stemming from a long history of police misconduct going without accountability and proper oversight. For those reasons, CASA and its members have joined the coalition on the statewide level, MCJPA, and the Baltimore-based coalition, CGSJ, and stand united in support of Senate Bill 441. This bill is the opportunity to achieve maximum civilian oversight and police accountability by building upon the infrastructure and experience of this existing Baltimore City Civilian Review Board. Strengthening the CRB through SB 441 will encourage community members to come forward and give their stories on police misconduct. SB 441 would create one strong independent oversight would create one independent oversight board as opposed to two weak, less effective boards. Passing SB 441 into legislation is a fundamental piece to bring transparency and police accountability to Baltimore City. For all of those reasons, CASA urges a favorable support for SB 441.
Excellent. Thank you all very much. All right, looking to the committee for questions. We've got one from Senator Bailey. Sorry, that's my...
Thank you, Mr. Chairman. And this could be to the sponsor or any of you ladies. What is the ability for a police officer to expunge the records of the complaint that were not sustained or if the police officer through the investigation was totally exonerated.
You mean through the civilian review board? What is?
Yes.
Well, last session, when you all passed HB 670, that repealed the provision that required that officers be able to expunge their records, so that is no longer in this bill, because moving forward after July 1st, that will no longer be a requirement.
So if we went to page 5 of the bill, down to line 13, it's bracketed where it takes that out. Normally, when it's bracketed, if it would come out last year. It wouldn't be bracketed for this year.
Well, HB 670 hasn't gone into effect yet. It goes into effect July 1st. Well, the portion of the bill that will repeal their ability to expunge records.
So their ability is already completely gone?
As of July 1st, it will be.
Okay.
And that's when the bill will go into effect. This bill.
So the wording of this bill is not being written to the law that we passed last year. It's being written to the law as it exists right now.
It's written to what it's going to exist as of July 1st. So the bill is written to be consistent with what the requirements are in HB 670, thus striking that provision.
Okay, thank you.
So it's written with the laws now, but she's right, because the bill doesn't, we kicked it out a year for the effective date, so the law is still on the books right now. Because we kicked out that portion of it till another year, to 2022. Instead of October 1st, 2021. Or, I've got that opposite, but yeah, out year out. You're right. All right, any additional questions for the panel? Okay, thank you all very much. Thank you. All right, we've got, I think that's the panel for the proponents of the bill. Now we'll go to the opponents of the bill, Ms. Thompson and Ms. Mayhew.
Good evening, Chair Smith, members of the committee, Natasha Mayhew here on behalf of the Baltimore City Administration in opposition to Senate Bill 441. I do want to start by thanking the sponsor for her history and hard work on this effort. And as she noted, we have had conversations with the advocates, and we do plan to continue to have conversations with the sponsor as well. However, we do oppose the bill as it undermines the city's authority. It creates an unworkable framework, and we fully intend to comply with the police reform that was passed last year. So HB 670 did put in place historic statewide police reform. It's established these civilian oversight boards, but did provide the local flexibility to establish them in ordinance. Senate Bill 441 takes that away from us. It tells us, Baltimore City, this is exactly how you have to move forward. There's no public engagement to shape the process locally. It puts us in a different standard than other jurisdictions. It's contrary to all our local control efforts that we've spearheaded just this past year. Our city council meets year-round. It allows for better access for city residents to be able to meet and speak with the council. They don't have to come to Annapolis during a 90-day session and take the day off work to do so. You will hear more from Deputy Solicitor Thompson about the framework concerns, but in a nutshell, they want complete independence from Baltimore City, but at the same time want a mandate that we fund them. And as noted, we are under a federal consent decree, so all our decisions regarding police conduct and operations do have to be carefully considered. So the mayor was elected on a platform of public safety and government transparency. We can't pay for past administration's sin. We certainly just want the opportunity to move forward, to take the CRB as it was 20 years ago, and the opportunities we have now under the police boards to the next level. The CRB walked, so the PAB and ACC can run, and we're proud of those efforts. So with that, we do request an unfavorable report on Senate Bill 441. Thank you.
Good evening, Chair Smith and members of the committee. My name is Ebony Thompson. I am Deputy Solicitor for Baltimore City, and we are requesting an unfavorable report and opposing SB 441 for the following legal reasons. First, the provisions related to the hiring of staff are at odds with the Baltimore City Charter and public local laws. Article 4, Section 6 of the City Charter gives the mayor the sole power of appointment of municipal officers. Municipal officers includes members of boards and commissioners. Pursuant to the Baltimore City Public Local Law, Section 16-42, the board is an agency within Baltimore City. Similar to any city agency, the board cannot fire employees independent of City Human Resources Department and City Service Commission pursuant to their charter powers. Second, the SB 441 declares the Civilian Review Board can sue and be sued and may hire or contract for legal representation. As a municipal agency, the board is not a legal entity and therefore does not have the capacity to sue and be sued. Therefore, this part of the bill is directly at odds with the existing law. Finally, the provisions related to the annual budget of Baltimore City are an unconstitutional violation of Article 11A of the Maryland Constitution. The Maryland Court of Appeals has spoken, has clearly defined the ability of the General Assembly to limit the authority of Baltimore City's government. It held the legislator has the power to describe the field within which the local authorities may legislate, but having once done this, it cannot restrict or limit this field of legislation without changing its boundaries. Any other interpretation would render the provisions of Article 11A meaningless and result in nullifying the purpose sought to be accomplished by its adoption. While the General Assembly has the authority to determine what powers are to be exercised by Baltimore City or the charter counties, the General Assembly may not enact a public local law for the city or any charter county which modifies the power so granted. For these reasons stated, we request an unfavorable for SB 441.
All right, thank you very much. Turn to the committee for questions. Senator West, and then Mr. Apple, I neglected to call you up, so we'll call you up for your testimony on this bill as well. My apologies. Go ahead.
Thank you, Mr. Chair. Just a quick question. Last year, the General Assembly devolved on the Mayor and City Council of Baltimore City the power to control the Police Department of Baltimore City. What is the timetable for the city to embrace that power and begin to actually exercise control over the Police Department of Baltimore City?
Thank you, Senator. So there's two timetables here. The change is effective upon a change of the charter that goes to a referendum. So right now, we have been meeting for a couple of months with our Local Control Advisory Board, who is overseeing that process. We fully intend to have a bill through the council and a charter amendment in time for the general election in November. Assuming that the residents, vote in favor of this, then we would assume control January 1st, 2023. There's a stopgap, and we also have the opportunity to do so at the next general election. Thank you.
All right, additional questions? All right, thank you both very much. Thank you.
Thank you.
All right, sorry, Mr. Apple, my apologies.
Thank you very much, Mr. Chair and distinguished committee members. I am testifying in favor of SB 441. My name is Chris Apple. I am a resident of Columbia, Maryland. I think the CRB is a great choice for conferring the powers of the Police Accountability Board and making that a reality. I had the opportunity to hear a member of the CRB speak at a meeting recently. I was impressed with the consummate professionalism that they had and the enthusiasm that they had for the work that they were tasked with. They're very passionate about it. The CRB has a lot of experience. It's been in existence for over 20 years. I think that gives it a great asset. And it has existing relationships with the community. So it's used to hearing complaints. It's made inroads with different communities. And it's a sort of a reciprocal relationship that they're used to. So I think that makes it a great choice to accept additional powers as mandated for the PAB. I think it would also be the choice with the least runway and spin-up time, because they're used to doing this kind of work already. So we wouldn't have to worry about a separate entity getting started and figuring itself out. It would just be some additional powers conferred onto an entity that's been working fine for a couple of decades. It also may help us save money and reduce duplication, since both the CRB and PAB are mandated to exist. Combining them together avoids any duplication that might be inefficient. So I'm excited to see the CRB get expanded capability. I hope you are too. I think it's a win-win for Maryland. And with that, I urge a favorable report. Thank you very much.
Excellent. Seeing no questions, thank you very much.
Thank you, Mr. Chair.
All right. All right, well, that concludes the testimony and the hearing for Senate Bill 441. We'll now move on to Senate Bill 509. Senator Carter, you're up. This is the last bill of the evening. Yes, Senator West.
You stole my thunder, Mr. Chair.
Oh, I'm sorry.
So,
I'm
members
sorry.
of the committee, I wanted to be pleased to announce that I'm as elated as you are that this is our final bill. And this should be a relatively easy bill for us because it's something that we've passed before. It's the third time that I've brought the bill. And so before I continue, I'd like to bring up my panel, Mr. Chair. So from Baltimore Harm Reduction Coalition, we've got I always say her name wrong, Ms. Goodlow. RG. Yeah, there we go. Also from Healthcare from the Homeless, we have Catherine Billop. And from Maryland Peer Advisory Council, we have Tiffany Scott. Without further, oh, she had to leave. But there's a number of other people that are here, I believe, to testify in favor of the bill. It looked like there were a lot of favorables, and so without further ado. So for the third straight year, I'm introducing this bill, Senate Bill 509, to repeal the prohibition of individuals using or possessing drug paraphernalia with the intent to inject, ingest, inhale, or otherwise introduce a controlled dangerous substance into the human body. This bill is part of a continued effort to improve public safety and decriminalize the serious illness of substance dependence. We passed this bill out of the General Assembly last year, which Governor Hogan vetoed. In his veto letter, the governor correctly identified the opioid epidemic as a crisis that we need to address and combat. However, the letter's assertion that paraphernalia decriminalization encourages the use and possession of drugs and allows distributors of illegal substances to stockpile paraphernalia is false. This assertion also ignores the research that demonstrates that harm reduction benefits of the harm reduction benefits of paraphernalia decriminalization. The goal of Senate Bill 509 is to increase both the public's safety and safety of those suffering from substance dependence. When the possession of drug paraphernalia is a criminal offense, it places the public at risk because individuals are much more likely to improperly discard used supplies like hypodermic syringes on our streets and alleyways and in our parks and playgrounds. There was testimony that I recall last year from a law enforcement officer that attested to what I'm about to say, that it also places our law enforcement officers in harm's way. Individuals subject to a search may fear arrest if they disclose the possession of drug paraphernalia, leading officers to conduct searches without knowledge of this hazard, therefore increasing the likelihood of officers being pricked with used needles. Further still, the threat of infection is markedly higher for members of our community who are struggling with substance dependence. Research shows that the fear of arrest for possession of drug paraphernalia is coupled with a higher likelihood of relapse or sharing supplies for drug administration. Taken together, it is not hard to see how the risk of transmitting infections like tetanus, HIV, and hepatitis C is not just limited to those engaged in drug use. For those reasons, the criminalization of drug paraphernalia is not an appropriate response to the opioid epidemic crisis ravaging Maryland's communities. Decriminalizing the possession of drug paraphernalia is a logical path toward increasing public safety and aiding the victims of the opioid epidemic. In addition, It will also reduce arrests that have the potential of derailing recovery from substance dependence, the financial burden of which is needlessly harmful to our state and its residents. For all of these reasons, I would urge a favorable report once again on Senate Bill 509. Housekeeping matter, the bill was not drafted exactly as what passed last year. There should be an amendment that was sent out before this bill hearing, which conforms this bill to what we passed last year, which does include, it should be in your packet, but basically it does include delivering or selling under certain circumstances, or manufacturing or possessing with intent to distribute or sell under certain circumstances, and that encompasses the need for these organizations such as harm reduction and others to be able to distribute, as well as people that are acting on behalf of other people that this bill needs to contemplate. And so without further ado, I'd like to introduce my panel. Of course, happy to answer questions with them or without. Thank you.
Good evening, everyone. I am Regini Goodlove-Valetti. I am Director of Mobilization with Baltimore Harm Reduction Coalition. We call it BHRC. And BHRC has been operating for over 10 years, primarily as a state-certified overdose response program and a syringe service program, which we refer to as SSPs. We are urging a favorable vote on Senate Bill 509 with an amendment to match the version that the Maryland General Assembly, many of you, already passed last year, right? So as Senator Carter mentioned, the use, possession, delivery, or sale of paraphernalia used to inject, ingest, inhale, or otherwise introduce drugs into the body is a criminal offense in Maryland unless the individual is enrolled in and obtains supplies from a certified SSP. Now here's the thing, speaking on behalf of one of the largest SSPs in the state of Maryland, proving you are one of our clients is confusing and applied very differently at the discretion of individual police officers. SB 509 would remove criminal penalties for paraphernalia used to consume drugs such as cocaine, crack, heroin, and fentanyl. Since legally starting to distribute these supplies, BHRC staff have seen clients switch from injecting to smoking or snorting, which is good for public and personal health, and many of my colleagues will speak to that in their testimony. The amendment we seek on Senate Bill 509 includes protections of sales and delivery, which we actually call secondary distribution. Secondary distribution is public health, which my colleagues will also speak to during this hearing. Decriminalization of paraphernalia reduces risk of overdose for myriad health and justice reasons. Maryland is primed to join a cohort of 11 states plus DC where paraphernalia is not criminalized. If passed, Senate Bill 509 with the amendment will reduce legal barriers to syringe access to align criminal law with widely accepted public health practices, saving costs, stopping unnecessary arrests, and improving the collective impact of drug treatment options. Happy to answer any questions. Thank you so much.
Thank you, Chairman Smith and members of the committee for the opportunity to speak this evening. My name is Catherine Billup. I'm a nurse practitioner and PCP at Healthcare for the Homeless in Baltimore City. The role of safe use supplies has been consistently demonstrated and are evidence-based solutions to overdose death and transmission of infectious diseases like HIV, but they only work when utilized. The pandemic has made it abundantly clear that access to healthcare, including safe use supplies, is not equitable. Fear of punishment from police, which disproportionately affects people of color, remains a significant barrier to accessing life-sustaining resources in the community. I met Sam, a 23-year-old enrolled in a substance use program. When he lost his job during COVID, he became depressed and soon relapsed using heroin for several months. When available, he attended a mobile syringe service program, SSP, but frequently noted police parked in the same area. Sometimes his friends were followed and questioned by the police. He became reluctant to venture out and risk being arrested. Supplies ran low. Feeling helpless, Sam reused needles from other injection drug users. Fast forward a couple of months, he's 3 weeks sober and presents to me his new PCP for a physical and baseline blood work. Results from our initial test reveal a novel HIV infection. He was devastated, as was I, knowing this could have been prevented with safe, legal, judgment-free access to sterile equipment. I met Tim and Cindy during my weekly rounds at an outdoor encampment. They currently live in a tent with 5 other adults, all of whom are sharing needles when supplies run low. They make turns visiting mobile syringe services, collecting supplies for secondary distribution among their social networks. Community members are less likely to volunteer this assistance if they know they might be arrested for possession of paraphernalia. Our team was able to connect Cindy to emergency shelter. I learned, however, only later that she lost her bed when shelter staff discovered syringes in her belongings. She has not attempted shelter since. Decriminalization of drug paraphernalia is an important step in ensuring access to emergency shelter, as well as participation in harm reduction programs such as SSPs. I ask for your favorable support with amendment of Senate Bill 509, the prevention of needless incarceration, death, and illness transmission through the decriminalization of drug paraphernalia. Thank you.
All right, thank you both very much. I'm not going to belabor the point tonight for a bunch of questions, but I'd love to call on both of you all just to get some of your practical experiences and stories, just if that's okay with both of you. Yeah, cool. All right, awesome. All right, with that, thank you very much. We'll call up the next panel. All right, Mr. Apple is Ms. Henderson. Mr. Ditello. And we'll do is Mr. Phillips.
Thank you very much, Mr. Chair, Mr. Vice Chair, committee members. My name is Chris Apple. I am a resident of Columbia, Maryland. When I learned that paraphernalia can sometimes bear a greater penalty than possessing an illegal substance itself, I got the sense that something was very wrong. I learned that from watching previous year's testimony on this bill. There is a history of addiction in my family. Drug abuse and addiction are serious public health issues. It can be deeply painful for the people who are afflicted with it. And I think what those people really need is help and not prison time. Prison can take them away from their families, can take them away from their support network. It can take them away from treatment and mean that it takes longer for them to get the help that they need. When they're incarcerated, they cannot work or provide for their families, so they can't earn money. And when they're released, the criminal record means it's harder for them to get a job. It can be harder for them to find housing. It can be harder for them to qualify for public assistance. And this can happen just for possessing a needle or a syringe, not even for possessing the illicit substance itself. So we should be treating these issues as illnesses, not as vices or as moral deficiencies. I believe the only humane thing to do is to decriminalize this paraphernalia so that we're not standing in the way of getting these folks the help that they need, and we're not adding to their burdens. So I respectfully urge a favorable report for this bill. Thank you.
Hello, my name is Kywan Jackson, and I'm speaking in talks to decriminalize, and I'm stepping in for Ms. Jane Henderson, who is my boss. I can't go into the things because I'm not a number guy, but I do know what being scared, having paraphernalia on you do. I have many family members in my family members who were strung out or who take drugs, and they were more afraid to ask for help because they was afraid to be judged or taken to jail would make them more thing. Like my colleague just said, it also makes them more stressed more because they're afraid of how they be perceived or being a criminal. And you don't want to make more stress for that makes a person relapse and get even more depressed and even go through another line of side effects for real. Also, I have seen people in my family arrested, beat, and treated like animals for just having a syringe. And it happened, sadly, to my father, who is not a drug user at all. He is diabetic. He had his diabetic syringe on him, and when the police saw him with a syringe, he was detained. When I saw that, I knew something had to change, so I truly urge and I beg of you to decriminalize paraphernalia, and thank you for letting me talk.
Good evening, Chairman, Vice Chair, distinguished members of this committee. Ron Phillips here testifying, and I can't believe that I'm testifying again for this. I really thought that we had this nipped in the bud, you know. These are detrimental policies, paraphernalia. You know, we're talking about syringes, cookers, pipes, you know, and I just think that we need to put this behind us and focus on real important issues like bringing OPS to Maryland. I thought we had it beat, but Hogan happened. Senator Bill Ferguson seemed disinterested in overriding the veto, but like I said before, just put it past us and get you some serious stuff here like OPS.
Hello. Normally I find myself here testifying against bills with the Senate, but I just wanted to add to this panel that I'm in full support of this bill. I believe that possession of an object applies in this case. It should not be a crime. The fact that, like he was saying, that you can go to jail for more years for the device that you administer the illegal drug than the actual drug itself is really telling. And unfortunately, I feel a lot of, you know, as someone who's not, who does not feel really underprivileged, I feel like there's people out there that they're directly exposed to this every day that, unfortunately, it just, you know, it hits them the hardest. And I have one example. I had a family friend growing up who had laced drugs, and he unfortunately did not make it. And I feel that when we criminalize things like this, we make it to where people go to underground markets, they don't feel safe, and they end up alone. I think this bill does some necessary good that makes it to where we don't have people being criminalized just for having an object the state doesn't approve of. And for that, I support and recommend this bill. Thank you.
All right, thank you all. Seeing no questions from the committee, thank you all very much for hanging in there with us tonight. All right, next we'll hear from Jesse Dunleavy, Owen O'Keefe, Harriet Smith, and Dave Fell.
Good evening. Thank you for having us here and for hearing this bill yet again. My name is Harriet Smith. I'm the Director of Services and Education with Baltimore Harm Reduction Coalition. As Reggie, my colleague, said, we are a state-certified overdose education and naloxone distribution program, as well as a syringe service program here in Maryland. It's our job to make connections with people who are at risk of fatal overdose. Various research shows that people who connect with harm reduction programs are more likely to take safety measures, reducing their risk of overdose over time. The current carve-out for participants of our program, again, as Reggie said, is not sufficient. To give an example, I carry a sharps container in my car because I am trained to pick up sharps if I see them in my neighborhood, as well as oftentimes I will take my father's diabetic syringes so that he doesn't have them around the house. If I'm stopped by police, I could be arrested, I could be held, I could have it to appear in court, all because maybe I forgot this little laminated piece of paper at work, proving that I'm a staff member of a state-certified SSP. That's ridiculous, right? I'm trying to be a helpful daughter, and I'm trying to be a good neighbor. I want to address the sales and delivery piece because I think that gets a little bit confusing. When I go to the store for my neighbor who has COVID and get him groceries, that's sales and delivery, right? I'm doing a favor. If I deliver Narcan and some syringes to a neighbor, that could be sales and delivery, especially if they're trying to give me a couple bucks for gas or they give me a cigarette and thanks.
We don't want that to happen. We want to keep community members looking out for each other and keep the connection to our services going. So I really appreciate this body for passing the bill last year, and I hope you'll do it again.
Hello again, committee members. My name is Dave Fell. I do street outreach for Baltimore Harm Reduction Coalition. This involves distributing life-saving items like Narcan, clean, sterile syringes to my Baltimore City neighbors. We know we can't possibly get supplies to all of our neighbors in need. There are conflicting schedules, folks with limited mobilities, the general chaos of life. We all get that. So we absolutely rely on folks who request extra supplies, like syringes, to deliver to a friend or family member who couldn't make it to the outreach tent, like Harriet said. We call them secondary distributors. To say that term again, it's an important term that we talk about all the time. These folks take their roles as community members and neighbors seriously, and I don't think they should be punished for that. People should be protected because they are doing a service for the whole community. The myth is that if sales and delivery of syringes are protected by this bill, people will maliciously stockpile syringes and use them in harmful ways. But the truth is that folks care about their neighbors and want them to have access to life-saving tools. I wanted to share a brief story about one of our participants who stockpiles syringes and other supplies. She's a weekly regular at one of our outreach sites. And over time, as we built a trusting relationship with each other, that takes time, but it happens. She started to request extra syringe kits, Narcan, hygiene supplies, and snacks to bring home to some of her elderly neighbors who have limited mobility and can't leave the house. One day, as she was making one of her deliveries, she encountered a neighbor experiencing an overdose alone in his home. Because she was there with supplies, she was able to intervene and save this man's life with Narcan. This is the reality of the secondary distributor. They care about their neighbors. They check on their neighbors. They care about the health and well-being of everyone in the community. We should not be making it harder for people to be there for each other, period. I urge you to support this bill to decriminalize drug paraphernalia with the sponsor-supported amendment. Thank you for your time.
Hello, my name is Jessie Dunleavy. I've lived in Annapolis, therefore Maryland, all of my life, as have multiple generations before me. I'm a self-employed author and a drug policy advocate, and I have been for a number of years. Thank you, Chairman Smith and the committee, for letting me speak in favor of Senate Bill 509, along with the sponsor amendment. We can't be proud of our mass incarceration in this country, any more than we can take pride in having the highest overdose deaths in the world. This bill provides a way to reduce arrests, which is something that I would think that everybody would be in favor of, and not only to have fewer people incarcerated, but to realize that arresting people sometimes turns them into criminals and is counterproductive and works against their lives instead of working in favor of their lives. Also, when they are able to access clean, safe supplies, it moves them along a continuum, building trust, and enables them to have a better shot at moving toward treatment and wellness. Every health organization in the world, and I know you've heard this, because you passed this bill last year, is in support of this kind of harm reduction effort. Specifically, I mean, they all do, the World Health Organization, the American Medical Association. But I was reading a letter this morning from the American Medical Association to the current administration urging low barrier access to supplies, policies that are non-punitive, syringe supplies specifically, and dealing with the pervasive inequities. So, you know, we had 40,000 people incarcerated in this country in 1980, and now we have over 500,000. I would think that even the police would be grateful to lop off a section of people that don't have to suffer the consequences of arrest. Thank you.
Good evening, Chairman Smith and members of the Senate Judicial Proceedings Committee. My name is Owen O'Keefe, and I'm a Community Outreach Coordinator with Baltimore Harm Reduction Coalition. I'm here with my colleagues today in support of SB 509 with the sponsor amendment to conform the bill to the version that passed through the legislature last year. Though Maryland currently has exceptions in paraphernalia law to protect participants and staff of an authorized SSP, the confusing patchwork of laws results in even authorized community members getting caught up in law enforcement interactions that should be completely avoided. Not to mention that our laws fail to protect people who receive paraphernalia from other sources, such as from a pharmacy or a secondary distributor of a syringe service program. Secondary distribution is an essential public health tactic used to reach people with the highest barriers to services, whether this be harm reduction supplies or at-home COVID-19 tests. This isn't something we just came up with here for this bill. This is something that is across all public health literature and much different types of service provision. And failing to pass this bill as amended, we are perpetuating health inequities for our most vulnerable, our friends and family members whose disability prevents them from going to a program themselves, and Black and Brown community members who are most at risk of arrest. I request that the committee give SB 509 a favorable report with the sponsor amendment to increase the opportunities that our community members have to get involved with life-saving harm reduction services. Thank you so much for your time.
Excellent. Thank you all very much. Seeing no questions from the committee, thank you very much for hanging out with us tonight. All right. We will now go to our, I think we have two more witnesses. So Ricky Moore Sr. and Stacy Jefferson.
Good evening, Mr. Chair, Vice Chair, and members of the committee. My name is Stacy Jefferson, and I'm here as the Director of Policy and Stakeholder Engagement at Behavioral Health System, Baltimore. And I'm here in support of Senate Bill 509 with the sponsor's amendment to mirror the bill from last year. And I know it's been a long night, so I'm going to try to be brief. I want to first thank the committee as well as the Maryland General Assembly for passing this bill last year. As the nonprofit organization that oversees mental health and substance use disorder treatment services in Baltimore City, we see firsthand the barriers that criminalization of substance use creates for people seeking treatment and supportive services. Current laws, as we know, create a disproportionate impact on people of color, which further exacerbates the inequities in access to treatment. But there is good news. There is evidence that shows us that policies like Senate Bill 509 create an atmosphere of less fear of punishment and arrest by police, which makes individuals feel safer accessing treatment. And so it's time that we decriminalize paraphernalia and join other states to help prioritize the health and safety of individuals and communities over punishment. And so with that, we ask for a favorable report on Senate Bill 509.
Good evening, Chairman. And my name is Ricky Morris, and I'm an outreach coordinator for Baltimore Harm Reduction too. And along with Dave, we work up close and personal with people that use drugs. And we have a lot of people that do secondhand distribution, and also we have a lot of volunteers that come out with us, and they walk around and they pick up these needles and things off the ground to try to keep it safe for all our kids that might be playing or going to school and things. And I was getting upset one time, and I say, why is there so much of these needles and things around the street? And one of the secondhand distributors say, you know why? Because they're frightened. Like, if they're walking down the street and they got something and they hear a police siren and they have paraphernalia needle, you know what they do? They take it out and throw it on the ground because they scared of getting arrested. And guess what? That same thing they threw on the ground could be something that one of our children might walk past and accidentally step on and pick up with something. It's unnecessary. We have a needle exchange for a reason. We want people to take and bring in their old tools and exchange them, but they need to feel safe while they're doing it. It also makes it safer for the people and the children and the public around. It cuts down on HIV and hepatitis C, the spread of all that. So I think it's definitely something that we should try to eradicate. Thank you, guys.
Thank you, Mr. Chair. I just want to thank you, sir, for giving what I believe has been the best testimony of this very long day. And with that, you were the last and the best. Thank you.
The gentleman who last spoke, I appreciate what you did as well. I agree with the senator, but I'm just curious, given the lateness of the hour, how does someone who works for an organization called Baltimore, whatever, wear a New York Yankee hat?
Well, sir, my barber, he
got it honest. He got it honest.
Okay.
Hey, I'll just say this. Look, a number of you all thanked us for being here tonight, but I would say that thank you for being here and participating in the process. Remember, we're your elected officials. We work for you, and this is your committee room. So just thank you for sticking with us until 8:23 tonight. And so with that, that'll conclude the hearing and the testimony for Senate Bill 509. Thank you, Senator Carter. Thank you to all the panelists.
Thank you.